ಬರ್ತೀವಿ. ಹಾ, ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಒಂದ್ 10 ನಿಮಿಷ ಬರ್ತೀವಿ. My lord, kindly have this memo, my lord.
Yes. Tomorrow.
My lord, my lord, kindly accept this memo.
Yes.
My lord,
What is that case? Suit for?
Then
Tomorrow. Yes.
my lord, kindly accept this memo.
Now, what is the next date? Monday.
Monday.
My lord, kindly accept this memo.
Monday. Why?
Yes, madam. One kade inda bani. When is the date? Yes, Monday. Yes. ಮತ್ತೆ 80% ಡಿಗ್ರಿ ಇರೋದು 100% 80% ಕೊಟ್ಬಿಟ್ಟು Tuesday. Yes, Tuesday. What is that order you are challenging, madam? Yes.
No, please, I'm sitting there, I'm raising order in paper, there no such thing. Allowed the IA and issue police for implementing order.
Saturday.
My lord, it's my lord.
All the two memos you have made any mistake and making an allegation against the court saying that matter is not post-admitted.
My lord. Okay.
Next week.
So any application proceeding. Land was developed by the municipality council. So it was challenged before the OS. So during the pendency of this notice was issued. So again the same notice was challenged before the LB report. The honorable court granted interim order, which will be lapsed and dispose the matter, and it will be lapsed by 28. There again in MA our interim interlocutory application for ex parte injunction was dismissed. Was not Hello.
Next week, third, yes.
No, it will be, will have 28
Yes, yes.
My lord, the suit is for recovery
28,
of money,
28.
my lord. Trial court ಅಲ್ಲಿ Monday arrears of rent ಕಟ್ಟಕ್ ಹೇಳಿದ್ದಾರೆ, but kindly have it tomorrow, my lord.
Why?
IA number 2 ಮೇಲೆ allow ಮಾಡಿದ್ದಾರೆ.
But you have to pay that rent. You are the tenant. What else is there next week? Yes, tell me.
My lord, sir, property
Yes,
given to this petitioner has been sold without even fixing the base plan. Now, my lord, option purchaser is seeking for delivery of possession.
Saturday.
My lord, sir, one more case, wherein, my lord, the impeding application has been came to be allowed. At the fag end of the case, my lord, sir, the matter was posted for argument. And my lord, suit.
What is the next date?
ಆಮೇಲೆ ಕೊಡ್ತೀನಿ.
My lord, sir, on 7th of February, my lord.
Yes, third.
Your lordship, the entire
ಕೊಡಿ ಹಳೆದನ್ನಲ್ಲ, yes.
The entire compensation amount has been paid by NHI, your lordship, before District Court Kolar. Now the decree holder is again claiming interest on the entire compensation amount instead of enhanced compensation amount. The court has kept the matter on Saturday for issuance of warrant, your lordship. Entire compensation amount is paid. Without hearing JDR, this order has been passed. So may
Saturday.
request for,
Saturday.
please, highly obliged.
Challenging the order, appointment of co-commissioner method. The trial court is urging us to have the final argument on 27th. Be a short date.
Yes, next week, third.
My lords, this.
Yes, let it be cross-examination. Yes, Wednesday.
My lords, I had moved this memo day before yesterday also, my lords. Your lordship had directed to list the matter today. It's not been listed, my lords. My application for recall reopen has been
Saturday,
dismissed.
Saturday.
My lords, tomorrow, my lords, because the matter is set out for arguments, my lords. tomorrow.
Tomorrow. Yes.
May be taken up tomorrow, my lord.
What is that urgency, Mr.?
I have filed a declaration and possession suit against divorced wife. She has also impleaded as one of the defendant. Proceedings have been
Yes,
okay.
next week, third.
Tomorrow, my lord.
No, what is that urgency, Mr.? So many urgent
Tomorrow, my
matters
lord. There is an urgency because it is posted for evidence on 2nd of February. Because
2nd of February.
Oh.
Yes, let there be an evidence.
Like
Yes.
tomorrow, my lord. Tomorrow,
Next week.
next week.
When is that next date? Next week, third. Yes. No, you don't know the date, madam. Yes.
Plaintiff filed the amendment application.
Some of the matters which is posted for orders and injunction has been granted, I have to take that urgent matters. Unless.
Plaintiff filed the amendment application. Amendment application is rejected, my lord. Finally, posted for plaintiff evidence, 27th, my lord, finally.
95 evidence, what will happen? 28, yes.
My lords, with my lords, kind leave, my lords. A section 8 application has been allowed by the learned trial judge in Punikal, my lords, without there being an arbitration clause itself, my lords. And accordingly, the plaint has been returned, my lords. If the matter may be listed on Saturday, my lords.
Yes, Saturday, yes.
Filed an application for vacating interim order. For the listed 2 dates, but they have taken, yesterday also listed, they have taken time, but next to witness there. because-
Date ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ. Now, yesterday date has been given. You are not there when they have taken time.
They have referred afterwards.
Then you should have objected that. Now we have already given a date and signature. Then.
Urgency in which interim order is operating, next to Wednesday.
Not Wednesday. Yes, on 30th. Sorry, 30th. Yes.
My lords.
30th.
I'm invested 1 crore for machinery industry.
What is that order you are challenging?
Not renting into. Not to interfere.
Your suit as filed by you. Yes, Saturday.
My lords,
Saturday, yes.
my lords,
Yes, Saturday.
my lords.
Saturday. Nothing will happen. Yes, Saturday. Yes. next week.
My lords,
ಆಯ್ತು ರೀ, ರೆಂಟ್ ಕೊಡೋದಿಲ್ದಿದ್ರು ಸೂಟನ್ನೇ ಡಿಸ್ಮಿಸ್ ಮಾಡೋ ಕೇಸ್ಗಳಿದಾವೆ ನೀವು. ಎಸ್.
my lords,
What is that matter? Tuesday. Not tomorrow. Saturday, yes, Saturday.
my lords, the respondents are impleading applicants before the trial court. The next date of hearing is 28th, my lord. So the necessary parties are required to be heard. Kindly post it on
Now,
Monday.
why your application is dismissed?
No, my lords, it's allowed, but they have to be heard, my lords, and necessary parties in this. It was stayed here in this honorable court.
Stay has been granted.
Yes, my
Now
lords.
you are filing an application for vacating.
Yes, my lords.
ನೋಡಿದ್ರೆ ಅಂದ್ರೆ ನೀವು ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ your colleague. No, she is your colleague.
Yes, my lords.
You have filed an application for vacating. Yes, tell you Wednesday.
Kindly post it on Monday, my lords.
Yes, Wednesday.
My lords, 28th is the next date in the trial
Let
court.
us see. Yes.
Please, ma'am.
Yes.
Matter pertaining to appointment of court commissioner, it was
Yes.
listed Monday. My lords directed me to serve upon the Lord advocate who appears for trial court. I have served. Lord, may I request, my lord, on Saturday, my lord,
Yes, Saturday. Yes.
mandamus, only a mandamus sought, my lord.
Let us see on Saturday.
Please.
Yes.
Eradunu connected, madam.
Wait. Saturday.
Saturday. For page wise adjournment, list number 1, page number 1, serial number 1 to 7. Page number 2, serial number 8 to 14. Page number 3, serial number 15 to 24.
Serial number 14 in concern, Monday,
Yes. at the
Monday,
request of
27th.
Counsel for the petitioner, leave this matter next week.
27th, ಯಾಕಂದ್ರೆ
Next
interim
week,
order,
next week.
only Supreme Court judgment ಕೊಡ್ಬೇಕಾಗಿದೆ ಅಷ್ಟೇ ಅದ್ರೊಳಗೆ. Hearing ಆಗಿದೆ, ಒಂದು Supreme Court judgment ಕೊಡ್ಬೇಕಾಗಿದೆ, at least 27th it may be.
Today, you were either today or next week. Yes.
ಅಲ್ಲ, 27th please.
Not 27th.
Page number,
Next week.
Serial number 16, my lord. I issued for the respondent caveator, my lord.
Have you informed other side?
Not informed. I
No, you have to inform and mood matter. Yes.
page number 4, serial number 25 to 28. Page number 5, serial number 29 to 31. Page number 6, serial number 32 to 35.
My lord, I'm
Yes.
sorry, madam. 38, my lord, I'm sorry, madam.
Page number 7, serial number 36 to 39.
My lord, 38, my lord, I am for the petitioner, my lord. In fact,
Yes.
38 and 96 are connected matter arising from the same suit, my lord. I seek an adjournment anytime next week,
You
lordship's
are appearing
convenient.
for?
I am for the petition, my lord, for the petition.
Yes. What is that maintainability?
My lord, this arising, the suit was filed, my lord, seeking an prohibitory injunction against National Highway, my lord. They say that we have acquired in excess. Now, we had challenged in our Order 7, Rule 11, we had filed an IA, my lord, which was dismissed. And against that, we went for the honorable subcourt. That was
At the
also
request
dismissed,
of-
my lord.
At the request of counsel for the petitioner, leave this matter after 2 weeks. Yes. The other?
96 of that.
Yes.
Bless
Both. Yes.
Page number 8, serial number 40 to 42.
Serial number 42, man. Bring for petition. 2 weeks time may be granted.
Yes. At the request of 2 weeks time is granted to do the needful.
Serial number 39, my lords.
Yes.
Objection is ready, my lords. I will file it by Monday, my lords. Kindly have it on Tuesday, my lords.
You are appearing for whom?
Petitioner, my lords.
Yes. At the request of counsel for the petitioner, week's time is granted to do the needful. No, there is vacating stay. Have you informed other side? You inform and come, mister.
I'm not informed, my lords.
You inform and come, mister.
Okay.
Yes. When there is a vacating, you have to inform. Yes.
Page number 9, serial number 43 to 45. Page number 10, serial number 46 to 50. Page number 11, serial number 51 to 54. Page number 12, serial number 55 to 60.
Serial number 60, 3 weeks adjournment,
60.
60.
Yes. At the request of counsel for the petitioner. What is that recalling, mister? Who has filed the application?
Petitioner.
Petitioner leaves this matter after 2 weeks.
Page number 13, serial number 61 to 64. Page number 14, serial number 65 to 67.
I appear for the, in serial number 67, my lord.
Hmm.
1 week time may be granted.
You are appearing for
I appear for the petitioner, my lord.
the request of counsel for the petitioner. Lead this matter of 2 weeks, yes.
Great, my lord.
Page number 15, serial number 68 to 76. Page number 16, serial number 77 to 83. Page number 17, serial number 84 to 90.
My lord, serial number 84, I'm appearing for the respondent.
Hmm.
Short accommodation may be given, my lord. Senior counsel is out of station.
Have you informed other side?
Please, my lord.
Yes, at the request of counsel for the respondent, leads this matter next week.
Serial number 90, I'm withdrawing that petition. The suit is settled by compromise.
Yes. Tomorrow,
Please, madam. I'm
Have the-
withdrawing this serial number 90, my lords.
9-0.
90.
Yes, learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this petition, dismissed as withdrawn.
Please.
Page number 18, serial number 91 to 97.
Lordship, I appeal for petitioner, serial number 93. Kindly extend the interim orders.
90?
93.
93. You
Kindly
are appearing for?
petitioner,
What you want?
kindly extend the interim orders.
Wait. Extension entry matter, wait.
Page number 19, serial number 98 to 100. List number 2, page number 1, serial number 1 and 2.
List number 2, madam.
Hmm.
It can be posted on Monday, madam.
Which one?
List number 1. List 2, list number 1,
List number 2,
serial number 1.
serial number 1.
ಅದು
Yes,
ನೆನ್ನೆ
you want-
ಕರೆಂಟ್ ಆಗಿರೋ ಮ್ಯಾಟರ್
Huh?
ಕರೆಂಟ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸರ್ ಇದು ಬೋರ್ಡ್ ಬ್ಯಾಂಕ್ ಲಿಸ್ಟ್
Yes. But the request of week's time is granted to comply after this.
ಅದು ಬಿಜೆಪಿ ಕಾಪಿ ಒಂದು ಅದು ಇವತ್ತೇ ಕೊಟ್ಟಿದ್ರು ಅದಕ್ಕೆ ಮಂಡೇ
ಆಯ್ತ್ರಿ, ಆ ಮ್ಯಾಟ್ರ್ ಜೊತೆಗೆ ಬರ್ಲಿ ಅಂತ ನೀವ್ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ ಅವ್ರ ಬೋರ್ಡ್ ಬ್ಯಾಂಕ್ ಮಂಡೇ
ಅದ್ರ ಜೊತೆಗೆ ಬಂದಿನ ಮೂವ್ ಮಾಡಿ. ಎಸ್.
List number 1 for preliminary hearing, serial number 1, Hanumantappa B.
For the petitioner, my lord.
Yes.
My lord, the petitioner and respondent, the petitioner, the tenant under the respondent, my lord. My lord, the respondent forcibly evicting so the petitioner, my lord, from the scheduled premises, sir. And then the petitioner had filed the OS number, my lord, annexure A, my lord, annexure A, before the Mehal court even or in the Mehal court, my lord, the honorable court has passed the order, my lord, annexure B, my lord, page number, my lord, the 43, my lord, 41, my lord, 41. Second para, my lord. Placing the memo and submission of the learned counsels appear representing as so the defendant and the plaintiff respectively on record when the defendant has undertaken that he will not evict the plaintiff from suitable property without adopting due process of law. Under such circumstances, the suit of the plaintiff is required to be decreed. Hence, the memo filed upon this defendant is accepted. In the consequences, the suit filed upon the plaintiff is decreed and the defendant is hereby restrained from so the here forcibly dispossessing the plaintiff from the suitable property without adopting due process, my lord. My lord, the respondent had filed the OS number, my lord, annex 0D, the 8350. He obtained, my lord, the order of eviction, page number 63, my lord, 63. The second para, my lord, the defendant is directed to vacate the suit premises and hand over vacant possession of the same to the plaintiff within 1 month from date of the judgment and immediately after vacation, the handing over. My lord, the 13 lakhs rupees not given by the respondent, my lord, without handing out this security amount to me. He evicted me, my lord. This bad in the law. He filed so the execution person, my lord, annexure D, my lord, it is. Now it is going on. Therefore, without, my lord, annexure D, my lord, it is. He filed EP. In the EP, without handing over some of the mass security amount, it is going on, my lord. That's why this EP is not maintainable, my lord.
No, where is that annexure? Which is that annexure order passed by that execution petition?
Annexure D, my lord, it is.
Page eldri.
Annexure D, my lord. The IA number 2, IA
Page number eldri.
page number,
Page
my lord, please.
tell the page number, Mr.
Page number, my lord, 102 minutes. The 103 minutes.
103 is what I have filed by that degree holder under so and so.
Is hereby allowed. Directed
Office is
to issue attachment warrant minutes.
Warrant of movable, immovable properties mentioned this. They have not filed that, paid that amount.
My lord, I have paid the entire amount, my lord, but my security amount not given, my lord. The security amount with
has
the
not
respondent.
paid. They have not paid the
Not
security.
paid, madam, not paid, my lord.
Have you raised that? Have you raised that in that?
Issue ಮಾಡಿದ್ದೀನಿ. Raised that issue, but despite that, so the court passes the order, my lord, the execution of the person going on. without handing over the 13 lakhs amount from me, without badi, that is, I put in terrible position.
When the order has been passed,
It passed on my lord on 11th January 2024, my lord. 11th January 2024.
yes, heard, issue notice, stay of further proceedings in execution petition
Next D, my lord, is
number 319 of 2023, pending in the file of 8th additional city civil and session judge, Bangalore, till next date of hearing.
Serial number 2,
my lord,
Pradeep Nayak.
hand delivery, my lord, 30 cases, hand delivery. I'll file memo, my lord,
Yes,
hand delivery.
yes, yes,
Please, I am for the petition, my lord.
yes.
Defendant's writ petition.
Hmm.
My lord, the respondent filed a suit for permanent injunction and moved an application under Order 39(1) and 2. Seeking to restrain the defendant from interfering with the same. The suit scheduled property measures 15 feet into 56 feet. We claims that it is a road. It is a-
Application is dismissed.
No, IA allowed.
IA allowed.
IA allowed. And after completion of plaintiff evidence, now he started to put up a permanent structure on that road. We filed an application under Order 39(1)A. That IA came to be dismissed. MA filed, MA also dismissed. Against that, the present writ petition is filed before your lordship.
Yes,
Your
heard,
lord,
issue notice. Parties are directed to maintain status quo
please,
in respect of petition scheduled property till next date of hearing.
public.
Serial number 3, Ajesh Kumar, yes.
The application to implead was rejected by the reference court, my lord. My lord, this is regarding the land act for acquisition by the Bangalore Metro. My lord is pleased to see ink page 58 is the final notification. And ink page 61, my lord, relevant part, item number 7, 60, my lord.
How are you
Item-
related to that property?
My lord, I am the tenant in the property and it is shown that I am a beneficiary. Please see item number 7, my lord.
Yes.
Anubhavadar. Number 2, citizen cars. I am citizen cars and
Owner is Parashimo here.
yes, yes. And including the BMRCL's valuation report, please see ink page 85. Ink page 85,
What, you are a tenant?
tenant, my lord. I have done the improvements.
Is it
I'm
tenant is required to be?
Interested party, my lord, section 10 of the Land Acquisition Act. This is before the amendment. As per section 30 of the KIDB Act, the provisions of the Land Acquisition Act will be relied on for the purpose of determining quantum of compensation. Whether I'm an interested party or not, my lord, what the honorable court, this honorable court has held is, if I have participated in the proceedings before the land acquisition officer, I'm an interested party. Now, my lord is pleased to see even the valuation report at ink page 85, where it shows, my lord, date of inspection at serial number 6. Item number 7, this is a non-residential commercial property, Gangadhar Tent House, Citizen Car Showroom, compound wall.
Why your application is rejected?
Yes, my lord. It says that I had an unregistered lease agreement. If I have to file a suit, I have to go separately against my landlord. And obviously, my lord, multiplicity of...
What is your claim there? You are a tenant.
I have done improvements on the property. Bangalore Metro's valuation report, including the general award, my lord. My lord is pleased to see the general award also.
That can be determined in that reference code.
Yes, I filed the impleading application in the reference code.
No, is it that reference court has a jurisdiction to decide all this?
Please, my lord, it would have, my submission is it would have, for the simple reason that I'm an interested party. My lord is pleased to see as per section 10.
They can decide that apportionment.
Apportionment.
Whether you have any right, you have constructed, all this can be decided in this.
In the reference code, my lord is pleased to see the award at ink page.
No, I'm not on that.
Yes, my lord.
What is that power of the reference court under that?
My lord, it will determine title, most respectfully. Please see the cost title at ink page 19. There's no claim as far as KIDB is concerned. KIDB has deposited the amount.
No. I'm
Yes.
not on that point.
Yes, my lord.
See whether reference court has a power or jurisdiction to decide all these issues. Whether you are a tenant, whether you made an improvement, whether you have to be paid. It is only apportionment between the owners of the property.
I would most respectfully submit, my lord, it will be under section 10 of the
No, it is under what Land Acquisition Act?
Yes, yes, because this is prior to the amendment.
Then it is section 30, apportionment and all.
Yes, under the section
Where is that?
30.
Where is that?
Yes, Manu. I'm saying section 10, why I pointed out is that whether I have participated in the proceedings. The inquiry by the collector, if my lord is pleased to see, section 10. Power to require, enforce making of statements as to names and persons of interest. The collector may also, subsection 1, require such persons to make or deliver to him at a.
That is true.
Yes.
Before passing an award.
Yes.
All interested persons can file.
Please, yes.
Have you filed that?
Yes.
You have, before that,
Please.
Land Acquisition Officer.
Yes, my lord, pleased to see in page 66.
Yes.
66.
Or issue notice. Stay of further proceedings in LAC number 152 of 2020. Pending in the file of second additional city civil and session judge, Bangalore, till next date of it. Emergent notice.
My lord, I may be permitted to serve the advocates appearing.
Petitioner is also permitted to serve a copy and the counsel appearing for respondent before the
Grateful, my lord.
reference.
Number 4, Ravindra BS for petitioner.
Pay for the petition, my lords. Plaintiff's writ petition, my lord. Suit for partition is filed against the brother, my lord, claiming the property belongs to our sister and her husband. My lord, the list between brother and sister. Then an impleading application is filed by my son, saying I am also necessary party before the court.
Partition suit.
No, my lord, yes, my lord, partition suit. But the son, my son do not have a right over the property during the lifetime of myself.
No,
I
but
say
it is between you and your sister.
sister, my lord, sister and brother, my lord. Sister is the plaintiff. She filed a suit saying that one of my sister died interstate. My sister has become absolute owner of, after that it inherits to me by virtue of class 2 heir. My son comes before the court saying that I am also necessary party. The court allows the application saying that he is a proper and necessary party. There is nothing to be adjudicated on behalf of my son, my lord.
Where is that order?
Lord's next year, my lord. Lord, the learned judge has not considered the application.
No, can't be given a share for you in your share which is allotted to you.
My lord, there is no division unless during the lifetime he cannot come on record, my lord.
No,
After that,
is it ancestral property?
no, it's not ancestral property, it's my sister's property. My sister died issueless. Subsequently, I being the class 2A, I say that after the death of my sister, I myself and my brother becomes co-owners of the property.
Yes.
So,
What is that? Where is the order of the trial
my
court?
lord, kindly take, my lord, next year, my lord. The relevant paragraph, my lord. Para 12, my lord. It is
12.
pertinent to note that herein admittedly applicant has not produced any document.
Page.
Page number, my lord, 35, my lord. Ma'am,
Yes.
it is pertinent to note herein admittedly applicant has not produced any document in support of the claim made in the application. But it is undisputed fact that he is one of the family member of the plaintiff and also having interest of the Venkamma and Gangamma. Further, admittedly, revenue entries will not confer any title. But at this juncture, it is
Further proceedings in OS number 366 of 2011, pending in the file of second additional city civil and judge JMFC Chikbalapura till next date of hearing. You are going to get it stayed by your suit.
my lord,
No, even if he is there, how it will affect? If he is not entitled for the interest,
my lord,
any share he will not interest.
let the stay of the impugned order.
No. We have to stay that suit. Suppose impugned order is stayed, tomorrow your writ petition is dismissed, suit is decreed, where you will go then? Yes.
Number 5, Parshuram R.
Appearing in favor of petitioner, my lord. In this suit, my lord, OS number 364 of 2019. The trial court has heard the arguments and the duty of penalty on partition suit of the 10/11/1998, my lord, on 23/10 of 23.
You are appearing for?
Petitioner, my lord. On 20.
Plaintiff.
Yeah, my lord, plaintiff.
Suit for?
Suit for relief of declaration of possession of consequential relief and injunction, my lord. The trial court has ordered all the arguments on 23-1 and 23-1 for orders, my lord. Till 1.5 year, the trial court has not ordered taken the decision and the orders is not been passed, my lord, till today.
Now,
It is-
what is that you are seeking for, Mister?
Seeking for the directions for my lord, writ of manam for taking the client pass the order to direction to the trial court to order the decision.
What is the stage now, Mister?
Yeah, argument, all the arguments has been done, my lord.
Main matter, evidence is over.
All evidence has been over, all both the arguments and written statements all been done.
Again, prior payment of duty, pass an order on payment of duty and penalty.
Payment of penalty, unregistered partition deed, my lord.
ಅದನ್ನೆಲ್ಲ payment of ಅದೆಲ್ಲ ಎಲ್ಲಿ ಬರುತ್ತೆ? What is that your prayer, Mister? Where is that order sheet?
Order sheet is annexure F, my lord.
Annexure?
F, page number 95.
ಏನಾಗಿದೆ? Case called advocate plaintiff to hearing on delay of penalty. ಏನ್ರಿ ಇದು? Card on both present. Hearing delay and pending. No, it is some IA they are passing an order, Mister.
IA is in.
ಎಲ್ಲಿದ್ದಾರೆ main petition ಅಂತ? ELCL, hence case is urgent. Due to rush of the work, it is not ready for the orders. Partition deed for order call on. Main matter mela call the both present, plaintiff, defendant present, right time to hearing on. Hearing order, hearing ಏನ್ರಿ ಇದು?
Sir, both side arguments ಮಾಡಿದ್ದಾರೆ sir trial.
ಮೇಲೆ
ಒರಿಜಿನಲ್ ಸೂಟ್ ಮೇಲೆ ಸರ್.
ಮತ್ತೆ ಆರ್ಡರ್ಸ್ ಮೇಲೆ ಹಾಕೊಂಡಿದಾರಲ್ಲ, ಆರ್ಡರ್ ಹಿಯರಿಂಗ್ ಏನದು?
ಅಂದ್ರೆ ಬೋತ್ ಸೈಡ್ ಹಿಯರಿಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎರಡು ಮಾಡಿ
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಹಿಯರಿಂಗ್ ಆನ್ 10/9/2020 ಹಿಯರಿಂಗ್ ಡಿಲೇ ಅಂಡ್ ಪೆನಾಲ್ಟಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ದೆನ್ ಯು ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಫೈನಲಿ ವೇರ್ ಇಸ್ ದಟ್ ಮಿಸ್ಟರ್? ಆರ್ಡರ್ ಆನ್ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಅಂಡ್ ಪೆನಾಲ್ಟಿ ಮೇಲೆ ಪೋಸ್ಟ್ ಆಗಿದೆ.
ಆದ್ರೆ ಅವ್ರು ಇನ್ನೂ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ, ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಆಮೇಲೆ ಟ್ರಯಲ್
ಮೇಲೋ ಅಥವಾ ಫೈನಲ್ ಆರ್ಡರ್ ಮೇಲೆ. ಯು ಡೋಂಟ್ ಟೇಕ್ ರಾಂಗ್ ಆರ್ಡರ್ ಫ್ರಮ್ ಮೀ ಮಿಸ್ಟರ್. ಯು ಡೋಂಟ್ ನೋ ವಾಟ್ ಹಸ್ ಹ್ಯಾಪನ್. ಇಶ್ಯೂ ನೋಟಿಸ್.
Cell number 6.
Other side, at least ಅವ್ರವ್ರು ಹೇಳ್ತಾರ ನೋಡೋಣ.
Cell number 6, Eugene Prabhu Bharat.
I am appearing for petitioner in this case, my lord. The suit is for separate position and declaration. Adರಲ್ಲಿ IA number 13 is filed, page number 76, madam. Adರಲ್ಲಿ IA number for issue of additional framing of additional issues. ಅದನ್ನ ಏನ್ ಮಾಡಿದ್ರ, it is framed and it will be taken
Suit for?
along with the suit for partition and separate position.
You are the defendant.
ಹೌದು ಸ್ವಾಮಿ.
ಏನು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
IA number 13 ಸ್ವಾಮಿ.
What is that IA number 13?
ಅದೇ ಸ್ವಾಮಿ, framing of court fee and suit violation, court fee ಮೇಲೆ. They have not, they, according to them, the section 35(1) ನಲ್ಲಿ ಪೇ ಮಾಡ್ಬೇಕಾಯ್ತು, 35(2) ನಲ್ಲಿ ಪೇ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. Along with that
Where is that
additional.
order?
Page number
Having gone through that material, it would appear to be to frame issue on the court fee. ಏನಾಗಿದೆ? court fee ಮೇಲೆ issue frame ಮಾಡಿ ಡಿಸೈಡ್ ಮಾಡ್ಲಿ ಬಿಡಿ. What is wrong in that?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಮೇನ್ ಪೆಟಿಷನ್ ಜೊತೆಗೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ.
Counsel for the defendant number 2, praise time to argue on IA number 13 is filed by the defendant number 2 under so and so. Praying to direct the plaintiff to pay proper court fee for cancellation of documents so and so. At this stage, having gone through that material, it is proper. Nim application mele now they are framing an issue for a court fee. Why you are challenging, mister? For the defendant.
ಮೇನ್ ಶೂಟ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರೆ, ಅದರಿಂದ
It will be that one of the issues. Additional issue is to be framed today and said disputed facts. Additional issues to be framed today and open court consequently taken on record. The plaintiff evidence call for so and so. What will happen, mister? If it is an additional issue also, one of the issues they are framing. You are filed defendant to and so and so praying to direct the plaintiff to pay the proper court fee or cancellation of the documents defendant directed so and so. Yes, you take notice, let us. Yes, notice.
Cell number 7, Kishore BK for petitioner, Ajesh Kumar S.
Yes.
Hearing for the KVA to respond, madam.
My lords, I've served a copy of the objections to the learned senior counsel. If I may be permitted to place it on record.
Yes, let us see first.
Please.
Yes.
My lord, the petitioner is the decree holder
Hmm.
and the respondent
Hmm.
is the
Judgment data.
judgment debtor, their father and son.
Yes.
There was a suit for partition by the petitioner
Hmm.
claiming 1/3 share.
Yes.
It ended in a compromise. The compromise decree is dated 24/6/2010.
Yes.
And one of the clauses in the compromise is that the respondent
Yes.
voluntarily agreed to pay a sum of rupees 2 lakhs per month to the petitioner.
Yes.
It was being paid, my lord, till last December.
Yes.
From January, he discontinued paying it, which resulted in this execution petition being filed.
Yes.
Now, in the compromise petition, it is clearly says that he has voluntarily agreed to pay a sum of 2 lakh to the petitioner, and his wife's name, Kumud Mozaria, is also there because in the event of death or so,
Yes.
naturally, but she is not a party to the proceedings.
Yes.
However, my lord, now before the lower court, the learned judge, observing that there is no clause for reduction in the compromise decree, reduces the payment from 2 lakhs to 1 lakhs on the ground that petitioner's wife died in 2010. Out of 2 lakhs, 1 lakh was to be paid to her. He is assuming, and 1 lakh is to be paid. Please see the clause in that relevant clause only, my lord. I will take your lordship.
Yes.
Page 30, para 13.
34.
30, sir.
30.
Page 30.
Yes. Para 13.
Howdu.
Hmm.
May I just read, my lord?
Yes.
Parties to the memorandum of settlement agree and accept that Mehul Mozaria, the respondent, my lord,
Yes.
is the son of Raju Mozaria, the petitioner, and in terms of the settlement, Mohal Mozaria has voluntarily accepted to pay a sum of rupees 1,50,000 on or before 7th day of each month commencing from the date of memorandum of settlement for 3 years, and thereafter the amount shall duly enhance after 3 years to 2 lakhs per month during the lifetime of Raju Mozaria and Kumud Mozaria. There is no clause, my lord, of any reduction in the event of death. Now kindly see the reasoning of the learned judge only.
Yes, mister.
My lords,
See,
yes.
that means to say, how long both of them living, you have to pay 2 lakhs. It is not that one of them is dead, therefore it has to be deducted.
Yes.
That is not understanding.
My lords, may I just
To their lifetime, you have to pay. There is no division among them is that 1 lakh for her or 1 lakhs for him.
My lords, may I just read out both the clause after the learned
Yes,
senior
yes, yes.
finishes
That
up?
is what that is one, yes.
Please. My lords, there are two aspects to this, my lords. The same compromise petition, my lords, if I may just be permitted to read clause 13 and clause 14.
Yes.
Clause 13 is the parties to this memorandum of settlement agree and accept that since Mehul Mozaria is the son of so-and-so, and in terms of this settlement, so-and-so has voluntarily accepted to pay a sum of 1.5 lakhs on or before the 7th day of each month, commencing from the date of this memorandum of settlement for 3 years, and thereafter the amount shall stand duly enhanced after 3 years to 2 lakhs per month during the lifetimes of so-and-so and so-and-so. My lords, the subsequent clause, why I'm reading the subsequent clauses that the please, my lords. Clause 14. The parties to this memorandum of settlement agree and accept that since so-and-so is the son of so-and-so, he has also agreed to pay a further sum of so-and-so to so-and-so, or in the event of his demise to so-and-so over a period of 3 years from the date of execution of this memorandum of settlement. My lords, in clause 14, what I'm just trying to point out is, my lords, the parties had consciously agreed that there was a concept of death which may happen and it would be paid to either of the parties, the other party who is surviving. But that is absent in 13. So in that absence, my lords, I'm stating that the memorandum of settlement ought to have been read by at
It
best.
has to be paid either of the parties, even assuming that it is correct. It is not that to reduce and paid.
My lords, because the understand.
What you are arguing will be accepted. See, either of the parties you have to pay. But one of the parties is dead, that has to be reduced. There is no clause, mister.
My lords, there is no clause. So my best case scenario, my lords, would have been that I don't have to pay.
Liability is 2 lakhs. whether one is alive or one is dead. Every month you have to pay 2 lakhs. That is your liability. You need not see that whether one is dead or one is alive. Monthly payment is that to 2 lakhs. That is what that you are understanding.
My lords,
Compromise is that your liabilities is 2 lakhs, still they have to be.
my lords, if I may just make this submission, my lords, the worst case scenario would be for me to pay 1 lakh, but the best case scenario would be for me to pay nothing, because it contemplated the lifetime of both. But then if my lord is pleased to see clause number 14,
See, lifetime of both, one of them is still alive.
my lords, for clause 13 to kick in force, my respectful submission should have been that both parties should have been alive. In the concept that
You
both
can't
parties.
interpret that
Please,
way.
it's not.
We have to go
No,
by
no.
My lords,
compromise.
please. In my statement of objections, I've also stated that a writ is not maintainable. And also that in the aspect of an ambiguity, my lords, the executing court could have gone into the construction of the settlement. My lords, now that the executing court has gone into the construction of the settlement, there is no perversity, is my respectful
That
submission.
we'll see that.
Please, my lords.
We'll see that now. Yes. Now but till then you have to pay.
My lords, my lords, what has happened is that the impugned order states that a memo of calculation has to be filed. Now, my lords, prior to this order itself, I had filed a memo of calculation wherein I'm stating that an excess of 75 lakhs has already been paid. To that, there has been no response. Subsequent to this impugned order also, my lords, the court says, please file a memo of calculation. For the last 3 hearings, subject to correction, the decree holder has not filed their memo.
The
of
order is
calculation.
illegal. I have challenged it. So this has to be set right
No, my
first.
lords, I'm stating that I have paid in excess. Now, if they can file a memo of calculation to either retort mine.
How much you have paid?
My lords, I have not
1 lakh.
I have not paid since January 2024.
Why?
But in my memo of calculation, I have stated that I have paid in excess of 75 lakhs. That would anyway cover any sums that ought to be paid.
Totally incorrect, sir.
Where is that memo of calculation?
And there is no argument on that.
My lords, there's been no objection filed to that memo.
No
of
argument
calculation.
on that.
See, whether is it that executing court has considered that we have paid an excess, therefore there is no amount has to be
My
paid?
lords, the executing court has stated that in pursuance of this order, both parties to file their memo of calculation, and then we'll see whether the executing
No,
petition.
that is not that issue.
Please.
Now you file in a memo of calculation.
My lords is pleased to see document number.
File it here before this court after serving. Then we will see till the disposal. You have to pay
2 lakhs.
According to you, one pay there. You have to 1 lakh. You have to deposit it before this court.
My lords,
If it is he fails, then it will return to you. If he succeeds, it will be paid to him.
my lords, if I may just furnish the memo of calculation that
Serving
I've served.
Yes, we'll have it next week.
Next.
Memo of calculation. Serve the copy, Mr.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರಂತೆ.
You just verify whether it is true or
Sir.
still it is due.
Sir.
Then we will, yes.
Sir.
When do you want?
Sir, week after next one date ತಾವು fix ಮಾಡಿದ್ರೆ, please.
My lords,
What is?
I'll take notice, my lords, I'm on caveat. My lords,
Take copy for respondent. Yes, leave this matter on 4th.
Please.
Yes, 4th.
And stay ಮಾಡಿ ಸರ್ ಅಲ್ಲಿವರೆಗೆ ಅಲ್ಲಿ ಮುಂದುವರಿಸ್ತಾ ಇದ್ದಾರೆ.
What is that is there in? Now it is.
ಇಲ್ಲ ಲಾಸ್ಟಿಗೆ
they're asking for stay
1
of
lakh
their execution.
ಆದ್ಮೇಲೆ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೀತಾ ಇದೆ. ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಇವರು ಅಪಿಯರ್ ಆಗಿ
Further proceedings now.
The further proceedings is, my lords, for the parties to file their memo of calculation.
No, further proceedings is that no, your execution petition. If it is stated that yes, he wants to
ಹೌದು stay ಆಗ್ಬೇಕು.
stay of further
ಇಲ್ಲಾಂದ್ರೆ
proceedings. In execution case number 427 of 2024, pending in the file of 43rd Additional City Civil and Session Judge, Bangalore, till next date of it.
Please, sir.
Yes.
My lords, if I may be permitted to file my
File it in
statement.
the counter.
Please.
Serial number 8, Murali M.
ಅದು date ಬೇಡ. Till next one. Yes.
I pay for petitioner, please. The suit for declaration injunction, Your Honor.
Yes. Serial number?
8, sir.
Eight.
Yes.
The suit for declaration injunction, my lord, I have filed application for appointment of court commissioner. That came to be rejected, holding that if the
You
court
are the
commissioner,
plaintiff.
please,
No, suit for?
suit for declaration in injunction based on adverse position.
Yes. Why that application for appointment of the commissioner has filed? Conducting a spot inspection, or what purpose it has been filed?
To spot inspection to measure the barrel and the house situated in the suit schedule property wherein the plaintiffs are residing.
Where is
Where-
that application?
Application is at page number 38, my lord. For appointment of court commissioner for to make a spot inspection, and measure the house and barrel at the suit schedule properties and measure the cultivated land of the plaintiff as per the mentioned schedule and submit a report thereon. This is my application, Your Honor. The
Why it
trial
is
court,
rejected?
the trial court passed an impugned order, my lord, at page number
Yes.
15
Hmm.
at para number 10.
Hmm.
Moreover, if the commissioner is appointed for the purpose of exact identification and possession of the social property, it amounts to collection of evidence. This suit is filed for the relief of declaration of the title by way of adverse position. Hence, commissioner cannot be appointed for spot inspection and to measure the house, barrel, and the land cultivated by the plaintiffs. It is for the plaintiffs to prove their possession over the
Already
social property.
adverse position ಗೆ spot inspection ಹಾಕ್ಬೇಕು ನಿಮಗೆ.
No, because all the revenue records are standing in their name only. I have pleaded in my plaint because all the revenue records are standing in their name and I am in possession of the property.
No,
To prove that position, I have produced the photographs and the barrel situated.
Adverse position, your position has to be proved by evidence, not by that collection of the documents. See, if you are disputing that area, then only you can appoint the commissioner.
No, the defendants are disputing the area and the defendants are disputing that there is no barrel existed in the social property and there is no house existed.
See, now
That is the reason.
you are saying that you are that plaintiff.
Please,
You have filed in a suit for adverse position.
adverse position.
Only thing is that you have to prove your possession for a 12 years.
To prove my position, I have
And,
produced
you need
photographs.
not take any help of that commissioner to see that whether you are in that position or not.
No, at least the existing structure, Your Honor, the existing structure, let the commissioner inspect the
You have to
spot.
be, see, in suit for declaration, if it is not an adverse position, it is different. When you are seek for an adverse position, then you have to establish that position. Yes, nothing wrong in that, Mr. Yes.
That's my lord, to ascertain whether the house and the barrel is situated, because they are disputing that the house and barrel is not situated.
Then what else you have to be proved in that?
If the house,
Position, you have to prove you are in the possession from so many years. We are not hostile to that rights of that owner.
please, to prove
Then
that,
you take that commissioner means it is nothing but collection of evidence.
no, whether the existing house is there or not in the social property, that is the agriculture land where.
That
the
you have to be proved, then commissioner has to come and say that it was existing in that so and so year. Then what else you have to be proved? Then commissioner report only has to be accepted and suit has to be decreed.
No, they are disputing that I am not at all residing in that social
Then
property.
you are.
That's
see,
why I filed the
if they said
photographs.
you are in that possession from 12 years, then they are admitting that. What they else to, they have to dispute, you have to prove.
Please,
That is what that in adverse position you have to be proved.
to prove that aspect.
Sir, I have filed the wakalat, my lord, for respondents. So what has to be proved is, nec qui, nec com, nec precario. So from, 12 years continuously he is in possession. No, the date of enter into the possession has to be proved. So that cannot be done by
By the
appointing the
commissioner.
commissioner.
No, the date of entering, I am not disputing, Your Honor. My respectful submission, whether the house and the barrel, because they are disputing where the house is not also not existed
No,
in
that
the
is
social property.
immaterial, mister. You are in the possession is that, see, possession they are admitted.
At
They
least
are
for
not
the
disputing
existence of structures, my
Why
lord.
existing of structure? We are evaluating that structure.
Yeah, we have evaluated and we are.
For
paid-
what? Adverse position, we have to evaluate the structure. What is this, mister? Yes, that's all. Tell.
Because in order to prove that, my lord, my house and barrel is existed in the social property, my lord, don't have any evidence except.
Existing or not is that criteria for deciding that adverse position, mister. They are not disputing your possession.
They are disputing my position. They are saying that they are in position. That is the reason why I filed application. To
This,
prove that.
totally.
Can you see the return
collection of
statement?
evidence that cannot be done, my lord.
Yes.
Because he has to prove his possession with the aid of independent evidence.
Yes, tell.
At return statement, page number 25, my lord.
Yes, yes, yes. Adverse position, you have to prove that position, mister, not by the commissioner.
Please, they are saying that they are not made any counterclaim also in the,
To prove.
they are not made any counterclaim also. But they says that they are in the position and there is no house existed in the social
If they
property.
are not filed in a counterclaim, then you have to prove that you are in the possession, that's all.
I have proved, to prove that, my lord,
Commissioner cannot be taken help of that.
no, for the, not for the measurement, my lord, at least for the existence of barrel and the house.
Yes.
Because they says that there is no house is existed in the social property. To
But-
prove,
Even assuming that there is no house, but if you prove that you are in the possession, that is the end of the matter. What is that necessity for house?
No,
Only thing is that you have mentioned that suit schedule property. If you are in the possession, if you have to prove whether
for-
their house is there or well is there or that some office is there, that is not the material there. You collecting that evidence to show that there is a house is there, that will not help you to prove that adverse position.
because I am residing there in that property.
Assuming that you are residing there,
No, you must, no, not residing, you should enjoy the property as the owner.
that is
So
that.
hostile to my interest, notorious to my interest. No, he
That-
has produced kata, taxpayer receipt as if he is the owner. No, he has not produced any such
Yes.
material.
No,
Before the
that is
fact.
not my pleadings, because all the revenue records are standing in their name only.
No, you prove that. Yes. If a revenue record stand in the name as an owner, then how can you claim adverse position, Mr.? Yes.
Now,
You have to admit first his
yes.
ownership. Then you
I
have to claim
admitted that,
adverse-
Your Honor, adverse to his interest only, I have entered into his position.
Not- Yes. This petition is filed by plaintiff challenging order dated 18/9/2024. So and so is undertaken to appear for respondent. In OS number 135 of 2014, whereby IA number 26, IA filed under, IA number 18 filed under order 26 rule 9 for appointment of local commissioner has been dismissed. Plaintiff has filed a suit for declaration claiming a title on the basis of adverse position. During the pendency of the suit, he has filed this application under order 29 rule 99 of CPC for appointment of the competent surveyor as a court commissioner for making a local inspection and measure the house and barrels situated at the suit scheduled property. The suit is filed, one for declaration claiming a title on the basis of the adverse position. If the commissioner is appointed for the purpose of exact identification of position of the suit property, it amounts to a collection of evidence. Hence, the commissioner cannot be appointed for spot inspection and to measure that house. The trial court has rightly rejected that application. There is no error or illegalities in the order passed by the trial court. Hence, writ petition is dismissed.
Serial number 9.
No,
Vijay
I
Kumar
filed
L.
the
for
wakalat on 8/1/2025.
Yes, your name will be shown. Mr.
Grateful, Your Honor.
Yes,
Serial number
The
9.
defendant can, your lordships wanted to know, my lord, whether the
Yes.
defendant can file.
yes.
In fact, the order itself, my lord, says that, my lord. Can I persuade your lords, look at order 1, rule 10(2). I'm judgment to ಇದನ್ನು ಕೊಡ್ತೀನಿ.
Yes, if rule provision says it's enough. Yes.
I should have, my lord, got
Yes,
this
yes.
your lordship notice. ನಾನು ನಿನ್ನೆ ನೋಡ್ಕೊಂಬರ್ಲಿಲ್ಲ, ಸಾರಿ, my apologies. Order 1, rule 10(2), my lord.
Yes. Court may strike or add.
Yes, my lord.
Yes. Court may at any stage of the proceedings either upon or without that application of either. of-
Either party.
Yes. Heard. Issue notice. Stay of
Further.
further proceedings in OS number 5456 of 2023, pending in the file of 75th additional city and session judge, Bangalore, till next date of it.
Please.
Serial number 10. Varun S. for petitioner. Connected matter. Ravindranath M.N.
Petitioner, this matter, my lords. This is that matter where, my lords, it is clearly a hand loan seeking to expedite timelines by appearing before the commercial court, my lords. I produced some judgments of the learned Bombay High Court, my lords.
Yes.
Sir, on,
Give that brief facts.
If I
please,
may submit.
may
my lords,
I clarify the brief
I have
facts, my
filed
lords?
another writ petition, my lords, challenging another order passed by the same court in the same order, my lords. My lords, the matters may be connected and be taken up because if this matter has an order passed, it has a bearing
My
on
lords,
that.
it's in their favor. I don't know why they've challenged. They're
Which
saying
is
they've
that
challenged.
order?
On,
Where is that writ petition?
on the impounding, it's FR number 2330 of 24, my lords, on the impounding of the business transfer. I think.
What is that
That's on
matter?
a different matter, my lords. My
It
lords,
is in the
what-
same IA, my lords. IA
No,
number
my
11,
lords,
the
that's
same
that's
order.
not, may I just clarify, my lords? The suit for recovery of money, my lords. 3 suits have been filed by this very plaintiff, his wife and his daughter. Our contention, my lords, in the 7 Rule 10 application was that there is no jurisdiction because it is not a commercial suit. It is not an ordinary transaction for banker, etc. My lords, in that same,
So that application is rejected.
It's rejected. Therefore, we are before my lords here.
Then what is that you are challenging?
My lords, in the same order, we also filed an application for impounding of a business transfer agreement, my lords, which was produced by defendant number 1 for transfer of business from D1 to D4, my lords, the partnership firm to the company, my lords. The same has been challenged, my lords. It's in the same order, my lords.
Where is that order?
My lords, in
May I assist, my lords? May I just?
See, in that order, whether it is there, yes.
My lords,
It's
in the
not
same
there.
order. It's in the same order, my lords.
Show me that.
Please, my lords.
Yes.
My lords, writ petition 33639, my lords.
Where is that order, mister? Which is that impugned order?
My lords, page number 8, my lords, of the impugned order, my lords.
No, which is that?
Page 57 of my petition code, my lords, please take, my lords. They are making submissions on a different IA.
Wait, mister. 57.
Please.
Yes.
My lords, can see at the top
Orders
of the
on IA
page.
number 7, my lords. 7 was filed by me, my lords. On the impounding, it's the
9, 10, 11 is filed by you.
9 to 11, yes, my lords. 7 is filed by me, my lords.
What is that on 7? The order is passed.
My lords, it is rejected, my lords. We had sought for impounding of the business transfer agreement, my lords. They have paid 500 rupees as stamp duty, my lords. The business is valued at around 30 crores, my
Where
lords.
is that order?
My lords, it is in the same
The
order.
common order, my lords.
It's a common order passed.
Order portion ಅಲ್ಲಿ ಇದೆ.
Page number 8, my lords, in page of
6 of
ಸುಮ್ಮನೆ 8 ಅಂತೀರಲ್ರಿ.
I think.
96 of the petition.
Yes. IA filed by the plaintiff under order 6 so Karnataka stamp for impounding the business transfer agreement details is rejected. Yes. Now that this court has no jurisdiction, then everything has to go.
That's all, my lords.
Then it has to be transferred to that proper court and they have to rehear that IA number 7.
That's all.
Will permitted them to file an, they will, in IA number.
Taken up together, my lords.
Wait, madam.
Please, my lords.
See, now all that has to be taken together.
Yes, my lords.
All writ petition has to be allowed. Then in respect of IA 7 is concerned, that the regular civil court has to be considered. Their IA has to be considered for impounding documents. It is always there. That has to be passed. When is which is your petition?
My lords, FR number 233. My lords, but I may be heard on this petition, my lords. I'm ready with this.
No, you will.
Please, my lords.
Here are
But
that. Yes.
it may be connected and taken up, my lords, because that matter, my lords, on impounding, my lords, has, because they say that 500 rupees is sufficient for a 35 crore transfer.
If I say commercial court has no jurisdiction, then all
Yes, my lords.
writ petition has to be, including your petition has to be allowed.
Please, my
But
lords.
your application has to be, it is an impounding of the documents, it is for the state revenue. That application will be considered, that regular court,
Please, my lords.
that application will be restored. It will not be this thing. Yes,
Let it come together, my lords.
Meanwhile, my lords, matters posted day after tomorrow, my lords.
For what?
Before the trial court for filing of additional WS. My lords, when it is the
Madam,
court
you will send
without.
that.
My lords, it may be stayed till the matter is, a date may be fixed, my lords, till then there be a stay, my lord, only till the next date.
Stay of further proceedings in OS number 207 of 2021. Pending in the file of 83rd Additional City and Session Judge, Commercial Court, Bangalore, till next date of hearing.
So, if R4 I'm on caveat now. For R2 and 3 also I'm entering appeal.
You are appearing for whom, madam?
I'm for R1, my lords.
R1.
R1 and plain,
You are
R1
2
plain.
to 4, you will appear. Yes,
4 defendants.
yes, yes, yes. So and so, caveator is undertaken to appear for R1.
R2.
Learned counsel. Huh?
R2 and R.
R2 and R3 you will take notice.
On caveat. R2 and R.
Who is appearing for R1?
I appear for R1, my lords.
Who is on caveat?
I'm on caveat
Caveat,
for
yes.
R4.
No, she is also on caveat.
No, my lords, I appeared. R1, my lords, I filed my,
Not yet filed any power.
we filed, my lords. Ravindranath's name is
Serial number history. Then you have already filed an wakalat.
been shown, my lords.
Yes. Yes. Caveator, so and so is undertaken to appear for 2 to 4. Office is directed to, yes, show his name. Stay until further orders. In same order, ಎಲ್ಲದರಲ್ಲೂ. Yes.
Great.
My lords, date may be fixed, my lords.
No, that, let that your petition be posted.
Please, my
With
lords.
that we'll order this has to be connected.
Please, my lords.
Yes.
Please.
You move it in a regular course after.
It will come before the same honorable court, my lords.
After compliance office objection.
Much obliged, my lords.
Cell number 11, Vikram Munni.
Murke shall stay for the, until further orders. But the suit number different. ಇದೆ.
Lord, matter arising out of a, in an execution proceedings. Lord, I filed an application under section 47 of CPC, my lord, pointing out that after the decree, there were negotiations, my lord, and the entire issue got resolved. And there is correspondence with regard to that aspect. Lord, that was placed before the honorable court, my lord. In fact, there were two suits, two amounts. Kindly see, my lord, page 60, which gives the breakup of the amounts involved in both the suits. With respect to page 60, my lord. This is in 2022, September 17th.
Yes.
There's an email in which, my lord, second paragraph indicates, my lord, what was the amount due in respect of both suits.
Yes.
Decrease. Lord, this was negotiated and ultimately settled for an amount of 25 lakhs, my lord, which has been paid. Lord, what happened is, with regard to one of the decrees, there was an execution already pending, and that was posted before Lok Adalat, my lord. It got resolved there. Now, at that point in time, because the other amount was very small, my lord, in fact, my lord, it's a very small amount involved. No further proceedings were there. Subsequently, another execution is filed to execute the remaining, in which I took a stand that the entire matter is settled. There are correspondence, and I should get an opportunity.
Execution is for 2 lakhs and odd.
Adu ella seri around 4 lakhs agat, my lord. I'll deposit some money. Lord, my application under 47 is rejected. As I said, my lord, amount involved is very small. There is only one judgment of the Delhi High Court, my lord, dealing with it. There is no judgment of our court, my lord, with regard to what is the scope of 47. My request, my lord, is to hear it, because I have correspondence available, which indicates, my lord, that both claims have been completely settled.
What is that 47 says?
Question to be determined by court executing the decree. All questions arising between the parties to the suit in which the decree was passed or their representatives.
No, executive court has to be decided all. It is like.
And relating to execution, discharge or satisfaction.
In respect of that charge.
I have discharged it, and decree has been satisfied. Court says no, because there is an earlier closure with before the Lok Adalat.
There is no mentioning of this.
Because there was no proceedings at that point, but the correspondence is with regard to both.
What is the Delhi High Court said?
Lord, Delhi High Court goes into this issue, my lord, and says, my lord, everything has to be decided in this particular pre-decree. If there is a contract, what happens? And my lord, what should happen if there is a post-decree contract? That is what has been gone into, my lord, by the Delhi High Court. They refer to judgment of Privy Council.
What is the stage in the execution petition?
Lord, I have appeared. I filed an application that is now rejected.
What is that due amount you have to pay? You deposit that amount.
Lord, part of it I will deposit, my lord.
50% you deposit here before the executing court.
Lord, I will deposit it here, my lord, because otherwise they will.
Yes. How issue notice stay of further proceedings in commercial execution number 341 of 2024 pending on the file of 84 additional city and civil judge Bangalore till next date of hearing subject to condition. The petitioner has to deposit. What is that 50%?
Lord, decretal amount is 4.27. Lord, I'll deposit, my lord, 2.27.
Yes. Directed to deposit 2 lakhs 30,000. 2 lakhs 30,000 before this court within 2 weeks.
Great.
Cell number 12, Chokka Reddy.
Lord, in this petition, Lord, already the trial court, very same court has granted PNDC certificate to the petitioners. Lord, that is granted PNDC 112/23, page number 37, Lord. and 17/11/23, that order was passed.
Hmm.
Again, by the respondents, my lord, they approached the very same court for the PNDC in a different will. This is a
Now that, who has filed that P&SC?
PNDC, my lord, the petitioners filed PNDC earlier.
What is that,
That is, my lord, annexure F, page number 37.
37?
37.
That is Sujatama.
Sujetama.
You have filed in a P&SC for what?
Yes, my lord, this petitioners, my lord, we are representing Sujatama and Karthik Reddy, my lord. Earlier PNDC certificate was granted by the very same court.
No, why you have obtained that P&S certificate?
My lord, the will was executed by the husband and the father of the first petitioner, second petitioner. Based on the will, my lord, PNDC certificate was the applied to 276. After the due inquiry, the PNDC certificate was granted 17/11/23. The respondent, my lord, the respondent number 1 and 2, claims a second wife and son. Before the 1 month death, they have created one will. She has applied the PNDC certificate on January 24.
They have filed one more this thing.
One more.
You have
That-
filed an objection there.
My lord, we have filed, we brought to notice to the court. Already PNDC certificate was granted based on the will. Their only option on 384 under the Indian Succession Act, they have to file the appeal for revocation or they file the declaration suit for the claiming their relationship and based on the will. That
now
is
the-
only the option. Again, second PNDC, it is a bar.
Now, what is that order passed by the?
My lord, no order was passed. We have challenged the second PNDC, the
No, why can't
registration.
you file an application there?
We brought to notice to the trial court. We have filed the implementing applications. It was allowed. We brought to entire thing. It was granted. That is page number 32, my lord.
See, CPC is not applicable to that.
CPC is not, 384 is very clear, my lord. Once PNDC certificate was granted, Indian Succession Act.
I tell you, why
384.
can't you file an application there and seek for that?
Once 276 granted, 384 the appeal.
Why can't you say all these things before that court?
My lord,
Now, what is the extent of CPC is applicable, mister? In which is the
and
provision?
384, my lord, subject to provision in part, an appeal shall be right to the High Court.
ಅದು ಗೊತ್ತಾಯ್ತ್ರಿ.
Yes, ma'am.
You can raise that ground before that same court.
My lord, in this page number 32, entire thing we brought to the notice, my lord. In my application, para number 9, my lord.
ಏನ್ application?
ನಮ್ಮ implementing application we brought to entire thing. Already
ಆಯ್ತ್ರಿ,
PNDC
ಅದನ್ನ-
certificate granted by the very same court.
ಆಯ್ತಪ್ಪ, dismissal ಗೆ ಏನಾದ್ರೆ ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ ಹಾಕ್ಬೋದಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
No,
CPC is not applicable.
CPC, my lord, under the 384 is appealable order that was my PNDC.
ಅಪ್ಪ, ನಾನೇ ನೋಡ್ಕೊಂತೀನಿ
Yes.
ಬಿಡಪ್ಪ. Under that Indian Succession Act ಅಲ್ಲಿ, what extent CPC is applicable proceedings under that Indian Succession Act ಅಂತ ಹೇಳ್ಬಿಟ್ಟು P&SC ಕೋರ್ಟಿಗೆ I am asking that. Now I have to read entire act and see that what is that extent it is applicable to that. Which is the provision for this thing, mister? Protection of property. Yes, you see this under Indian Succession Act, whether CPC is applicable to the
Yes.
what extent? Password.
Yes.
CPC is applicable, mister.
ಅಲ್ಲ ಅದು ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆ, ನಾನು ರೂಲ್ಸ್ ಅಲ್ಲಿ ಇದೆ,
Rules ಅಲ್ಲಿ ಇದೆಯಾ?
ರೂಲ್ಸ್ ಅಲ್ಲಿ ಬರ್ತಾರೆ ನೋಡ್ಬೇಕು, ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
One date may be given, I will peruse the.
That's all that.
Yes.
If there is what extent is applicable, you can file an application under that and
Yes,
seek
yes,
for a dismiss. Why you have to burden this court, Mr.
Yes,
Severi? When do you want?
On next Monday or Tuesday, when the date may be.
Yes, leave this matter on Tuesday.
Bill number 13, Ananda Ramake.
Petitioners. It's a plaintiff's writ petition, my lords.
Yes.
Where, my lord, I have sought for, I filed an IA for deleting issues number 2 and 5. My lord, the case of the plaintiff says. Suit for, my lord, partition on the basis of a will.
Yes.
my lord, I claim, my lord, the rights to the property under a will dated 13/9/2019, executed by my maternal uncle. And my lord, the defendants 1 and 2, they claim, my lord, under a subsequent alleged will dated 5/12/20. So in the 5/12/20 will, the execution of the earlier will is admitted. And they also admit in the written statement with regard to the will executed in my favor, which I am, my lord, which I have projected. Now, my lord, issues are framed. Kindly see, my lord, issue number 2, that is with regard to proof. My lord, page 79 at annexure H.
Yes.
Issue number 2, whether the plaintiffs prove that the testator by name so and so has executed his last testamentary document on 13/9/2019 when he was at free state of mind. This issue does not arise because it is admitted in the written statement. Your lordship may kindly come to the written statement, my lord, at page number 51.
By admission itself is enough.
Yes.
No, will has to be proved, mister. Even if there is an
Will is admitted.
See, even if it is admitted, you have to be proved that will has been executed. It is not like that any other pleadings, if that they have admitted, it cannot be. What about that will?
My lord, the will dated 13/9/2019, its execution itself is admitted by the defendant. So therefore, my lord, the question of again proving it will not arise.
No,
The question is, second will.
No,
The second will.
see, anybody claiming in a rights on that will,
yes, ma'am,
it is burden on you to prove that that executor has state of mind and that whether there is any coercion and all has to be proved. Even if there is no, denial, you have to be proved, mister. It is what that on the will. Even there is no denial, will has to be proved. Just because you filed in a will, other side said that there is no objection, will is there. That is not that. Will has to be proved by, therefore court has framed that what is that difficulties. If you are in a genuine will, you have to prove it.
Lord, kindly see, Lord, page 53.
Show me that in respect of the will, if other side admitted, it cannot be proved. You show me that judgment, then I will accept.
Lord,
That is-
specifically, my lord, I will look out for those judgments.
You see that,
But
that is the main point. Why is the court?
Generally, my lord, in pleadings.
No, all that pleading, it is right. In respect
Yes.
of the will is concerned, it is different. Even nobody is objected, you have to prove that will. You verify that.
I'll verify. My lord, there's one more issue, my lord, that is issue number 5. That is, my lord, regarding the subsequent will dated 5/12/2020. Literally, the burden is on the defendants.
Whether the
Other-
plaintiff prove that will dated so and so is fabricated, defendant number 1 is, no, that is not correct. He has
That
to
is
prove-
not correct. That is not correct. Issue number 7 will cover ಆಗ್ತದೆ. The other side has to prove it. That will be covered in
Whether
issue number
defendant
7.
number prove that this is malapasasi. If you prove that will is genuine, then question of you have to be.
Not true, does not.
That is not correct. 5 is not correct.
5,
Yes, but this is 2 is correct.
2, I will, my lord, make my submission.
Yes.
But
Very
till then, my lord, until next date, let there be a stay, my lord. The court is proceeding for evidence.
No, we will stay in respect of the issue number 5. Let the proceedings go on.
Very well.
Yes. Or issue notice. Stay of order dated 10/1/2023 only in respect of issue number 5.
My lord, notice to respondent number 3 to 6, my lord, can be dispensed because plaintiffs only objected, my lord. R1 and R2 objected for my application. Others did not object.
Whom you have to dispense? 1 to?
R3 to 6 can be dispensed, my lord.
Yes, filed in a memo seeking
I'll file a memo.
dispensation to 3 to 6 dispensed at the risk of the petitioner, issue emergent notice to 1 and 2. Stay of order dated so and so in OS number only in respect of issue number 5. Yes.
Problem.
Cell number 14 adjourned, cell number 15, Krishna S. Vyas.
Lords, this petition, my lords, arises out of the order having been passed by the Ghana trial court, my lords. Execution proceedings, sir. It may kindly be seen that, my lords, sir, an application came to be preferred by the decree holder, my lords, sir, under the provisions of Order 26, Rule 4 of the Code of Civil Procedure, my lords, sir, thereby seeking for an appointment of a court commissioner for
Yes.
measurement of a property, my lords,
Suit for?
which had been decreed. It was originally a suit for injunction, my lords. The suit was filed and decreed in the year 29/9/2019.
Injunction suit. Now that,
A bare injunction suit.
who has filed an application for appointment of commissioner?
The plaintiff, who now is a decree holder in the present execution petition. Later, my lord, the execution petition came to be instituted on 11/3/2022. 99 decree, 2022 is the execution petition which came to be filed. It is interesting to be noted that, my lords, in the original proceedings, it was the claim of the plaintiff that in survey number 215 of Mudigere village, my lords, 15 guntas of land belongs to the plaintiff, who is the decree holder. 16 guntas of land belongs to the defendant, who is the judgment debtor herein. The evidence which is led by the defendant, my lords, is already by plaintiff, my lords, is also to the said effect. I draw the attention of this honorable court to page number 68, being the cross-examination in the execution proceedings of the decree holder, my lords. I draw the attention to paragraph, line number 2, my lords.
Yes.
In a decree schedule survey number ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 31 ಗುಂಟೆ ಎಂದರೆ ಸರಿ, ಸರ್ವೆ ನಂಬರ್ 215 ಪಕ್ಕಾ ಪೋಡಿ ಆಗಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. A property which has not been pakka powdered.
Yes.
And later, my lords, I draw the attention of this honorable court to page number 65. The earlier page, my lord, 65, which is the chief examination of the decree holder. Paragraph number 4, my lords.
Yes.
ಅನುಸೂಚಿ ಸೊತ್ತನ್ನು ಅಳತೆ ಮಾಡಲು ಸಹ ಜಡ್ಜ್ಮೆಂಟ್ ಡೆಟರ್ ಬಿಡುತ್ತಿಲ್ಲವಾದ್ದರಿಂದ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ 215 ಇನ್ನೂ ಪೋಡಿಯಾಗಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಪರವಾನಗಿ ಭೂಮಾಪಕರು ಅಳತೆ ಬಂದಾಗ ನೀಡಿದ ಹೇಳಿಕೆ ದೃಢೀಕೃತ ನಕಲನ್ನು ನ್ಯಾಯಾಲಯ. So here the land is not ported, the boundaries are not determined. It is an admitted fact that survey number 15, 16 guntas of land belongs to this petitioner. Now, my lords, when the land is not ported, it is completely covered under the Land Revenue Act of Karnataka. And a surveyor has to be appointed.
What is that decree?
My lords, decree is an injunction decree, my lords. A suit for injunction, a decree of
Have you
injunction.
taken that contention that property cannot be identified?
Yes, I have taken all through my contention. This is the.
In the original suit,
Yes, I have taken that.
court has granted.
Still, court has granted.
You
the
cannot
decree.
challenge that.
I challenged it in RA, my lords. RA also confirmed the decree. And because, my lords,
No, then how that decree will be implemented if that property is, suit schedule property is not?
that is the difficulty here, my lords.
No, but you have failed in that appeal also.
No, my lords, my question is that I don't dispute with regard to 15 guntas of land belonging to the plaintiff. Let it be there. But it is supposed to be done in a proper procedure, wherein notices have to be issued to all the neighbors of the property. It cannot be by the interference of the civil court.
No, but in the degree, there is a schedule.
Yes, that schedule also does not match, my lords, here.
But
That
how
is the
can you
difficulty.
allow for granting a degree, mister? You are saying that everything is not matching.
Yes, yes, my
But
lords.
court has granted a degree. Degree for what then?
That is the difficulty here, my lords.
But even the appellate court also confirmed.
And that also, my lords, 1999 decree came to be passed. Now in 2022, they are passing it. It is a non-ported property. Whether there is a decree or not, my lords, decree would to be the extent of.
Now, what is the order passed by the trial court?
My lords, order passed by the trial court is at page number 34, my lords. The judgment of the trial court.
Yes. Yes.
Plaintiff's suit is hereby decreed as prayed for. The defendant.
No, no. Now, what is that order you are challenging?
Yes,
here?
my lords. Impugned order
Yes.
is at page number 88, operative portion, page number 90, my lords. Begins from page number 88, operative portion, page number. IA number 2 filed by decree holder under order 26, rule 9 of Code of Civil Procedure is hereby allowed, and accordingly court commissioner is appointed.
No,
ADLR Mudigere is hereby.
Conducted a commission work to hold that local inspection so as to conduct the survey of the degree suit schedule property to note that encroachment, if any, in the same and to submit a report. Yes, he will
No.
survey in terms of that boundary.
No, my lords, here the difficulty is that let the survey be conducted. That is not our difficulty. Our difficulty is that certain portions of property belonging to the decree holder himself has been acquired by certain other neighbors of the property. Now, if this survey is conducted beginning from a particular boundary, my lords, then they would say that there is an encroachment of your property because we have not moved into. Whereas the northern portion, certain other neighbors have moved into.
Yes.
Now, it is, we do not dispute with regard to 15 guntas.
What is stay of impugn order dated. What is the date, Mister?
Dated 5/12, the 29/11/2000,
29/11/2024,
my lords.
passed by Civil Judge JMFC Moodgere in execution 6/2022 on IA number 2 filed under Order 26 Rule 9 of CPC till next date of it.
Much appreciated.
Bill number 16, Purna Chandra M. Puranik for petitioner, Prithvi Wadiyar.
The caveat respondent, my lord.
Lord,
defendant's
defendant's petition.
My lord, I make one submission. My lord. It is, Prithvi Wadiyar cousin brother is passed away, my lord. He is rest to native, my lord. Next week, any date, my lord?
Yes, Mr. What is? Yes, 21.
28th, my lord.
Yes, 28.
28th. There's some urgency in the matter, my lord.
What is that?
I'm challenging the order of the first appellate court in granting an injunction in favor of the plaintiff. I'm the defendant. The trial court held that I am in exclusive possession of the property
No,
and
suit for
suit for bare injunction, my lord.
who has filed?
Plaintiff has filed. I am the defendant.
A suit, what has happened? Suit.
In
Suit
the
is
suit-
dismissed.
No. In IA number 1, the suit has dismissed. First appellate court granted an order of injunction.
No,
I have to harvest my crops, my lord.
no, I'm asking, suit is decreed.
No, my lord.
No,
It
no.
is an
On-
order on
it's an
IML.
Application
Application on IA number 1 for temporary injunction.
then is granted.
It is
dismissed.
rejected by the trial court.
First
And
appellate court.
First appellate court allows the application and granted the injunction on the ground that the plaintiff is a co-owner. Trial court had held that the plaintiff is not in exclusive possession. Defendant is in exclusive possession.
Now, only thing is that who is in the possession, Mr.
I am in the possession and the bare injunction suit is not maintainable, my lord.
Monday, my lord, I am at least.
Yes, Monday.
Monday.
Yes. No, 28th only. 28th. Monday, so many matters. 28th.
Grateful.
Published.
Bill number 17, Anandaram K.
Petitioners.
Yes.
Suit for declaration. The parties, my lord, are the same as in serial number 13, my lords. My lord, the defendants there, 1 and 2 there filed this suit, my lord, by way of, my lord, a counterblast. Then, my lord, here also, my lord, the same wills are in question. The other side filed the suit declaring that they are the absolute owners as per the will dated 5/12/2020. Now, evidence is led. Both the cases are called before the same court. Evidence is led. After leading evidence on all the issues, your lordship may kindly come to Annexure T, page 227. They file a memo. The burden is on the plaintiffs in respect of all the issues. My lord, they file a memo saying that seeking liberty to lead rebuttal evidence.
220.
227.
Plaintiff number 1 being
Examined as PW1 and also on behalf of the plaintiff, witnesses have been examined. About 5 witnesses have been examined, including, my lord, the attesting witnesses to the will and sub-registrar and others.
Total evidence after the evidence of the defendant is reserving liberty.
Lead rebuttal evidence.
That order passed by the trial court.
The trial court says the liberty is reserved to lead rebuttal evidence because they have to prove after the defendant proves certain issues.
Which is that provision which provided for this rebuttal evidence?
Order 18, Rule 3 minutes. Order 18, Rule 3.
What is order 18 to?
No, this liberty in general, my lord, to lead rebuttal evidence is unheard of.
No,
My
let
lord,
us
if
see what-
burden, yes, if burden is exclusively on the defendants, then, my lord, plaintiff can lead reserve liberty saying that once the defendants lead evidence, then I will.
No, what is that issues? What are
Issues the same issues, my lord, whether the plaintiffs prove the will dated 5/12, issues are, my lord, at
Where is
Annexure
that
H.
issue?
Annexure H, page 76.
76. Yes.
The first issue is, my lord, with regard to the will dated 5/12.
What about that issue number 2?
Issue number 2 has been recasted. This is also, my lord, they have already led evidence in respect of issue number 2.
For that, he has to give an evidence.
No, my lord, it is defendants checked the plaintiffs and Tamadidar. That order is there, my lord, in the order sheet. This issue has been, I filed an application saying that casting of burden on defendant on issue number 2 is not correct. So therefore, that issue has been recasted.
Where is that?
My lord, kindly come to, my lord, the order sheet, Annexure A.
No, let us see that.
Yes,
Then, what is that additional issue? Whether the defendant number 2 to 5 prove that will dated. Again, that issue is there on the defendant. Additional issue.
Additional, kindly, my lord, additional issue 3. Your lordship may kindly say additional issue number 3.
Additional issue number 1.
Addition 1 and 3, my lord, 1 will not arise because 3 has to be proved first and he has led evidence.
No, see.
Whether plaintiffs prove that Ramakrishna Shetty executed the will dated 5/12. This is same as, my lord, issue number 1.
No, that issue number, whether the defendant number 2 to 5 proves that will dated so and so, concocted, got made by that coercion and so and so.
My lord, this, my lord, your lordship saw in the other case. Issue number 5 in the other case.
We have not sought for any this thing.
This, my lord, now that this application is being filed to delete this issue, my lord.
Then,
So-
till then.
Adu, my lord, that issue does not arise because kindly come to issue number 3. Additional issue number 3.
No, if you are put in a question on these issues, if your answer,
Yes.
then he has to rebuttal is there for him. When there is an issue, burden is lies on you. Unless
no.
that issue is,
My lord, this burden is wrongly casted in additional issue number 1.
if it is wrongly casted, you have rightly filed a writ petition in that connected matter.
Yes.
Here you have not filed any this.
My lord, here, my lord, they are filing the application to delete this issue.
Then only
In
we can.
any event, my lord, issue number 1, additional issue number 3 are all one and the same. Because he is seeking absolute ownership on the basis of the will dated 5/12. He has led evidence.
Maybe once issue is there, lies burdens on the defendant, liberty will be given to the plaintiff, rebuttal in case. But here issue is there. Unless that issue is there, you can't say that it is wrong.
My lord, issue number, kindly see, my lord, issue number 1, additional issue number 1.
No. Now that you see issue number, additional issue number 1 is burden on you to prove. As long as the issue is there, it is burden on you. If you are not done it, tomorrow's degree in that.
Lord, additional issue number 1, the burden does not arise at all because ಈಗ ಈ additional issue number 3 ಮೇಲೆ evidence ಆಗಿದೆ, cross examination ಆಗಿದೆ. My lord, additional issue number 3 is whether they prove the will dated 5/12/20. So whether they prove or not, attesting witnesses are examined, sub-registrar is examined, cross-examined.
Liberties is given only if you have say something about that concocted documents of that will, then he can rebuttal. Because that
Lord, that question will not arise, my lord. My lord,
as
solely
long as-
if, my lord, a particular issue, the entire burden is on the defendants alone. Only then, my lord, the question of leading rebuttal will arise. Rebuttal will come, my lord, only when the plaintiff does not lead evidence in chief first.
Now, where is that put-in?
Order 18, Rule 3. Because he has to start first, my lord, by way of a rule.
Order 8?
Order 8, Rule 3, my lord.
Yes.
Order 18, Rule 3, my lord. Sorry. Order 18.
Yes. Rule 3.
My lord, hearing of the suit and examination of witnesses. Right to begin. The plaintiff has the right to begin unless the defendant admits the facts alleged by the plaintiff and contends that either in point of law or some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks, in which case the defendant has the right to begin. My lord, kindly come to Rule 3, my lord. Evidence where several issues. Where there are several issues, the burden of proving some of which lies on the other party. The party beginning may at his option either produce his evidence on those issues or reserve it by way of answer to the evidence produced by the other party. And in the latter case, the party beginning may produce evidence on those issues after the party has produced all his evidence, and the other party may then reply specifically on the evidence so produced by the party beginning, but the party beginning will then be entitled to reply generally on the whole case.
See.
Now, your lordship may kindly see the first part, where there are several issues, the burden of proving some of which lies on the other party, the party beginning may at his option either produce his evidence on those issues or reserve it by way of answer. Here he has not reserved it by way of answer.
Wadi.
He has produced it already.
It by answer to that evidence
Produced by the other party. And in the latter case, the party beginning may produce evidence on those issues after the party has produced all his evidence. And the other party may then reply specifically on the evidence so produced by the party beginning. But the party beginning will then be entitled, only, my lord, if rebuttal evidence is issued, then, my lord, generally. But generally does not mean generally in respect of the entire evidence.
No, here either he can do it in first or he can reserve it.
Reserve. Here he has not reserved. He has led evidence. On the will dated 5/12/20, he has led evidence.
No.
And he has examined 2 attesting witnesses, sub-registrar.
Later case, the party beginning may produce the evidence on those issues after other party has produced all
his evidence.
evidence, and the other party may then reply specially on the evidence.
Specifically on the evidence so produced by the party beginning.
But the party beginning will then be entitled to reply. There is no case that he has to be reserved. He can do it.
Howದು, at his option.
Option.
Now, my lord, he has not exercised the option
No,
initially.
there is no provision says, first he has to take, take any options or liberty before beginning his evidence. It is not that wording like that.
No, but he has an option.
He has an option.
Has an option. Now, my lord, when he leads evidence, impliedly it would mean that he has exercised the option to lead evidence.
No, that it is not said or and. He can do it.
No, that, my lord, has been interpreted, my lord, by various
See,
courts.
if provision says, if you are opted first one, he cannot later. But that is not that provision. Provision says either of them he can do it.
But then he has to reserve liberty, my lords. Now, my lord.
Liberty reserve.
Issues, for example, my lord, there are 5 issues. One of the issue, my lord.
He has filed an application for liberty.
The memo is filed, but the memo is filed to lead rebuttal evidence generally. Your lordship may kindly see the memo. He says, I have completed my evidence, I have led witnesses, let them lead evidence, I will lead rebuttal evidence. No, that cannot be done.
Now, court can consider only if there is any burden lies on that defendant.
Burden is not there.
If there is an issue, additional issue number 1.
My lord, that burden will not arise because it comes under additional issue number 3. That issue, my lord, is wrongly framed.
Where is that order of the trial court?
Annexure A, my lord.
What is the finding?
My lord, kindly come to page number 25.
Yes.
About 4 or 5 sentences, my lord, from the top.
The plaintiff are reserving the right to lead that rebuttal evidence on the issues burden shifted on the defendant. Adu correct ideyalri?
Alla, shift aad nanತರ ಬರೋದಿಲ್ಲ. My lord, he has to lead, my lord.
See,
my lord, when
shifted anta word is wrong, where that burden lies on that defendant.
Correct.
Shift anta helidare anta andre issue ali burden is there on you. Under those circumstances he can. Suppose if that additional issue number 1 is not there, then he has no option for seeking.
My lord, additional issue number 1 specifically will not
take out notice. Yes.
My lord, till then, my lord, further proceedings may be stayed, my lord.
No. You have rightly challenged in that other case, but here you have not challenged.
ಅಲ್ಲ ಇಲ್ಲಿ ಅಲ್ಲಿ ಡಿಲಿಷನ್ ಹಾಕಿರ್ಲಿಲ್ಲ by oversight.
You file it. Take notice in the meantime. And if you want, I will give an hand summons also.
ಆಯ್ತು, hand summons, my lord, and a date may kindly be given.
Yes, heard. Issue notice. In addition, petitioner is also permitted to take out hand summons to the respondent.
No, I'll serve on the advocates. Serve on the advocates.
Barlilla antandre, you can't say that it is served. That is the problem. He may file an application, wakalat, or he may say he will not come.
No, I'll take both hand summons and on the advocate.
In addition, he is permitted to take out hand summons to that respondent and also permitted to serve a copy on the counsel appearing for the respondent before the trial court. Yes.
Lord, date may
After service, you move that matter.
My lord, if it is a pending matter, then my lord, to list it.
You can move at any time in my court. 10:30, if you say I have moved it, then I will fix the date.
After 2 weeks on the date code is not.
Yes. Is this matter on 5th? Yes.
5th February.
5th February.
Apply.
Cell number 18, Sheshadri NS.
Plaintiff's writ petition, my lords. Plaintiff will suit for specific performance.
Yes. Our officially immediate notice ಕಳಿಸಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ. Process ತಕ್ಷಣ notice. Yes.
Defendant executed 2 agreement of sale in favor of plaintiff.
Yes.
Petitioner herein. He admitted the execution of P1 and he has denied execution. Specific performance.
Yes.
He has admitted the execution of exhibit P1, a registered document, and he has denied the execution of exhibit P2, my lordship.
What is that application you have filed?
For appointment of handwriting expert under 26 rule 10A, my lordship. That application was rejected. As against that, my lordship, petitioner has filed.
No, he has admitted that execution.
There are 2 agreements, my lords. He admits one agreement and he denies another agreement.
No, but you seeking in a specific performance on both agreement or?
Please, both agreements.
Yes, what is the reason given by the trial court? What is that reason, Mr.? Present circumstance case Denial of the execution by the defendant itself cannot be a reason to send that admitted handwriting expert for his opinion. The evidence attached to witness is evidence with regard to the execution document by the person is best direct evidence opinion of the evidence handwriting experts.
Court come to the conclusion that
Yes.
by leading the evidence of witnesses, it can be ascertained.
Notice stay of further proceedings in OS number 7154 of 2012 pending in the file of 31st Additional City Civil and Session Judge Bangalore till next date of it.
Office section first time matter, serial number 19, Naveen JN.
Worship, I put for the worship only one office objection, your worship, it can be overruled. ಅಲ್ಲ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಅದು ಮ್ಯಾನುಸ್ಕ್ರಿಪ್ಟ್ ಟೈಪ್ಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ರಿಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಎಲ್ಲ ಟೈಪ್ಡ್ ಅಲ್ಲೇ ಇದೆ. ಪೇಜ್ 46 ತಗೊಂಡ್ರೆ ತಾವು
Yes.
ಆರ್ಡರ್ next week any date, your worship.
Yes, leaves this matter. Submission of learned counsel for the petitioner is accepted. Office objection is overruled. Leaves this matter on 6th. Yes.
Obliged, worship.
Serial number 20, R.A. Devanand.
Yes, 2 weeks to comply of subjection.
Serial number 21, Sneha Nagraj.
2 weeks. You are there. Yes. Is there any urgency? Yes. What is that?
It arises from an order 1 rule 10 application.
We'll see that office objection first.
Office objections are in the impugned order, a cover sheet illa anta. We'll produce that, my lord. That's the first objection. The second objection is
Page to be filed in that annexure. That is the only objection.
that's the only objection. The other objection, my lord, seems to be there's some note because in the
No, I don't think any, that is the only objection.
Only objection.
Yes. What is this, Mr.?
my lord, can I request my lord to kindly go to page number 351, my lord.
Yes.
Now, my lord, I am the plaintiff in the suit.
Yes.
My lord, the suit, my lord, in the suit, I have filed the suit against the defendants contending that they have fabricated some document
Yes.
for a declaration that this document is, I'm not a party to it, it is an illegal document and it's non-nest void, etc.
Yes.
So that's my relief.
Yes.
Now, my lord, a third party comes and files an application to say, please implead me because the person who has created, the defendants in the suit have in turn had some other transaction with them. So therefore, I should be made a party to this,
Why he is necessary in that?
my lord. So therefore, I contended that he is not a necessary party. It will change the complete complexity of the suit. Now, my lord, kindly look at page 351.
No, his application is allowed.
No, my lord, first his application was dismissed.
Yes.
The order of dismissal, my lord, will get at page 351.
Yes.
That is on 22/2/23.
Yes.
My lord, may kindly go to page number 354.
Yes.
My lord, the third line
Filed by that so and so is dismissed.
is dismissed. If if the right of the proposed is
Then he has
affected,
filed
they
an
are at liberty
petition.
to file a fresh suit, etc.
Hmm.
Then, my lord, that order was challenged before this honorable court.
Yes.
And, my lord, may kindly now look at page 355 is the order of this honorable court.
Yes.
The challenge.
What is that?
My lord, can I request, my lord, to kindly look at page 370? This court said, the trial court should have looked at the issue of who is a proper and who is a necessary party. There's no finding about who is proper and who is necessary. Kindly look at page 370, my lord. Paragraph 13.
Yes.
Kindly see paragraph 13, the last 3 lines of that paragraph 13.
Yes.
The question that requires consideration is whether the petitioners are necessary or proper parties to the suit. Then, may I request you to kindly look at paragraph 17 at page 372. In that view of the matter, without adverting to merits of the case, the parties are relegated to trial court. Trial court shall dispose of the application afresh, keeping in mind the settled principles of law applicable for adjudication of application and order.
Whether necessary or.
Now, my lord, the impugned order, my lord, may kindly see at page 46. My lord, the court my lord, passes the exact opposite order, but again without considering whether it's proper or necessary.
Yes, there is no reason given that why he is in a proper party.
Yes, whether he is a necessary or a proper party, there's no finding at all.
Yes. Or issue notice. Submission of learned counsel for the petitioner is accepted. Office objection is overruled. Issue emergent notice. Stay of
impugned order, my lord.
Order dated 7/6/2024.
24 on IA number.
Passed in OS number 530 of 2016 on IA number
3, my lord.
by 7th Additional Senior Civil Judge Bangalore till next date of hearing.
Cell number 22, Shivakumar KB.
Yes. Now we'll see that office objection, what is.
Office objections, I will comply with the office objection, there is no difficulty. Aದೇನೋ
Writing of the
registration certificate
parties
ಕೊಡ್ಬೇಕು.
to be OS court.
Registration certificate ಕೊಡ್ಬೇಕು ಅಂತ ಒಂದು.
Annexed designations of the petition.
I will correct all those things, all technical objections we will do it.
No, you comply, it will pass it over.
ಅಲ್ಲ, ಇದು ಒಂದು
Only
ನಿಮಿಷ.
after compliance.
ಮಾಡ್ತೀನಿ. My friend will do it. The urgency is this, kindly look to
No,
page 112.
I will hear, you comply it, will take at 2:30. All that cases, if there is an urgency, office objection required to be complied, you comply it, will take at 2:30. Yes. Pass over.
Cell number 23,
File.
Suma K.
Yes.
ಈಗಲೇ ಮಾಡ್ತೀನಿ.
I'm the advocate for the petitioner. There are 3 office objections. Monday, a date may be given. I'll comply it by Monday.
Yes, 2 days time is granted to comply office.
Much obliged. The date may be fixed, Your Lordship.
You comply it and move that matter. Yes.
Cell number 24, Devendra N.
Petitioner in this case, the respondent disconnected the water and
No,
electricity.
what
The
is
water-
that office objection?
Each page ಗೆ signature ಮಾಡಿಲ್ಲ ಅಂತ ಚಿಕ್ಕ small.
You do it, you
Please.
comply, you comply it, pass over.
Please.
Wherever that's required, you have to comply. Yes.
Office objection, second time matter. Cell number 25, Basavanna KM.
Yes.
For the petitioner, Your Honor, praise 1 week's time to.
Yes, week's time is granted to comply office objection.
Much
Fourth
obliged.
time office objection, serial number 26, Pradeep Nayak.
Here for the petitioners,
Hmm.
I've given an council submission on this.
Hmm.
The objection is that there is no preamble to Annexure D. Annexure A and Annexure D are both certified copies of the lower court record.
Hmm.
I'd applied for them together, both have been given together. So the preamble for is just the cause title for Annexure A.
Preamble petition annexure A has to be stated, yes.
So the
Submission of learned counsel for the petitioner is accepted. Office objection is overruled. When do you want?
As I'm ready today, if your lordship, I had made brief submissions on the last date also. Suit which is filed by somebody with no cause of action.
Yes.
I file a 7-11.
There is an
Yes,
interim, there is an interim order against me, so any early date, my lords, even today we are ready.
Yes, on third February. Please, yes.
Deeply obliged.
Interim order is already granted in this.
It should be
But
extended.
I filed a vacate application.
Yes, interim order granted earlier is extended till next date of hearing. Yes.
Obliged.
For order, serial number 27, PB Raju for appellant, JM Anil Kumar.
Letter
Well,
of extension.
B3 in this matter, my lord.
Extension of time.
Yes, my lord.
Yes, this court by order dated 21st September 2023 directed the trial court to dispose of the suit as expeditiously as possible, not later than 1 year from the date of receipt of the certified copies of the order. The registry has received communication from Principal Civil Judge, Civil and Session Judge Bangalore on 6/1/2025, seeking further extension of the time for disposal of the suit. What is the stage now in this one?
It is for defense evidence, my lord.
Yes. For the reason stated in that communication dated 6/1/2025 and 28/12/2025. The further period of 6 months.
Much further.
Further period of 6 months is extended from today.
Serial number 28, Amit Deshpande for petitioner, government advocate.
In this case, my lord, your lordships had dismissed it for default, for no appearance. My lord, now, at the time of filing of the writ petition, my lord, we had deposited 4.5 lakhs as a deposit money. My lord, with regard to that and also on the merits, my lord, I may be permitted to address because on the day when.
Here for the petitioner, learned counsel for the counsel appearing for the respondent, Gram Panchayat submitted that lease granted in favor of the petition.
That is erroneous, that is wrong, my lord, because we had deposited the money.
5 years has been expired. As per the demand notice, L petitioner paid the lease amount. Submission. Now that period is expired.
Expired, but at the time of, my lord, making this submission, at the time of the hearing of the writ petition, we had deposited 4.5 lakh rupees. And not only that, my lord, the matter on hand is with regard to the correctness and correctness of the demand that was raised. It is ultimately fishing rights in that Bairmangla lake where we had sought for certain fishing rights, my lord. It may be restored. I have served the copy on Mr.
No, restore, you can't say that, mister. When you are not appeared, why you have not appeared? You have to explain that.
My lord, I have filed an application.
What is that reason?
My lord, my lord.
Say that I will not appear on.
No,
that
no, I'm
day,
sorry, my lord.
dismiss, you can restore it.
No, I'm sorry. I have
Don't
filed
take-
an application.
Granted, yes.
I have regretted, my lord. I have made a regret in my affidavit also.
Yes, what is that
My
reason?
lord, I have stated that, my lord, I was advised to file an application subsequently, my lord. I came to my colleague who was instructed to appear.
Who has filed an affidavit?
My lord, I filed an.
Yes. Who is that other side?
My lord, Mr. Nagarajappa, my lord, I have- I served him. my lord.
Yes. What is that rectification of office
ಅದೇ
objection?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾಗರಾಜಪ್ಪ ಅವ್ರಿಗೆ
Yes.
ಕೊಟ್ಟಿದ್ದೀನಿ.
IA.
Delay is also there.
Yes, IA 1 of 2020. Delay there. IA 2 of 20. Which is that IA for delay, mister?
My lord, I 2, my lord.
2 for recalling.
Yes, 1 is for delay, my lord.
Yeah. IA 1 of 2024 is filed for condonation of delay in filing an application for recalling that order dated 10/7/2024. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay in filing recalling application is condoned. IA 1 of 2024 is allowed. Consequently, IA 2 of 2024 is allowed. Order dated 10/7/2024 is recalled. The petition is restored to the file. Yes.
Any date for preliminary hearing next week.
It is come the regular court, mister.
Objection.
Yes.
I'm good.
Officer. Bill number 29, Inayatullah Sharif KF.
My lord, in this matter, the reputation is about to get infructuous in that background. Only respondent number 9 is contesting. In fact, I ought to have taken for dispensation before. But since I am not permitted to do that, I will withdraw the reputation with respect to respondent number 6 and respondent number 4. They are not contesting the claim of the petition for the trial court also.
No, you need not withdrawing that. You can delete them from the parties. You can, this thing.
In fact, they have been placed excerpt before the trial
No,
court.
you
They
can
did not-
dispense that notice.
Notice
You're
is
not
already
withdrawing
issued.
that writ petition. What is that suit for?
So, my lord, suit is one for declaration of title.
Hmm.
With respect to land bearing survey number 27/1A. Only a typographical error in the schedule that came to be filed.
You are the plaintiff.
Plaintiff. May I kindly
That
take,
order you are challenging.
my lord, order is at page number 37, annexure E. The application came to be dismissed on the sole ground that
No, what is that application for?
application is for amendment. It is at annexure C, page number 33.
You are the plaintiff.
I am the plaintiff.
Any respondent, defendant has filed an objection for that.
Objection has been
Who has
filed.
filed?
Respondent number 9. Now
Is
he is served, but he is not represented before this honorable court.
he
Is that-
served now.
He is served.
Yellide.
ಕೆಳಗಡೆ
Which respondent is?
respondent number 9.
Respondent number 9 is.
Unserved cover returned with postal share in respect of R3 to R7. Sorry, R3, R7 to R10 as addressee absent, not claimed.
No, R9 is not served, mister. He is the.
Addressee absent, not claimed.
No.
RPD ಹೋಗಿದೆ ಆಮೇಲೆ ಅವರು
R7 to R10 adu.
R7 to R10.
Yes. Notice issued to that respondent number 3, 7 to 10 is written with postal shara, not claimed. Then service of notice to R3, R7 to 10 is held sufficient. ಇನ್ಯಾರಿಗೆ ಆಗ್ಬೇಕು?
ಇನ್ನೆಲ್ಲರಿಗೂ ಆಗಿದೆ. R4 ಗೆ with respect to, she is not
Non taking
contesting my
steps in
claim.
respect of R6 and R10, what do you want?
R6 is dead. His LRs already brought on record in trial court, but they have also been placed expert. They are not contesting.
No, now you want to dispense the
Yes,
notice.
I want to dispense. I do not.
Give that memo. Learned counsel for the petitioner has filed a memo seeking dispensation of notice to
R4 and
R4 and R6. Yes, memo is
My
taken on record, notice to so and so is dispensed. Yes, what is this matter?
My lord, the suit is one for declaration of title with respect to 2 acres 26.5 guntas in survey number 27/1A. Page number 24 schedule.
Page number
24.
Then
Land bearing survey number 27/1A, totally measuring 5 acres 13 guntas. In fact, it ought to have been land bearing survey number 27, measuring 5 acres 13 guntas. 1A ಅನ್ನೋದು ತಪ್ಪಾಗ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲಿ. Out of which plaintiff's share 2 acres 26.5 guntas in survey number 27A. So the larger extent is
Measuring
27.
1A, totally measuring 5 acres, 13 guntas,
Please, madam.
out of which plaintiff share is
2 acre 26.5 guntas.
Huh.
That ought to have been mentioned as 2 acre 26.5 guntas in 27/1A. The larger extent in line number 1 ought to have been just 27. That is the only correction that I am seeking for.
See, out of which plaintiff share is 2 acres 26 guntas andre, it is under 27/1A antane artha.
Ade 27/1A la I'm seeking to rectify 27/1A as 27. The plaint governments also say that in the plaint it is properly mentioned.
It is not 27/1A.
No. 27 is 1 by is the 2 acre 26.5 guntas. The larger extent is 5 acre 13 guntas. In the larger extent.
See, in land bearing survey number 27, totally measuring 5 acres 13 guntas, out of which plaintiff share is ಅದರಲ್ಲಿ ನಿಮಗೆ ಒಂದು ಸರ್ವೆ ನಂಬರ್ ಬೈಫರ್ಕೇಶನ್ ಮಾಡಿದ್ರೆ you need not say out of which meter. You can directly say on 27/1A he is entitled for 2 acres 26 meters. Why you have
ಅಷ್ಟು ಮಾಡಬಹುದು.
that should have been your amendment.
That should have ಅವರು ಈ ತರ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. Amendment application is page number 33. Plaint ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
Plaint ಎಲ್ಲ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Plaint ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. May I take your lordships to plaint page number 21. Last line ಅಲ್ಲಿ survey number 27/1 measuring 5 acre 13 guntas last line.
27/1 measuring 5 acres
13 guntas. So larger extent is 27/1.
ನಿಮ್ದು ಎಷ್ಟು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದೀರಾ?
Out of which ಅದು ನಮ್ದು ಎಲ್ಲಿ ಅಂತ page number 22 paragraph number 3 ಒಂದು 6 lines ಆದ್ಮೇಲೆ RTC, the plaintiffs were in possession and enjoyment of 2 acre 26.5 guntas by dividing orally in survey number 27/1A. ಕೆಳಗಡೆ page number, paragraph number 3 after 6 to 8 lines.
Yes. Now that why the trial court has rejected, what is that objection filed by the?
Objection filed is that it has not been filed at the proper stage. When the matter was set down for arguments, in fact, this was filed. That was when it was noticed.
Where is that trial court order?
Trial court order is at operative portion is at page number 41.
What is the reasoning given?
Reason is given is that in despite due diligence, the plaintiff has not chosen to amend the said mistake within proper time.
Already completed that matter set down for the argument at the fag end of the litigation. Plaintiff has come up with this application. Conduct of the plaintiff, the plaintiff has not filed that application due diligence. Now that what is the stage now?
Say arguments.
Illen stay agide alli.
Stay agilla. That is the reason 2021 it was filed and defendant number 6 died in the meanwhile. So to bring his records, LRs on.
Now that will permit it to amend, but the evidence will not.
No, I don't want to go lead any evidence
because that doesn't.
Yes. Since it is only a typographical error, I will not lead any evidence. It may go, matter may go on.
This petition is filed by plaintiff number 12. Who has filed this? Plaintiff number 12? 1 to 9, 10.
1 to plaintiff, 1 to 6.
No, 1 to 12. Filed by plaintiff number 1 to 12.
Petitioner 1 to 12, plaintiffs 1 to 6.
Plaintiff number 1 to 6.
1 to 6, petitioner 1 to 12. Totally 12 persons have filed. Before the trial court, their rank is plaintiff number 1 to 6.
Yes, plaintiff number 1 to 6 has filed this petition under Article 227 of Constitution of India, challenging order dated 3rd February 2022, passed by 5th Additional Civil Judge JMFC, Tumkur, in OS number 199 of 2012, whereby IA filed by that plaintiff under Order 6, Rule 17 for amendment of the plaint has been rejected. Plaintiff has filed a suit for
declaration of title and injunction.
Declaration of title and injunction. When the matter is posted for argument, it was noticed that when posted for argument, the plaintiff has filed an above application for amendment of suit scheduled property on the ground that by oversight, by typographical error, instead of, where is that your amendment?
Amendment application at page number 33, annexure C.
33,
Annexure C.
instead of survey numbers 27-1, it has been mentioned as 27-1A. The learned counsel appearing for the petitioner has contended that the petitioners undertake that they will not adduce any other evidence on amendment. Only he requires to correct this line. Since there was a typographical error. The respondent has been served unrepresented. In view of the above, the writ petition required to be allowed. Accordingly, writ petition is allowed, order dated so and so is set aside. The application filed by the fifth plaintiff under order 6, rule 17 of CPC is allowed, and it is made clear that petitioner shall not be allowed to produce any further evidence. Yes.
Bill number 30, PM Siddamalappa.
Yes, furnishing a PF, 2 weeks time is granted to do the needful.
Bill number 31, Ganapati Subbaraya Bhatt.
Steps to be taken R3. 2 weeks to take necessary steps in respect of deceased R3.
Yes, my lord. Bill number 32, Rupesha B.
Rectification of office objection raised on IA 1 of 24. Where is that other side?
ನಮ್ದಲ್ಲಿ ಅವರು
Yes, none appear for the respondent. Leaves this matter after 2 weeks.
ಎಂಟ್ರಿ
Interim order granted earlier is extended till next date of hearing.
Bill number 33, Lokesh R.
Yes, rectification of IA filed under.
That copy has been served on that.
Okay, I have no objection. Amendment application may be allowed.
What is that amendment they have sought for?
My lord, one order which was supposed to be challenged was left out.
Or that last.
Consequential
madam.
order
Yes,
and preliminary order.
Yes, IA 1 of 2025 is filed for amendment of writ petition. The respondent has no objection to allow that application. For the reasons stated in that accompanying affidavit, IA is allowed. The petitioner is permitted to file amended petition.
Yes, madam.
Yes.
A very short matter, any day for final arguments
Yes.
or hearing on IA.
When will you do it, Mr.?
My lord,
We'll have it on,
Ivatte I am ready,
the application ಹಾಕ್ಬೇಕು. Have it on 4th.
maybe 4th. yes.
4th, yes. In the meantime, you have to.
Yes,
file.
ma'am.
Bill number 34,
Lords,
Ajit
leave, lords.
Shetty
I'm
for
sorry,
petitioner.
lords, 32 lords, I was just outside, lords.
Yes, it's.
It's a small matter, lords, where,
No, pass it over, pass over. Yes, we'll see.
but then,
Pass over, that will pass over, Mister.
ಸೋಮವಾರ ಹಾಕೊಳ್ಳಿ ಬೇಕಾದ್ರೆ ಸೋಮವಾರ ಮಂಗಳವಾರ ಹಾಕೊಳ್ಳಿ
Monday,
ಆಗ್ಬೋದು.
Monday ಆಗಲ್ಲ, Tuesday ಅದು.
ಟಿಲ್ ದೆನ್
None appear ಅಲ್ಲ,
ಹಾ, sir.
please this matter on Tuesday. Court of Survey, ಹೇಳಿ ಅದು ಯಾರು?
Small
Interim order
impleading
granted
application,
appear.
ಅದೇನ್ ಜಾಸ್ತಿ complication.
You are not there at stage,
sorry.
you end. At least your request has been considered and date has been given.
ಹೌದಾ? I'm sorry, please.
Yes.
Tuesday, it
Number
will.
34,
Middle of that proceedings, see.
I'm sorry.
At least you have to go through that list. I can't pass over, wait and all. It's whoever there, take a chance, argue.
Tuesday.
Yes.
ಟಿ ಐ ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್
33 interim order, if any is extended.
32 ನಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ
32, yes.
Bill number 34, Ajit Shetty.
I appear for respondent.
Yes.
It's a case where, my lords, they don't take steps for 1 year. Last date of
Is there any interim order?
interim orders is there.
Will not extend interim order, that's all.
Now, my lords, they have not amended the cost height.
Interim order granted earlier is extended till next date of hearing. Will is this matter? Learned counsel for petitioner through the video conference submitted that file memo registry today stating that respondent so and so. Mention the counsel appearing for the petition. And the cost title and file an amended cost title.
Last date of hearing, my lords, it was posted today with the understanding that it will be taken up.
Yes, serial number
34, sir.
34. Learned counsel for the respondent has made a serious objection that in spite of granting sufficient opportunity, the petitioner has not amended the cast title and he was not present when the case is called and objected for extension of interim order. Yes. Please this matter. None appear for the petition. Hence, please this matter after 2 weeks.
Please, my lord.
Yes.
Serial number
Trial
35.
court may be directed to proceed, my lords, because,
Let us see one time.
please,
Next time,
Then
you
the
go
date
and
may-
say that there is no interim order.
please,
If they are not proceeded, then we'll see.
date may be given, my lord. sir.
2 weeks.
ಅಂದ್ರೆ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಅಲ್ಲಿ ಏನು ಮಾಡೋದಿಲ್ಲ.
Now you show this order.
Please.
Yes.
Serial number 35, Vinod Reddy V.
Lord, I appear for the petitioners. The office objection is that, my lord,
Hmm.
in view of the section 96 of CPC, my lord,
What is that maintainability, mister?
that is, my lord, that is the office objection right there. In
Hmm,
view of
what is-
section 96 of CPC,
Huh?
in view of section 96 of CPC, my lord, this petition is not
What is
maintainable
that order you are
and you
challenging?
should file an appeal anta office has been raised an objection.
What is that order?
The
you are-
order as I challenged is that, my lord, the suit which I have filed in PNDC, my lord.
Hmm.
PNDC subsequently, their respondents have filed the objections and it was been converted to the suit.
Hmm.
After conversion, my lord, the court has directed us to pay the court fee, in view of the conversion, my lord.
Hmm.
After that, I calculated and I paid the court fee also.
Hmm.
Subsequently, my lord, at the stage of framing the issues, the court,
No, it is dismissed.
yes, my lord, come to a conclusion saying that it is not maintainable until that has been dismissed.
Hmm.
And there is no decree. This is an order passed.
See, once it is dismissed, then there is no petition is maintainable under 227 because only pendency of the suits, if there is any interlocutory order has been passed, that can be challenged under 27.
But
What is that next remedy? You have to find out that.
Then here, my lord, there is no decree also.
Hmm,
Only
if-
on the ground that
If
it is
any
not maintainable.
order passed, rejection of your suit filed under which?
Suit is for
provision?
PNDC, my lord, grant of probate and succession.
You see that under act. If I against the final order, what is the remedy?
Final order, it is an appeal, my lord.
Then you have to file an appeal only. This is final order.
But here, then the office has raised, in view of section 96, appeal should be filed.
See, before me, it is not maintainable.
Yes, ma'am.
It is not an order on interlocutory application, pendency of the suit. If any order passed, termination of that entire proceedings,
yes.
it's an appeal, no, 227 is maintainable. You see that
Then-
full bench judgment.
Permit us to withdraw this and liberty may be granted to file an appeal, my lord.
No, competent court I will give, whichever the competent court you go. Yes, learned counsel for
My
the,
lord, another, the time wasted here, limitation may be, section 14 may be at least.
yes, that you have to file application.
I will
There
file.
you have to be explained. Yes.
Okay.
Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this writ petition. Office has raised an objection regarding maintainability. Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this writ petition with liberty to challenge that impugn order before appropriate legal forum.
Section 14 may be mentioned, my lord.
Has withdrawn. Liberty is reserved to approach appropriate legal forum. Yes.
Section 14 may be
File
mentioned.
in your
I
application.
will file it, my lord.
There you have to be sick. Here I cannot give that permission. Yes. You
Serial
have to
number
explain that
36,
this was pending here.
Ravi Shankar S for petitioner.
Appear for
FP Hegde, government
petitioner.
advocate.
Number 1 and 2, I have not received the copy of writ petition. Wakalat, I will furnish, my lord.
Yes, you,
I will furnish.
yes. Learned counsel for the, you, I will not pass order, you give that copy.
I will not, no, he is my friend.
Leave
no.
this matter next week.
Serial number 37, Ravi Shankar S.
Your lordship may kindly give 1 week time. I will take the steps for second time.
Second matter, week
Ah.
time is granted to do the needful.
File
Serial number
operation.
38 urgent, serial number 39, Hanumant Rai D.
Yes.
Your lordship, have it on Wednesday, my lords. I will file my objection to vacating stay, my lords.
ಅಲ್ಲ ಫಸ್ಟ್ ಪ್ರೋಸೆಸ್ ಕೊಡ್ಬೇಕು ಅದು ಹೋಗಿ ಬರ್ಬೇಕು
ಕೊಟ್ಟಿದ್ದೀವಿ,
ಆರ್ಡರ್ ಒನ್
ಕೊಟ್ಟಿದ್ದೀವಿ.
ರೂಲ್ 10
ಕೊಟ್ಟಿದ್ದೀವಿ sir.
ಆರ್ಡರ್ ಒನ್ ರೂಲ್
Process
10
ಕೊಟ್ಟಿದ್ದೀವಿ
ಹಾಕಿದ್ದಾರೆ
sir. ಕೊಟ್ಟಿದೆ,
ಟು
ಕೊಟ್ಟಿದೆ.
ಇಂಪ್ಲೀಡ್ ದಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸಸ್
ಕೊಟ್ಟಿದೆ ಸ್ವಾಮಿ.
ಸರ್ವಿಸ್ ಆಗ್ಬೇಕು
Process ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
Now that again it is come first time, we have not paid the process, mister.
Yesterday we paid the,
Yes, learned counsel for the petitioner submits that Needful has been done. Office to verify and proceed further.
And interim order, my lords.
Interim order granted earlier is extended till next date of.
Serial number 40. Chitra Nirmala P.
Please, my lords.
Hmm.
My lords, there are three office objections.
Hmm.
The first one was twice the prayer was mentioned. I've deleted that and filed
Now, what's
separate
the
IA.
maintainability, madam?
My lord, it is the commercial court has proceeded against the properties that have been placed under SARFAESI action, my lord. Actually, the petitioner has challenged the possession of the bank, which has been taken under SARFAESI Act, my lord. That was the initial stage, my lord. And there he had sought for an interim order on 13/3, my lords. On the same date, simultaneously, he filed a writ petition over here and two interim orders he has obtained, my lord. Here one interim order and
No,
there
I
one
am on
interim
that.
order.
Which is the order you are challenging, whether it is maintainable or not.
Yes, my
Don't
lord, it is 13th, on 13th March 2023, the commercial.
The order you are challenged, you tell me, then I will see. Yes, you can.
My lord,
file
they
your
have.
merit later. First, what
Yes,
is-
my lord.
Which is
The-
that order you are challenging?
My lord, it is in page number 13, my lord.
1-3.
1/3, my lords.
What is that 1-3?
1/3, my lord. The relevant page is in page number 30, my lords.
What is that order you are
My
challenging?
lord, in this order, the commercial court has directed us not to proceed with the SARFAESI. And if you see in the last line, my lord.
Wait, madam, nane note tinbidi. What is that order dated? Yav order, right?
The application.
Priorly, yav order, where is your relief sought is that 13/3/2024?
Yes, my lord.
Which is that 13/3/2024?
13/3/2024, it is in page number 13. Order particular part is in page number 30, my lord, 30.
What is that IA filed under which provision?
They have, it has been filed, my lord, for stay of the proceedings, my lord.
Order
Under
39.
39, my lord, rule 1 and 2. The application had been filed to stay the proceedings, my lords. And the commercial court has stayed the SARFAESI proceedings, my lords, and also not to disturb with the possession.
Against that, the appeal is provided.
My lord,
Order passed under 39(1) and 2, I think you have to file an appeal.
but my lord, it has crossed its jurisdiction, my lord, under section
No.
34, my lord.
All that has to be considered in that appeal. Therefore, office has raised. Order passed under 39(1) and 2, appeal has to be filed. Even that appeal also, it has to be go before that commercial court. It is constituted in that high court also. It is not then writ. That is what that office objection.
My lord, but particularly we are challenging the jurisdiction of the commercial court to deal with the SARFAESI matters, my
All
lords.
that you can challenge only filing an appeal. There you have to say order is passed by the court without jurisdiction. It is not maintainable, not before this court. Against 39(1) and 2, you have to file an appeal. Therefore, office has raised this thing under section 13(1)(a) of the Commercial Court Act.
Sir.
Any person aggrieved by the judgment order of the commercial court below that level of the district court may appeal to that commercial appellate court within the period of 60 days. You see that?
Yes, my lords. My lords, but in our prayer, my lords, we have also challenged one more order, my lords. And that order, my lords, I have the certified copy. It is an order passed under section 151 of CPC, my lords.
No, here you are challenging that order passed under 39(1) and 2. You go before that. If you challenge that, you file in a separate petition, that we'll see. Yes, here you see that your prayer. Your prayer is only order passed on 13/3/2021 under order 39 rule 1 and 2.
Yes, my lords, but the lordships may also kindly see, we have mentioned about the next order, my lord, which was passed on 10th September.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು petition ಹಾಕ್ರಿ. ಇದ್ರಲ್ಲಿ ಇರೋದು ಈ order challenge ಮಾಡಿದ್ರೆ it is not maintainable. Yes.
My lord, liberty may be granted for me to file an appeal.
Yes, office has raised an objection regarding the maintainability. Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this writ petition with liberty to approach appropriate legal forum.
My lord, the limitation period which I have spent here may also.
Nothing will come if you want file an appeal, madam.
I will do so, my lords, but your lordships may.
There you have to ask for that, madam. Delay application if there is any delay. Yes, liberty is reserved to file an memo is taken on record. The above writ petition is dismissed as withdrawn with liberty to approach appropriate legal forum. Yes.
Serial number 41, Rahul Gadigappa.
Yes.
Respondent number 20 has unclaimed, my lord.
Non-furnishing of PF.
With respect to respondent number 1, my lord, respondent number 1 is dead, my lord. I am filing memo, my lord. LRs of respondent number 1 are already on record, my lord.
Now, what you say about that process in respect of R20? Respondent number 20 ಗೆ ಏನ್ ಮಾಡ್ತೀರಿ process?
Claim ಮಾಡಿದ್ರೆ ಮತ್ತೆ pay ಮಾಡ್ತೀನಿ sir.
ಬಂದಿದ್ಯಾ? ಎಲ್ಲಿದೆ? Where is that unclaimed? Yes, notice issued to that respondent number 20, written with postal share unclaimed. Service of notice to R20 is held sufficient. IA1 of 2024 for correction of the order, ಏನ್ರಿ ಇದು?
Please, my lord, in this case, my lord, the entire proceedings has been stayed, my lord. I sought for the stay of the order passed by the trial court, my lord. ಅದಕ್ಕೆ correction ಹಾಕಿದ್ದೀನಿ sir.
ಎಲ್ಲ ಆರ್ಡರ್ ಆಗಿದೆ stay of?
Stay of entire proceedings, my lord, dated 25/4/2024, my lord.
Till next date of hearing.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, I am the plaintiff, my lord. I have filed suit for specific performance. ನಾನೀಗ injunction application file ಮಾಡಬೇಕು. Apprehension ಮೇಲೆ ಮಾಡೋದು, defendants may
So what is that order you are challenging?
My lord, I challenged the, my lord, trial court impounded the document and directed me to pay due time penalty, my lord. My lord,
Without paying the penalty, how you permitted to proceed the suit, mister?
please, my lord, matter is covered by judgment, my lord, of this honorable court, my lord.
You service complete, you will hear that.
With respect to R1, my lord, the LRs are
That
already on record.
no non-taking steps in respect of R1.
Please, my lord, I have filed memo, my lord. Legal rights of respondent number 1 are already on record, my lord.
Who are that?
My lord, respondent number 2, 5, 8, 12, 17 and 19, my lord.
Who is that respondent number?
ಅವ್ರ ಮಕ್ಕಳು ಸ್ವಾಮಿ ಎಲ್ಲಾರು.
ಅಲ್ಲ ಯಾರು ಸತ್ತೋಗಿರೋದ್ರಿ?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ತೀರೋಗಿರೋ ಸ್ವಾಮಿ.
ಸಣ್ಣಮ್ಮ.
ಸಣ್ಣಮ್ಮ ತೀರೋಗಿರೋ.
ಯಾರ್ಯಾರು ಎಲ್ಲಾರ್ಸು?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2, 5, 8, 12, 17 and 19, my lord.
17 and 19.
Please, my lord.
ನೀವ್ ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಿ?
R21.
Yes. ಮೆಮೊ ಹಾಕಿದೀರಾ?
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
Yes. Learned counsel for the petitioner has filed a memo stating that respondent number 1 is dead, leaving behind respondent number 2, 5, 8, 12, ಮತ್ತೆ
17 and 19, my lord.
12, 17 and 18.
19
are the LRs of deceased respondent number 1. The memo filed by the petitioner is taken on record. Respondent number 2, 5, 8, 12, 17 and 19 are treated as LRs of respondent number 1. Learned counsel for the petitioner is permitted to amend the cause title. IA1 of 2022 is dismissed as not pressed. Now that, what is that order you are challenging?
My lord,
ಮತ್ತೆಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಏನು, what is that order you are challenging?
Annexure K, my lord.
What is that annexure?
Is at page 94, my lord. Orders on stamp duty, my lord. My lord, documents are of the year, my lord, 2014-19, my lord. My lord, this honorable court, my lord, in Anil versus Babu, my lord, has held that
Patra, right of the parties over the properties were relinquished, hence plaintiff shall pay the duty of the, as per the so and so 5%. What is that order of this court?
My lord, this court, my lord, has held that after 5 years, my lord, documents cannot be impounded. After
5 years from what?
From the date of execution of the document, my lord.
As you have you seen this, mister? ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಕಾಪಿ ಕೊಡಿ. Yes, since matter is involved in respect of stamp duty, government advocate is directed to take notice. Office is directed to show the name of government advocate in the cost list. You go through and make submission.
Please.
Yes. When will you come back?
Next week also.
Yes, leave this matter on 4th.
4th bed also. 5th, my lord, 5th or 6th.
5th, yes. 5th.
Please.
Our government advocate ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Please.
Yes, because
interim order may be interim order
granted earlier is extended till next date of hearing.
Cell number 42 adjourned. Cell number 43. Yes, Raju for petitioner connected matter Ambaji Rao Nadzre.
43. Rectification of office objection raised on IA1 of 2024. Who has filed this IA?
I have filed this application, my lord.
IA filed by the
Production of documents ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ದು?
respondent. ನಮ್ಮ ಕಾಪಿ ಸೆಲೆಕ್ಟ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, weeks time will be granted. Council on record is not in.
What is that production of documents? You can file it here, mister.
ಹೌದು, ನಮ್ದು. Respondent ಏನೋ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
You want time?
Please 1 week time.
Yes.
Yeah.
They want, yes, at the request of council for the respondent number
1 to 6.
1 to 6. Leaves this matter after 2 weeks.
Up to 2 weeks.
Uh,
Interim order may be extended.
Interim order granted earlier is extended till next date of hearing. In the meantime, we pay the process, mister.
No, please.
Yes.
Bill number 44, Venugopal MS.
Interim
Yes.
order may be extended.
Yes, interim order granted earlier is extended. Yes, mister.
Lord's office objection is, my lords, cost title in the trial court does not tally with the cost title in the writ petition.
Council submission. The
Lords,
council
what happened is,
List
my
of the
lord,
petitioner
original
to be
plaintiff died.
clarified with OS number. List of the petitioners to be clarified with OS number ಅಂದ್ರೆ
Must
ಏನು?
be rank, ಅದು rank ಅಂತ rank ಇರಬೇಕು.
Rank ಇರ್ಬೇಕಂದ್ರೆ rank of the petitioner to be
Original
clarified.
plaintiff died. My lords, before the trial court 22 rule 3 application is filed, it is yet to be decided. Therefore, plaint does not contain the name of the petitioner.
LRs has been made as a party. That is the only office.
It is the only.
Yes. Now that, when do you want?
My lords,
In
I
order-
have sought only return of the plaint under order 7 rule 10.
Hmm.
IA ಇನ್ನೂ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ 1 ವರ್ಷದಿಂದ. So
You want to directions.
direction to the trial court ಅಷ್ಟೇ.
Submission of learned counsel for the petitioner is accepted. Office objection is overruled. Suit for
ejectment, my lords.
you are the.
I am the plaintiff.
Hmm.
What happened is it was filed before the vacation court, my lords. After making over to the regular court, it went to the junior division,
Hmm.
which has no jurisdiction because annual rent is above 3 lakh.
Now you want to return of the.
Return of the plaint to present it in the senior division.
Why it is,
My lords, trial court has not considered my memo. Then
what
I filed a miscellaneous petition before the district court to transfer this to the concerned court. That miscellaneous petition is rejected, stating that I may file under 7 rule 10 for return of the plaint. Then I moved under order 7 rule 10. My lords, it is filed, my lords, on in 2023. For one or the other reason, that application is not considered.
Where is that order? Now what is that process in that suit? Counsel
Please,
plaintiff is.
I
also
have
filed
produced
along
the
with-
order sheet, my lords, page 75.
ಆಯ್ತ್ರಿ, ನೀವು ರಿಟರ್ನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆದ್ಮೇಲೆ ಏನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗ್ತಾ ಇದೆ court ಅಲ್ಲಿ?
ಹಾಕಿದ್ದೇನೆ, page 75.
ಏನ್ ಆಗ್ತಾ ಇದೆ ನಾವು?
ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಒಂದು ಆರ್ ದಿ ಅದರ್ ರೀಸನ್ ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಅದು ಇದು ಅಂತ ಹೋಗ್ತಾ ಇದೆ. Since that court has no jurisdiction, my lords, whatever the further proceedings takes place, that
Now first they have to decide that
please,
application.
that is
Yes.
what I am. 8/8/2023, my lords, application is filed.
Listen. The petitioner plaintiff sought for mandamus, sought for a direction to the trial court to dispose of IA number 7 filed by the petitioner plaintiff under order 7 rule 10 of CPC in OS number 498 of 2020-21. In view of the above, service of notice to respondent is not necessary. The plaintiff has filed a suit for
Possession, ejectment.
for possession before
Before, my lords, it was before vacation court, it was filed.
possession.
Bangalore rural.
It was filed before vacation court, Bangalore rule.
Please,
ಅಲ್ಲ, ಯಾರು vacation court ಆದ್ರೆ ಕೋರ್ಟ್ ಯಾವ್ದ್ರಿ?
please, my lords, I will point out. Page 63, my lords, vacation court, Bangalore rural, Bangalore ಅಂತ ಅಷ್ಟೇ ಇದೆ.
60?
63.
ಆಯ್ತು, ಡೆಸಿಗ್ನೇಷನ್ ಏನು?
ಇಲ್ಲ, vacation judge ಅಂತಾನೆ ಇರ್ತದೆ.
Before that vacation court.
Vacation judge, 64 ಅಲ್ಲಿ ಇದೆ.
Yes. Thereafter,
It was made over, next page, 65.
it was been made over to
First additional civil judge.
Bangalore Rural District, Bangalore. Thereafter, petitioner has filed this application, IA number 7, under order 7, rule 10 of CPC for return of plaint.
Please.
Since that application is not filed an application when, Mister?
8/8/23, my lords.
8/8/23. Till today, that application is not disposed of, therefore petitioner is before this court seeking a direction to early disposal of that application. In view of the above, without expressing any opinion on the merit of the case, the first additional civil judge Bangalore is directed to dispose of that IA number 7 filed by the petitioner under Order 7, Rule 10 of CPC in OS number 498 of 2011, 2021, in accordance with law, as expeditiously as possible, not later than 3 months from date of receipt of.
1 month, my lords. It is only-
Copy bandu or other side then objection. Yes.
Till number 45.
Other side has not objected that.
Yes.
Suresh K.
40? Yes. Non-compliance of the office objection, counsel. Weeks time is granted to comply officer.
Till number 46. Yes, Venkateshwaran.
Hearing for the respondent KV terminal.
Yes. Non-compliance of the office objection, none appear for the petitioner. 2 weeks time is granted to comply office objection.
Till number 47. Narasimhamurthy K.
Lord, sir, the order passed by this court on 12/12/2024 has not been complied. They are not deposited the rent still today. Lord, no, my lord, sir.
Offered 8 lakh.
I will come one by one.
Yes, please, my
Now
lord.
that, what is that office objection?
Office
That's-
objection is that, my lord, I had to pay the arrears of rent. That
Rent.
was the order passed by this honorable
Like
court.
three office objection.
My lord, out of that, my lord, I am paying now 8 lakhs.
Non-compliance of order dated. Yes, what is that order, Mister?
My lord, order is that, my lord, I have been directed to pay the arrears of rent, my lord.
Yes, as per that order dated 12, learned counsel for the petitioner undertake that petitioner would deposit the entire arrears of rent as per the order of trial court on 22 to within the period of 15 days. Has made it clear that if the undertaken is not complied, free order granted by the cell stand vacation. Till today petitioner has not complied with that. Require 10 days time to comply this order. Finally, time is granted 15/1/20 to comply with that order dated, in which the interim order granted so also. What is that you have to pay? How much amount, Mr.
My lord, sir.
My lord,
The-
my
my lord,
lord, he has
That I
not.
will say, that I will say, my lords, that I will say, my lords. ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ನಾನು ಹೇಳ್ತೀನಿ, that I will say. My lords,
ಇವಾಗ
the
ಅವ್ರು
trial
ಯಾರು
court has,
protection ಕೊಡ್ತಾ ಇಲ್ಲ.
no, the trial court has ordered, my lords, there is order sheet. The trial court has ordered that from February 2022 till date, they have to pay arrears of rent at 99,000 rupees per month.
Now, what is that this court has granted an order?
My lords, this court has said the entire arrears of rent. It is admitted debt, my lords, that the
Wait. 12/12. As is Sanjay, the learned counsel undertake to accept the notice for respondent. G.R. Chandrasekhar, learned counsel for the petitioner submitted that petitioner would deposit the rent as per that order passed by the trial court within a period of 15 days. Now, what is that order of the trial court?
my lords, trial court order I have produced before this court, my lords.
Where is that?
Last occasion I read out, my lords.
Yes.
Order on IA number 1 is hereby directed defendant deposit remaining balance of arrears of,
ಕೊಟ್ಟಿದ್ದೀರಾ?
lords, this
Object
order
of
is,
hearing is-
this order is on 22nd April 2024. I had produced one order, my lords,
Order on IA 1.
order on IA number 1. My lords, I have a printout. That's the operating portion.
IA 1 is filed by that plaintiff is hereby allowed. Consequently, this court directed the defendant to deposit the remaining balance arrears of rent 2,12,000 within 2 months from so and so. 2,12,000.
Further, my lords.
And further defendant is directed to deposit that admitted rent of 99,000 per month regularly with effect from due from that February 2022 to till today, how much, Mister?
35 lakhs, 65,000.
Yes.
Because, my lords, from February 22 to 23, 11 months.
ಈಗ ಎಷ್ಟು
from-
ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು?
ಅವ್ರು ಏನು ಕೊಟ್ಟಿಲ್ಲ. And the last occasion, my lords, let me finish, my lords. Last occasion, my lords, they have filed some memo saying that they have deposited rents. I have clear statements. I
This
have,
court order is clear. As per the order of this court, trial court, he has to deposit entire amount.
please, my
If it
lords.
is not deposited, interim order will be okay.
I have now offering 8 lakh rupees in the.
I will,
of the
I-
first
No,
respondent.
see, this is
And
the,
it is already paid, my lord, 10 lakh rupees has been
No.
deposited.
see, this court said, in terms of that order, you have to deposit entire amount.
That is
99
correct, my lord.
lakhs.
My lord, may I make one submission?
He's not allowing me to carry on. This is a manufacturing. unit.
No, I am not concerned this, Mr.
When
There is an
so
order.
Unless I carry on the business, I
No,
manufacture.
is it your case that before earlier bench, you have come before the court, admitted that I will pay it, take an interim
Correct, my
order?
lord. Now I am saying, my lord, I'm.
No, you go and say before the same court, mister. You don't dare. Why you have not said on that day? I am not allowed to carry out, therefore I am not paying. On that day you have accepted, take an interim order.
Even now, my lord, I am bound by that. My lord, why only I am making.
You are bound by, I am bound by that earlier order passed by this court, mister.
That is correct, my lord. I am not saying no.
No,
my
I will
lord.
dismiss
Now
it.
I am offering, my lord, I am offering, my lord, I am not against the order on IA1. I am not on the order on IA5. IA5 before this.
No,
order.
can you read what is the order passed by this court on 27/11/24?
My lord, I am aware of that, my lord. May concern.
Then you have to comply that.
My lord, I will comply that, my lord, with installment, my lord. I am now offering
Court
8
has
lakh
not-
rupees, my lord.
Court
I
has
already-
not granted any installment, mister.
My lord, I already deposited 10 lakhs.
That is false, my lords. That is totally false, my lords.
Yes.
That is not.
They have not
false. If you
deposited
take
any
the
amount, my lords.
Sheet of the trial court, you will come to know. You are not.
Yes.
Yes.
Unless you get it modified, that order passed by this court on 12/12/2024, you have to be compliant. It is not that by changing a bench, judge
But I'm
has to
not-
change
but
that
I-
order.
My lord, I am not going beyond the order of 12/12/2024. My lord, I am now offering 8 lakh rupees.
No, there is a due of 35 lakhs.
Please, my lord.
Sir, 35 lakhs already deposited, 10 lakhs, my lord. Last time I filed a memo to that effect.
Lords, I have
filed a
statements to
memo
show that
effect.
whatever they say
My
is
lord,
bogus.
that is the
I have
order
not
of the-
received a
that is
single
order sheet
statement.
of the trial court.
Lords, let me make a submission.
I'm not hearing that, mister. You comply it, pay that, and then you.
My lord, I am now offering 8 lakh rupees.
No, now
my lord.
Allah, you have to deposit the entire amount, mister.
My lord, I will deposit, my lord.
No,
I
there
will
is
not
no
say
time
no.
is granted, mister.
Unless, my lord, he may, my lord, I am paying now 8 lakh rupees. Part of it, that amounts to 18 lakh rupees. Another 70, I will pay it, my lord. I will not say no to that.
No, 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 no. You can say that I will pay it 12
I will
years.
pay, my lord.
You are
I'm
not
not
saying no, I will pay it. That is not that tenor of that order, mister.
Lords,
My lord,
they
I
have
know
submitted
what
a
they-
false statement, my lords. They have submitted a false statement before this court. I have, I have,
Say, my lord,
Well,
what
let
is
me
false?
finish.
No, I am not on that, mister. There is clear order of this court. There is no extension of interim order. You go and get it clarified. Yes.
My lord, let the
As per
master,
that order
my lord,
dated.
you, lordship may kindly direct him to accept the same.
No, I will not accept it, my lords. I will not accept it, my lords.
That is for, see, if you deposit the entire amount, I will extend. Otherwise, this court by order dated 12/12/2024 as undertaken by the petitioner, counsel for the petitioner, that he will pay. I will deposit the rent as per the order passed by the trial court dated 22/4/2021 within period of 15 days. If the petitioner, if that petitioner is not complied, undertaken, the interim order granted stand vacated. Since he has not paid that entire amount as per that order dated 22/4/2024, in view of the order dated 12/12/2024, the interim order is vacated.
Grateful, my lords.
Yes.
My lord, it may posted for B group, my lord.
Yes, leave this matter in B group. Yes.
B group, date.
Yes, on 11th. Yes.
11/2, my lord.
Yes.
Cell number 48, Sriram Timappa.
Respondent number 1. Yes, I am appearing for the petitioner.
Yes.
I have filed one memo on 28/11/24, my lords.
Yes.
I am producing another memo.
Furnishing a PF copy issue notice to the second time for correction of address so on. So what is this, mister?
I'll do that, my lords. I'll do that. It has
Next time
come
is
after the interim order, this has come for the first time. ಏನಾಗಿದೆ ಇದರಲ್ಲಿ ಈವನ್ ಆಫ್ಟರ್ ದ ಆರ್ಡರ್ ಆಫ್ ಸ್ಟೇಟಸ್ ಕೋ ಬಂದಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿ ಹೊಡೆದು ಎಲ್ಲ ಮಾಡಿದ್ದಕ್ಕೆ ನಾನು ಒಂದು 28/11 ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ ಅಲಾಂಗ್ ವಿತ್ ಆಲ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಆಲ್ಸೋ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಹಾಕಿದ್ದು ನಾನು ಎಲ್ಲಾನು ಇವ್ರಿಗೂ ಆಪೋಸಿಟ್ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ. ಈಗ ಮೊನ್ನೆ ಬಂದ್ಬಿಟ್ಟು ಏನ್ CCTV ಕ್ಯಾಮ್ರಾಗಳಿವೆ ಅದನ್ನೇ ಹೊಡೆದಾಕಿದ್ದಾರೆ ಒಳಗೆ. ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಆಲ್ಸೋ ದ FIR ಆಲ್ಸೋ ದಿಸ್ ಟೈಮ್.
Yes.
ದೇ ಆರ್ ನಾಟ್ ಎಟ್ ಆಲ್ ಕಂಪ್ಲೈಂಗ್. ಒಂದು ವಾರ್ನಿಂಗ್ ಆದ್ರೂ ಅವ್ರಿಗೆ ಅಟ್ ಲೀಸ್ಟ್ ಕೊಟ್ರೆ
Yes,
ಬಂದಲ್ಲಿ
please. Where is your application, mister? Where is your application?
Application what?
You have filed an application for
No.
violation.
I am just intimating the court.
You file in a contempt then.
Yes, I'll do that.
You do the contempt. Yes. 2 weeks time is granted to do the needful.
Serial number 49, Udita Ramesh.
Yes.
My lord, I approve to the petitioner, my lord. My lord, office objections, everything has been complied with and only two office objections requires my submission, my lord.
What is that office objection?
My lord, the first office
Parties
objection.
of annexure plaint not made.
Yes, my lord. Parties to the suit, my lord, the other party, people in the plaint were not made parties, my lord, because the suit this current petition, my lord, is for directions regarding 39 rule 1 and 2, my lord. We have only made the plaintiffs who have filed the initial IA as member,
You
parties.
have to make all them as a party, then you can seek for any dispensation, mister.
My lord, because there is no, there's no requirement, my lord. The others are all defendants, my lord. I am also a defendant. The petitioners, we've made the plaintiffs who have filed the IA, we've made them a party.
All the persons who are party in the trial court has to be make as in a party. Is there any rule says that they can be, person who is not interested cannot be made as in a
My
party?
lord, they're not a
Here you
necessary or
can-
a proper party, my lord.
Here you can file an application.
My lord, but then there's no necessity or, because neither are they necessary a proper party, my lord. For that very reason, I didn't make them a party, my lord.
No, that, which is that, within the provision where all the parties in that suit has to be made. Pass over, we'll verify. If that is the rule, then I will dismiss it your petition for not making them party. Yes, pass over.
Serial number 50, answer. CM Nagabhushan.
Petitioner, ma'am. Pray for short and.
On complaints, yes.
Caveat copy ಕೊಟ್ಟಿಲ್ಲ ಅಂತ caveat copy ಕೊಟ್ಟಿ.
I have received the copy, my lord, sir. Short accommodation may.
I am not seeking any interim order, your lordship.
Amendment plaint not filed before the trial court. That is your submission. Amendment plaint. Copy to be served to the court. You are filed, serve and copy.
Yes.
Yes, he wants time, yes. Yes, next week. Yes, at the request of the caveator,
ಒಂದೇ date fix ಮಾಡ್ಬಿಟ್ರಿ.
please this matter on 4th. Yes, mister.
ಅಲ್ಲ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಏನು ಕೇಳಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ನೋಡ್ತಾ
ಇಲ್ಲ ಇಂಟ್ರಿ ಮಾಡಿ ಕೇಳಿಲ್ಲ ನೋಡಿ ನಾವು.
ಇಲ್ಲ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಏನು ಕೇಳಲಿಲ್ಲ.
Now then you take notice.
ಹೌದೇನು?
What is this matter, Mr. Nagesh?
Your lordship will kindly see, myself and the respondent 1 to 3 are the children of Narayan Padiyar. He had a properties. They are squatting on that and realizing the rents. I have made an application for deposit of the rents. And I am not claiming that any share in that rent is to be paid. All the rents realized by them should be deposited. The respondents 8 to 30, 20, 31 are the.
You are appearing for whom?
I am for the respondent number 1 to 3, my lords.
1 to 3, caveator is undertake to appear for respondent number 1 to 3. Issue emergent notice to respondent number 4 to 28. Yes.
Fourth.
Serial number 50, 51, Ashok B. Patil.
Non-rectification of the office objection raised on.
ಅದರಲ್ಲಿ
IA.
that was I number 1 was to be served on the other side. That has been done and they have filed their objections also.
No, that is the only office objection.
That's the only option.
Order.
Answer.
Objection to it. But in this matter, the petitioner is the 6th defendant.
No, office objection and not.
ನಾವು RPD ಕಳಿಸಿದ್ವಿ ಅವ್ರಿಗೆ.
Yes, what is this matter?
Plus the petitioner is the 6th defendant in the suit filed by respondents 1 and 2. But at the stage of the further cross-examination of the petitioner, they file an application for amendment of the plaint.
Suit for?
Suit for partition. And one of the properties was sold by the father and brothers of the plaintiffs way back in the year 2001. And that was also one of the subject matters of the suit. Then that sale was not challenged by them in the suit. But at the stage of cross-examination of the petitioner, they filed this application for amendment of the plaint, which is at annexure L,
H.
118.
Yes. What is that amendment they sought?
Amendment is to add a prayer to declare the sale deed dated 28/5/2001 is not binding on the right of the plaintiffs. And this amendment is filed in 2024.
No, this, you are claiming on the basis of the sale deed.
Now, I am the purchaser from the purchaser under the sale deed.
Yes, from one of the family members.
No, the one of the family members sold it to defendant number 4. I am the purchaser from defendant number 4,
You are the second purchaser.
second purchaser. Now, you lost me kindly see the original plaint. ಅದು ಏನಾಯ್ತು ಅಮೆಂಡೆಡ್ ಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಅವ್ರು ಶೆಡ್ಯೂಲ್ ಹಾಕಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಒರಿಜಿನಲ್ ಪ್ಲೇಂಟ್ ನ ಒಂದು ಮೆಮೋ ಜೊತೆಗೆ ಫೈಲ್ ಮಾಡಿ ಅದು ಐ ಥಿಂಕ್ ಇಟ್ಸ್ ಪಾರ್ಟ್ ಆಫ್ ದ ರೆಕಾರ್ಡ್ ವೇರ್ ದೇ ಮೇಕ್ ಎ ರೆಫರೆನ್ಸ್ ಟು ದಿಸ್ ಏಲಿನೇಷನ್ ಇನ್ ದ ಪ್ಲೇಂಟ್, ಬಟ್ ದೇ ಡೋಂಟ್ ಚಾಲೆಂಜ್ ದಟ್ ವೆನ್ ದ ಸೂಟ್ ವಾಸ್ ಫೈಲ್ಡ್.
What is that reference?
If you lost me kindly take my memo filed on 7/1/2025, the plaint as originally filed by the respondents 1 and 2. It is not that they were not aware of the sale deed. They were aware of the sale deed.
ಆಯ್ತು, ಈಗ what is the stage in the suit?
Nandu further cross examination stage ಅಲ್ಲಿ ಇತ್ತು. In the application, they must make a statement and also establish, despite a due diligence, why they could not seek this prior or amendment before the commencement of the trial. That is not there.
No, now what prejudice will cost if this is allowed?
That after 24 years, this prayer is sought to be brought. The limitation, it runs foul of the Limitation Act.
No, that, is there any bar for challenging that?
Exactly, because 2001 is the sale. It is within their knowledge. They make an averment in the plaint filed in the year 2011. Sorry, 2013.
2013.
13 suit. ಅದರಲ್ಲಿ 2001 ಸೇಲ್ ಡೀಡ್ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಹೇಳ್ತಾರೆ.
There is that. No.
ಪ್ಯಾರಾ 4.
No, your memo.
ಅಲ್ಲ ಮೆಮೊ ಅಲ್ಲ, ಆ ಮೆಮೊನಲ್ಲಿ ದಿ ಪ್ಲೇಂಟ್ ಆಸ್ ಒರಿಜಿನಲಿ ಫೈಲ್ಡ್. Dated, sir. 7/1/2025. May I request your lordships to kindly see the cause title.
ಆಯ್ತು, ಎಲ್ಲಿ pleadings ತೋರ್ಸಿ.
Para 4.
Yes.
The first defendant is also an archer. First defendant is the father of the plaintiffs. Has sufficient means to maintain the family. He is not managing the properties as a prudent man and misusing the joint family properties with an intention to deprive the rights of the plaintiffs. The land bearing survey number 13, measuring 1 acre 31 guntas, is garden land. There is a stone riveted well with a pump set of 5 HP, and the joint family has planted 30 coconut trees. It continued in possession and enjoyment of the plaintiffs and defendants 1 to 3. In the last week of May 2013, the plaintiff came to know, you lost me kindly notice, came to know that the defendants 1 to 3 colluded together and have executed certain documents in favor of the 4th defendant. This is the sale deed. Immediately, the plaintiffs applied for copies of the said documents on 2/5/13 and obtained the same. The plaintiffs surprised to know that the defendants have executed sale deed in favor of 4th defendant. The 4th defendant is a stranger. He is not entitled to joint possession and enjoyment with the plaintiff. The sale deed executed by defendants 1 to 3 do not bind the plaintiffs or in their joint family properties. The plaintiffs each entitled to 1/5
So,
share.
Now that sale deed which they are sought for amendment executed in favor of the 4th defendant
Fourth
or
defendant.
in your favor?
4th defendant, from 4th defendant, I had an agreement to purchase. That purchase, that was prior to the suit. And I filed a suit.
Now that sale deed which they are questioning, which is,
It is in favor of my vendor,
that's your vendor.
my vendor.
Now the issue is, they said
They're aware of
It
the transaction.
is not binding on them.
Not binding ಅಂತಂದ್ರೆ, it is challenging that sale deed.
No, see, in the suit for partition, they can claim that sale deed is not binding on them. There is no limitation will come. There is an, I think, judgment. Somebody has to get that judgment. You have that judgment, mister?
They are aware of this, sale transaction.
No, you know, the question is limitation. Limitation declaring that sale deed is null and void, limitation is applicable. In the suit for partition, I think they can seek that.
Now the Supreme Court has said, in fact, I have that ruling. If they want to, this is nothing but challenging the sale.
No, partition suit ಅಲ್ಲಿ different ಇದೆ. You get
ಇಲ್ಲ,
that?
ಅದು
One of them has to get, see, therefore, court fee is also not required to be paid
ಅದ್ರಲ್ಲಿ
because
ಏನಿದೆ
they are not.
ಅಂತಂದ್ರೆ, now you lost me kindly appreciate, what they will be seeking, partition and separate possession. If it's a question of possession is there, even in respect of a portion of the property,
Mr. Patil, find out in the suit for, you also, Mr., you have that judgment.
I have the judgment today. I have.
Where that limitation is applicable or not in that case.
So far, the amendment is concerned. It
No,
depends
no, no,
upon,
not amendment.
one sir.
Hmm.
Amendment is concerned.
Hmm.
It is depend upon the fact and circumstances of the case.
Hmm.
One is when there is no binding on that one, no limitation at all. So far, the other aspect is concerned. Your lordship, who has challenged the impugned order in this
Mr.
petition?
Leeladhar,
Yes,
it is a question of law.
please.
You are seeking declaration of that sale deed.
Yes, your lordship.
There is a limitation.
Yes.
Whether it is applicable or not that whether amendment is filed, a delay or that stage, Mr.
Please,
You have
please.
to answer that question.
Yes, your, I will furnish judgment. Your lordship. I will furnish
In
judgment.
suit for partition, if you seek any declaration of the sale deed is
Yes,
not binding.
That is
Limitation.
section 54 is applicable, not by,
Judgment ಕೊಡಿ.
but
ನಾನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
I-
ನೀವು-
ಅಲ್ಲ,
I will furnish you.
ಕೊಡ್ತೀವಿ.
I will furnish it to her.
ಈಗ ನಮ್ಗೆ ಸಮಸ್ಯೆ ಏನಾಗ್ತಾ ಇದೆ ಅಂತಂದ್ರೆ, when I filed the writ petition, it was at the stage of my further cross examination.
You
Because
have taken this contention and answered by the trial court. In
Yes, it is answered.
what
ಇಲ್ಲ, it's not answered.
The answer. Your lordship, the impugned order, your lordship, in page number 235, annexure W.
if that limitation is applicable,
No,
then
only
it
one,
is part.
only one submission. What difficulty we are facing now is, when I filed the writ petition, it was at the stage of my further cross examination. Because there was no interim order, the court has closed it and proceeded for final arguments on Monday. Next week ಇಟ್ಕೊಳ್ಳಿ, but stay next date ನಾವು stay ಮಾಡಿ, we'll assist the court on that point.
Next date
raised by-
Now precipitate ಮಾಡೋದು ಮೊನ್ನೆನೇ
ಇಲ್ಲ,
ಹೇಳಿ
ಇಲ್ಲ,
last
ಇವತ್ತು
time.
ಅಲ್ಲಿ ಜಡ್ಜರ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲ, ಇಲ್ಲ.
ಇವ್ರೇನೋ
No,
ಬೇಡ,
sorry.
stay ಇರ್ಲಿ,
I am sorry.
next date ತನಕ stay ಇರ್ಲಿ. ನಾವು ಅದ್ರ mean time will give.
Further proceedings, you only that judgment it is produced, it's end of the.
Yes, your lordship.
See, if you show the judgment even in the partition suit also.
Yes,
limitation,
certainly.
Then
They
if it
can't have
shows
an-
that it is not, then that is the only.
Yes,
Therefore,
certainly.
certainly we will assist the court.
Question of filing an amendment at stage, what is the stage? It is immaterial, but because court can.
It is,
impose
it
the
is,
cost
it
under-
is, I will.
Now,
that.
if the limitation for challenging that is there, then it is bar.
Certainly.
That cannot be allowed.
That will assist.
Partition, it can be, then that is
Yes.
the only point. Yes.
Therefore, kindly, stay this matter till the next
The
day,
next date.
Monday, coming Monday.
Yes, Mr.
We have submitted in the court also, we are not,
ಇಲ್ಲ.
this matter is
ಅಲ್ಲಿ
pending.
ಅಲ್ಲಿ
Matter is pending.
ಅವರು
It is a
judge
voice of the advocate,
Sir,
voice of the advocate.
let it be recorded.
Yes.
Let it be recorded.
Let it be recorded.
Learned counsel
No,
for
no problem.
respondent undertake that he will not precipitate the matter.
Yes, sir.
before the trial court. Yes, when do you want both of them?
One short date put petition.
Yes,
next
read
week
this
I'll-
matter on fifth,
Yes, sir.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ತನ್ನಿ ಅಷ್ಟೇ.
I will furnish it to her.
ನೀವು ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕಾದ್ರೆ ಲಾಯರ್ಗಳು ತಗೋ, ನಾನ್ ಜಡ್ಜ್ ಬಂದು.
ಇಲ್ಲ, ಇಲ್ಲ,
point
ನಾವು
ಇಲ್ಲ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ ಟ್ರಯಲ್ ಶುರು ಆದ್ಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೊಡುದು ಅಂತ
ಅದು ಬೇರೆ.
ಇದ್ದಾರೆ.
ಏ, ಅದು
But
ಪಾಟೀಲ್, that is secondary, that is discretion
No, no,
of the
that is-
court.
that
That
is-
is, see, your point for limitation is a jurisdiction point, that you have to be answered.
very well.
If that limitation is there, then that amendment cannot be allowed at all,
Yes.
whatever may be the stage.
ಅಲ್ಲ ಇದರಲ್ಲಿ
You have to answer that first basic question, then you
Right.
go for the others.
The provisor to Order 6 Rule 17 amended provisionally, it
No,
loses its
ಅದಕ್ಕೆ-
sanctity
You-
if
you-
they can apply at any stage.
No, then you are giving up this contention.
No, I'm.
First you answer, mister,
ಅದು
then I will answer that.
Certain.
Cell number 52, Dore, Raj, BH.
Lords, will appearing for the petitioner, my lords.
Yes,
May not seek for a short accommodation, my lords.
yes, at the request of counsel for the. Why, what is this
Petitioner.
maintainability, mister?
My lords, initially we had filed an RFA, my lords.
Hmm.
And it was, sorry, my lords?
Oh, you want to file an RFA?
No, my lords. We had initially filed an RFA. It was found to be not maintainable under RFA, and therefore we are filing under WP.
Yes, at the request of counsel for the petitioner, leave this matter next week.
Much obliged, lordships.
Cell number 53, Ramesh KR.
48, which is that? What has happened?
Sir, 2 weeks. time.
48 interim order granted earlier is extended till next date of it.
Serial number 53, Ramesh KR.
My lord, in this matter, my lord, I am appearing for the petitioner.
Hmm.
The my lord, office was raised the maintainability in this case. My lord, instead of CRP, my lord, I have filed a writ petition. We are permitted to convert the writ petition, my lord, for instead of CRP.
Yes, learned counsel for the petitioner has filed a memo
Please, my lord.
seeking leave of this court to convert the petition into civil revision petition. Memo is taken on record. The petitioner is permitted to convert this writ petition into civil revision petition.
Yes.
For statistics purpose, writ petition is disclosed.
Serial number 54, Abhishek Marla MK. Wait, sir.
Yes, awaiting service of notice. R1 and R2.
Serial number
Yes, mister. ಅದೇನೋ ಮಾತಾಡ್ತಿದ್ದಾರೆ ನೋಡ್ರಿ.
Sir, mic mute ಆಗಿದೆ. Sir, Abhishek mic mute ಆಗಿದೆ.
Yes. Await service of notice, mister.
Serial number 55. Sir. Fifth, Sir.
For the petitioner.
Yes. Non-compliance of the
Abhishek
officer.
Abhishek Marla.
Yes, mister. Which matter, mister?
Sir, 54, sir.
ಏನಾಗ್ಬೇಕು?
ಅದು ಸರ್ ಮೆಮೊ ಕೊಟ್ಟು ಕಳಿಸಿದ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಹೇಳ್ತೀನಿ ಅಂತಂದ್ರೆ.
ಮೆಮೋ ಏನಕ್ಕೆ?
ಸರ್ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ.
ಸರ್ ಹೇಳೋದಲ್ಲಿ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅಲ್ರಿ? ಮ್ಯೂಟ್ ಆಗಿದೆ. ಸರ್ ಏನ್ ಹೇಳ್ತಾರೆ? Yes. What is the end memory? Handsome sir. Handsome sir ಮಾಡಿದ. ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಕೊಡಿ ವಾಪಸ್. Yes, await service of notice.
Serial number 55.
For the petitioner, my lordship, the office objections are complied with it. Only one office objection with respect to defendant number 1 and 2 has not made as a parties. My lord, I am the impleading applicant before the trial court. I am the transferee pendent lite. I have filed an application under 1 Rule 10. Different number, I am seeking the relief against the plaintiff, hence I have not made a
Pass
parties.
over will ask the registry. ಅದು ಇನ್ನೊಂದು ಕೇಳಿದ್ವಲ್ಲ ಅದ್ರ ಜೊತೆಗೆ ಪಾಸ್ ಓವರ್.
Yes, my lord.
Serial number 56, Vamshi Krishna C.
Lords, I appear for the petitioner in this matter, my lord.
Complaints office objection.
My lord, one office objection was left out in this matter, wherein yesterday, my lord, the pending, the file came at 1 and immediately dispatched. We were not able to comply with that, my lord. In the trial court, the matter is posted on Saturday. There is urgency in this matter. May I request to be posted tomorrow, my lord? Saturday, the matter is kept. If taken tomorrow before this honorable court, that may help, my lords.
Comply that office objection.
My lord, in the course of the day, today itself, we'll comply.
Yes, leave this matter day after tomorrow. In the meantime, petitioner is directed to comply office objection.
Serial number 57, Chandan VC.
In this case,
Sir,
for
in this case.
respondent, I take notice here.
Take non-compliance office objection.
My lord, with respect to
Point
the
number 18
serial
and
number
19.
11,
The laws of that
respondent number
is
16.
brought on record before the death of that respondent 16 as per 16. Entry of the office of.
My lord, sir, respondent number 17 and 18 are the, now which has been corrected, my lord. The respondent number 18, 17 and 18 are the LRs of the respondent number 16, my lord.
Laws of that respondent number 16 were already brought on record.
Yes.
Before the.
If a
ಮೊದಲು
record-
16 ಅಂತ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಅದನ್ನ this it has been ಅವ್ರನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 16 ಎಂ ಕುಮಾರ್ ಅಂತ ಮಾಡಿ
ಯಾರು ಸತ್ತೋಗಿದ್ದಾರೆ?
ಮೈ ಲಾರ್ಡ್ ಸರ್ ನಂಜೇಗೌಡ ಸಾರಿ.
Which respondent?
My lord sir, earlier we have been made him as a respondent number 16, my lords.
16.
Yes.
Hmm.
Now office objection has been taken up with respect to the respondent number 16. ಅಲ್ಲಿ ಕೆಳಗಡೆ ಸಿನ್ಸ್ ಡೆಡ್ ಅಂತ ಮಾಡಿದಕ್ಕೋಸ್ಕರ ಏನು ಅವ್ರನ್ನ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದ್ರು. ಸೊ ವಿ ಹ್ಯಾವ್ ದ ಅಗೇನ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 17 and 18 ನೌ ಆರ್ ದ LRs ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 16 ಅರ್ಲಿಯರ್ ಮೆಂಬರ್ಸ್. ಅವ್ರೇನ್ ನಂಜೇಗೌಡ ಅವರ ಹೆಂಡತಿ ಮತ್ತೆ ಮಕ್ಕಳು ಬಂದು ಅಕ್ಕಯ್ಯಮ್ಮ ಮತ್ತೆ ಶ್ರೀನಿವಾಸ್.
ಅವ್ರು ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್?
Lords, now the 17 and 18, earlier 18 and 19 ಆಗಿದ್ರು.
ಏನ್ರಿ ಇದು ಆಫೀಸ್ objection?
LRs ನ ರೆಕಾರ್ಡ್ ತಂದಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
Submission. Yes. Yes, what is this, mister? Yes.
Yes,
Make
my lord,
a
the respondent
submission,
no-
your lordship.
You take notice.
Yeah, I take notice. They have sought for 3 amendments. Your lordship, I allow as per the amendment number 2 and 3, not 1, your lordship, because there is an admission, it is a joint family property. After
Yes.
15 years, they want to change it as a self.
Suit for
partition, my lords.
suit for partition. You are the plaintiff.
Yes, my lords. Plaintiffs.
What is that amendment you sought for?
My lords, earlier in the plain pleadings, it was specifically mentioned with respect to joint family property. And subsequently, when it was the property which is duly purchased by the father of my,
Your amendment petition,
my lords, annexure E, my lords.
page number
Page number 50, my lords.
15.
Yes, my lords. 50. Sorry, 59, my lords. 59. 50 on annexure E, my lords.
59.
Yes, 50, my lords, 50.
Yes. What are the proposed amendment?
My lords, with respect to the proposed amendment in paragraph number 3 of the plaint, in place of words comments from that, the plaintiff so and so, the land bearing survey number 363, measuring 3 acres, land in survey number 365, 4 acres, situated at Betta Alsur village, Jala Hobli, Bangalore North Taluk, or ancestral and joint family properties. This was the earlier which it has been mentioned with in the plaint, my lord. Subsequently, that particular paragraph is to be deleted, and subsequently the averment which have been specifically mentioned in the next page, my lord. It is a self-acquired property purchased by the late Munishamappa in the name of said Munimarappa, one property. Adadmele late Munishamappa has been purchased the property in one sale deed. There are two different sale deeds which
No, you have objection for first.
First, as for the second and third, it may be allowed on payment of cost, your lords.
No, he wants that first also.
yes, my lord.
First, your lordship.
Because it's a
will say-
registered sale deed which has been
Changes the nature of the property because.
Then we'll hear that now
Yes,
it's for an admission. Yes. You are taking notice to whom?
17 and 18.
Yes.
17,
Others,
18 ಅಲ್ಲ ಹಂಗಾರೆ 19 ಅವರೇ ತಗೊಬೇಕಾಗುತ್ತೆ ಸರ್ ಅವರ ಮಗನೇ
ಅವ್ರ ಫೀಸ್ ಕೊಡ್ತೀರಾ ನೀವು?
ಅಲ್ಲ ಅವರು
ಅವರೇ ತಗೊಳ್ಬೇಕು ಅಂತ. It is for that advocates and the party, mister. If the party don't want to engage, if they want.
18 and 19 I will take you.
18, 19 ಇಲ್ಲ. ಏನೋ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರೆ ಈಗ.
ಎಕ್ಸಾಕ್ಟ್ಲಿ
ಯಾರ್ಯಾರು ಹೇಳಿ ಅದು? ನೀವು ಹೆಸರು ಹೇಳಿ
ಅಕ್ಕಯ್ಯಮ್ಮ and ಶ್ರೀನಿವಾಸ್ ಅದು 17 and 18 right now.
17 and 18, mister. Yes, now that 19 has been yes.
My lords, on 28th before the trial court for the suit.
I will stay that is your suit. Yes.
ಅವ್ರದೇ suit ಅದು.
He wants to say, let me will say, yes. Issue notice.
My lords, the respondent number 1 to 15 are not required, hence the notice to them may be dispensed.
Memo haki.
Yes, my lords.
Lordship may have on Tuesday or Wednesday, your lordship may hear and dispose. 28th or 29th. ನಿಮ್ಮ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಬಿಟ್ರೆ
ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡ್ತೀನಿ.
Notice to filed in a memo seeking
Yes,
dispensation of notice to respondent number 1 to 15. Memo is taken on record. Notice to 1 to 15 is dispensed. So and so learned counsel undertake to appear for 17 and 18. 16 ಒಬ್ಬರಿಗೆ notice ಹೋಗ್ಬೇಕು.
ಹೌದು ಸುಮ್.
Issue emergent notice to respondent number 16. Stay of further proceedings in OS number
520 of 2010, my lords.
520 of.
I take for 16 also, your lordship. It
take
will not be dragged.
Yes.
Kumar.
So and so is undertake to appear for 16, 17 and 18. Notice to 1 to 15 is dispensed. Yes, stay of further proceedings in OS number
520 of 2010, my lords.
520 of 2000. ಎಲ್ಲ ಹಾಕಿದ್ರಿ OS number
Last page, my paragraph, page number 12, my lords.
520 of 2010 pending in the file of third additional senior civil judge JMFC Devnadli till next date of hearing. Use this matter on 10th. Both of them ready will, yes.
10th ದೂರ. If your lordship can take it early and 29th, 28th or 29th.
So many matters have given.
All right, I will not pay you. I will not trouble you.
Yes.
Petitioner
70? Yes.
ಅಲ್ಲ ಮೂವ್ ಮಾಡಿದ್ವಿ ಅದ್ರಲ್ಲಿ.
ಆಯ್ತು 77 at the request of counsel.
ಅಲ್ಲ 1 week date may be fixed ಮಾಡಲ್ಲ.
Next week. Entry ಮಾಡ್ರಿ ಇದೆಯಾ?
Entry ಮಾಡ್ರೆ ಕೊಟ್ಟಿಲ್ಲ, that's why.
Yes. Is this matter on 4th?
ಆಗ್ಬೋದು.
My lord, serial number 61, my lords. 61, I appear for the petitioner. Lords, the respondent has filed an IA for vacating stay. My lords, the matter has to be heard on merits. And I have not been served a copy of
You are appearing for?
petitioner.
I have informed other side.
My lord, I've tried contacting, I'm not able to.
And
get
then you
through
wait
to them.
till the matter is caught. Yes. Because it's vacating, their application is.
My lord, I've not been served a copy of the IA.
ಆಯ್ತು ಅವ್ರು ಬಂದಾಗ ಹೇಳಿ. When matter is.
Serial number 58 offer for.
58. You are appearing for? Yes, at the request of counsel for the respondent, leaves this matter after 2 weeks.
Serial number 60.
My lord, serial number 59.
Our objection ಹಾಕ್ಲಿ.
Milords, serial number 54, Milords. Apologies, Milords. There was some technical glitch, Milords.
Review ಏನದು? ಏನ್ review?
ಆಲ್ರೆಡಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ವಿದಿನ್ 1 year ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಅಂತ ಅದನ್ನ ಮುಗ್ದು ಹೋಯ್ತು ಇವ್ರು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸುಮ್ಮನೆ ಅಯ್ಯ
ಆಯ್ತ್ರಿ ಅವ್ರ RP ಏನಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನೀವು.
ಅದನ್ನೇ ಹಾಕ್ತೀರಿ.
ಆಯ್ತು. Is this matter on 5th?
Serial number 59, my lord.
ಆಯ್ತಲ್ಲ ಕೊಡ್ರಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೊಡಿ.
My lord, serial number 59, my lord. I am for the petition, my lord. I have filed IA for return of original documents. My lord, I will verify the file, my lord. What are all the documents are not mentioned in the IA?
59.
Reach ಆಗಿ.
59. What you want, mister?
My lord, 1 week time, my lord.
You are appearing for?
Petitioner.
At the request of petitioner, read this matter for 2 weeks.
Serial number 65.
Milords, serial number 54, Milords.
Yes.
Apologies, Milord. There was some technical glitch, Milords. Milords, interim order may be extended, Milords.
Here is extended till next date of hearing. Yes, madam.
Kindly have it.
65.
Yes, Milord.
By next week, my lord, please.
65, you are appearing for?
Petitioner, please.
There
Respondent
is
is.
an IA for vacating, madam. Have you
Okay.
informed other side?
Yes, he is here.
And I
at the
have-
court.
Yes,
Please, sir.
you have any objection?
Tomorrow it is posted for.
Tomorrow, if it
Day
is
after tomorrow, Milords.
no, either Tuesday or Wednesday, 29th. 29th, madam.
Please, my lord.
Yes.
Interim order. sir.
Yes,
65.
interim order granted earlier is extended till next date of.
Court officer, sir.
Sir, 68 ಇದೆಯಲ್ಲ?
Court officer, sir.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಹಾ.
Sir, 68 ಇದೆಯಲ್ಲ?
ಆರ್ಡರ್ 1.
Sir, 68.
ಮಾಡಿದೆ. ಹೇಳಿ ಸರ್, BCL ಯಾರು?
ಸರ್ ಅದು ಏನು ಕೇಳ್ತಾ ಇರ್ಲಿಲ್ಲ 54 ಅಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸರ್.
ಮಾಡಿದ್ದಾರೆ ನಿಮ್ಮವ್ರು ಇದಾರೆ ಬಿಡಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಇದೊಂದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ. ಹಾ ಸರ್, ಹೇಳಿ ಸರ್. 80 ಇದೆ ಸರ್, ಇದೆ. ಯಾರೋ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಏನು ಕೇಳಿ. ಒಂದ್ ನಿಮಿಷ. 84 ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡಿದ್ದಾರೆ, ಬೆಳಿಗ್ಗೆ ಫಸ್ಟ್ ಅವರು ಬೇಕಂತ. 84 ನೀವೇ ಕರೆಕ್ಟ್. ಇತ್ತಪ್ಪ, ಇದು ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮೆಮೊ ಸೈನ್ ಹಾಕ್ಸಿದ್ದೀನಿ. ಯಾರಮ್ಮ, ನೀವೇನಾ? ತೊಳಿ ಬೇಗ, ಸಾಹೇಬ್ರು ಊಟಕ್ಕೆ ಕುತ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಎಲ್ಲದ್ರಲ್ಲೂ ಈ ತರ ತೆಗಿತೀರಾ? ಅದು ಕಾಮನ್ ಆಗಿ ತೆಗಿತಾ ಇದ್ದೀರಾ ನೀವು. ಈಗ ಡಿಪೆಂಡೆಂಟ್ಸೇ ಪಿಟಿಷನ್ ಫೈಲ್, ಅವರು ಕೋ ಡಿಪೆಂಡೆಂಟ್ಸ್ ನ ಪಾರ್ಟಿ ಮಾಡೋ ನೆಸೆಸಿಟಿ ಇಲ್ಲ. ಯಾಕೆ ಮಾಡ್ತಾರೆ? ಯಾಕೆ ಮಾಡಬೇಕು? ಸರಿ, ಅದು ಬಿಡಿ, ಅದು ಅವ್ರದ್ದು ಪ್ರಶ್ನೆ. ಈಗ ನೀವು ಯಾಕೆ ತೆಗೆದಿದ್ದೀರಾ ಅನ್ನೋದು ಪ್ರಶ್ನೆ. ಯಾವ ರೂಲು, ಯಾವ ಪ್ರಾವಿಷನ್, ಎರಡೂ ನಿಮ್ದೇ ಮ್ಯಾಮ್. ಅವ್ರು ಅನ್ನೆಸೆಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೋಗ್ತಾನೆ ಇರ್ತದೆ ಅದ್ರ ಮೇಲೆ. ಅದಕ್ಕೆ ಒಂದು ಇತಿಶ್ರೀ ಆಡ್ಬೇಕು. ಹೋಗಿ ಬೇಗ, ಸಾಹೇಬ್ರು ಊಟ ಕುತ್ಕೊಂತಾರೆ. ಬೇಕಾದ್ರೆ ಅಲ್ಲೇ ಸಾಹೇಬ್ರ ಹತ್ರ ಮಾತಾಡ್ತಾ ಅದನ್ನ ನೋಡಿ. ಅದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ, ಇಷ್ಟೇ ಅಬ್ಜೆಕ್ಷನ್. ಇದನ್ನ ಯಾವ ಪ್ರಾವಿಷನ್ ಮೇಲೆ ತೆಗಿತೀರಾ ಅಷ್ಟೇ ಹೇಳ್ಬೇಕು ಸರ್. ಮತ್ತೆ ಹೆಂಗ್ ತೆಗಿತೀರಾ? ಎಲ್ಲದಕ್ಕೂ ಸೇಮ್ ಫಾರ್ಮುಲಾ ಅಪ್ಲೈ ಆಗಲ್ಲ. ನೀವೀಗ ಪ್ರೀವಿಯಸ್ ಕೋರ್ಟ್ ಬಿಟ್ಬಿಡಿ, ಇದೊಂದು ಕೋರ್ಟ್ ಏನ್ ನಡೀತಾರೆ ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲರೂ ಬಂದವರೆಲ್ಲ ಅದೇ ಹೇಳ್ತಾರೆ, ಹಿಂದೆ ಹೆಂಗ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸಾಹೇಬ್ರು ಆ ತರ ಇಲ್ಲ. ಏನೇ ಮಾಡಿದ್ರು ಅಕಾರ್ಡಿಂಗ್ ಟು ಲಾ. ಪೇಪರ್ ಹಿಂದೆ ಇಲ್ಲೇ ಒಂದ್ ಮಾತು ಹೇಳಿ ನೋಡೋಣ. ಅದು 2 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ, ನಂಗೆ ತಂದು ಕೊಡ್ಬೇಕು. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೇಳ್ಬಿಡ್ತಾರೆ ಅಲ್ಲಿ ಇವ್ರ್ಗ ಅವ್ರ್ಗ. ಎಲ್ ರೀಚ್ ಆಗುತ್ತೆ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಇನ್ನು ಹೈಯೇ ರೀಚ್ ಆಗಿಲ್ಲ. ಇಲ್ಲ, ಆಗಿದೆ. ಕಾಯಕ್ಕಾಗಲ್ಲ. ಬರುತ್ತೆ ಅವ್ರು ಇನ್ನೂ ಅಲ್ಲೇ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಮೂರುವರೆ ಇಟ್ಕೊಂಡಿದ್ದಾರಪ್ಪ. ರಾತ್ರಿ ಇರುತ್ತಲ್ಲ, ಅಲ್ಲೇ ಬರುತ್ತೆ, 3:30 ಬಂದು ನೋಡಿ. ಹೆವಿ ಇರುತ್ತೆ, 2 ಬ್ರಾಂಚ್ ಹೋಗ್ಬೇಕು ಬರುತ್ತೆ.
ಊಟ ಇನ್ನಿಲ್ವಾ?
ಕೊಡ್ತೀವಿ, ಅರ್ಜೆಂಟಿರೋದು ಅಲ್ಲಲ್ವಾ? ಅದೇ ಕೂಟ್ನಿ ಕೊಟ್ಟಿರ್ತೀವಿ, ಅಲ್ಲಿಂದ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ. ಆಮೇಲೆ 3:30 ಬಂದು
ಊಟ ಇನ್ನು ಇವಾಗ 98 ಇದೆಯಾ? ಇದೆಯಲ್ಲ? ಹಾ ಮಾಡಿದ್ದು ರೀಚ್ ಆಗುತ್ತಲ್ವಾ?
ಏನೇ ರೀಚ್ ಆಗಿದೆ ಇದೆ ಎಷ್ಟು
ಕೆಲಸ ಹೌದಲ್ಲ, ಲೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಸರ್, ಈ ತರ ರೂಲ್ ಇಲ್ಲ ಫಾರ್ ಲೋವರ್ ಕೋರ್ಟ್, ಅದೇ ನಿಮ್ಗೆ
ಇಲ್ಲ ಕಂಪಲ್ಸರಿ ಏನಿಲ್ವಾ? ಇಲ್ಲ ಸರ್, ಕಂಪಲ್ಸರಿ ಇದೆ, ನೋಟ್ ಬಿಲ್ ಅದ ಕಾಸ್ಟ್. ಹೌದು ಸರ್.
ದಾಂಡೇಲಿಯವರು ಇದೆ ನಿನ್ ಕೈ ಕೊಟ್ಟೆ ಫಸ್ಟ್ ಮಾಡಿ.
ಸರ್ ಯಾವ್ದು?
ಮುಂದೆ ಹೇಳಿದ್ದಾರೆ. Serial number 41. ಐದನೇ ತಾರೀಕು date ಇದೆ. Okay, sir. ಮೇಡಮ್ ಈಗ ರೆಕಾರ್ಡ್ ಬರುತ್ತಲ್ಲ 41 ರೆಕಾರ್ಡ್ ಕೊಡಮ್ಮ. ಬರುತ್ತಮ್ಮ 3 ಗಂಟೆ ಬರುತ್ತೆ. ಕೊಡ್ತಾರೆ.
One mentioning, my lord.
Yes.
Lord, item number 84, my lord.
Hmm.
Appear for the petitioner. Lord, we have moved the memo, my lord. In the opposite council have taken date, my lord, without informing us. There's some urgency in the matter, my lord. Maybe take any date may be fixed. My lord.
Who has taken that?
Respondents, my lord.
Respondent.
They have said that they have informed you.
They have not informed us, my lord. We in fact have moved a memo, my lord. Any date may be fixed, my lord. We'll argue the matter.
1 week ಅಂತ ಅಂದ್ರೆ on 3rd date ಕೊಟ್ಬಿಡಿ.
Please, my lord. Great.
Is there any interim order?
There's no interim order.
Serial number 61, Ajesh Kumar as per petitioner.
My lord, I appear for the petitioner in this case, my lord.
Hmm.
My lords, the respondents have filed an IA for vacating stay, my
Yes.
lords.
None
I've not
appear-
been served a copy.
Yes, none appear for the respondent. Leaves this matter after 2 weeks. Interim order granted earlier is extended till next date.
Please, my lords.
Serial number 62, T.N. Vishwanatha for petitioner, Nischal Dev B.R.
Respondent, my lord.
Lordship 62, my lords, I appear for the petitioner.
Yes.
My lords, last time I had sought for an adjournment as my senior counsel appearing was not keeping well. My lords, in fact, he has still not recuperated and he is still under arrest, my lords. May I request my matter to come up next week, my lords. The counsel shall be physically present before your lordships and shall argue this matter.
Why?
I make one request, my lord. If that is the case, my lord, let them argue whenever they want the writ petition. That interim order had to be vacated.
That interim order.
Let me
Lordship,
see
that-
the interim order, my lord. On 26/6/2023 is the interim order given. I'll read the last paragraph, my lord. Meanwhile, the executing court before whom commercial execution petition so and so is pending is directed not to take precipitative steps action against the petition. However, the executing court is permitted to continue the proceedings in all other aspects. My lord, this interim order, my lord, is being misled to say that executing court should not do any action.
That will confirm, they modify, they clarify
Yes,
that.
my lords may clarify on that.
Yes. This court by order dated, learned counsel for the petitioner praise time. Ala either, but this court by order dated 22/6/2023,
26/6.
22/6.
I'm sorry.
Yes. As directed, has passed an interim order. Executing court is directed not to take any precipitate steps or action against the petitioner. However, it is made clear that executing court is permitted to continue the proceedings in all other aspects.
Yes, ma'am.
Therefore, there is no stay for continuing the proceedings in all other aspects. The executing court is directed to proceed with the matter.
Yes, ma'am.
Yes.
Lordship, may kindly have the
And
matter
the
to
request
next
is
week.
This matter of 2 weeks. Yes. Interim order granted earlier is extended with that modification. Yes.
Serial number 63, Arvind Reddy H for petitioner,
With your lordship's kind permission.
Hmm.
But this is a matter where a suit for partition filed before trial court.
No, that service is not completed,
No, service, we served personally to the council before trial court.
but party is not served, mister.
Party is not served, but there was a direction by this court to serve
No,
a
that is-
copy on a council.
If he come and appear, it's good. Otherwise, it is not a service. I take hand summons.
It's all right.
Council, there is no obligation. Only if come and file an wakalat, it's good. Otherwise, party has to be served. You take hand summons, that is the service.
We'll take hand summons.
Yes.
In the meantime, maybe because
What is
our
that?
examination is over.
Hmm.
We have the defendants before the trial court, only cross-examination is kept.
Hmm.
Now the trial court is proceeding in view of dismissal of my application for amendment to the written statement.
is
There
a-
are two,
no.
three
What is that? Your application for amendment is rejected.
application for amendment to the written statement is rejected.
Why?
They say that you have the trial is commenced, after commencement of trial, you made an application.
Hmm.
So that is what it is quoted at page number, the trial court
What is
judgment.
the stage now?
A stage is for cross-examination of defendants. That is
Yes.
the petitioners.
You have paid the process,
We paid the process.
awaiting service of notice to stay of further proceedings in OS number 174 of 2017, pending in the file of Senior Civil Judge JMFC Chintamani till next date of hearing. Awaiting service of notice to the
Obliged.
Now they will come. Yes.
serial number 64, Govindraj K.
Here for the petitioners.
Yes.
Lord, this is a suit for partition.
LRs of deceased are.
Lord, the person died is one of the plaintiffs, man. There are 4 plaintiffs.
No, there is no, this thing. You are not claiming any relief against that,
No, my lord, for all other plaintiffs, my lord, my friend is appearing.
no, you are not seeking any relief against that R3.
No, it is a joint relief, my lord, in respect of all the plaintiffs.
No, in this writ petition,
My lord, my only
is
prayer
it
is
necessary to bring LRs or you
no,
don't?
bringing LRs is necessary.
Then
my
you
lord.
do it. Then otherwise, how can
No,
I hear?
I will.
Yes.
My lord,
Weeks-
in the meantime, my lord, I request for a consideration of my interim prayer.
What is that?
My lord, suit is for partition.
Hmm.
My lord, the petitioners here in our defendant number 2 to 9 in the suit.
Hmm.
There are totally 17 defendants.
Hmm.
My lord, the defendants 10 to 17, my lord, propounded a will.
Hmm.
Therefore, my lord, trial court asked them to lead evidence first.
Hmm.
My lord, in that junction, my lord, I filed a memo
Hmm.
stating that I will lead evidence after the completion of evidence of all other witnesses.
Hmm.
Court accepts a memo. Then, my lord, after plaintiff's evidence, suddenly posts the matter for arguments. Then again, I file a memo requesting the court that I made a request earlier itself, kindly permit me to lead evidence.
No, you are the
No.
defendant.
Yes, I am one of.
After the plaintiff evidence,
Yes.
that opportunity has been given to the defendant.
No, my lord, the other defendants, my lord,
The other defendants opportunity has been given.
they led
Is-
evidence first. They began the evidence because they
No,
propounded.
after that, have the case posted for your evidence any day?
Defendants have also
No.
been examined.
No, my lord.
That's correct.
After plaintiff's evidence directly posted for arguments. At that stage, I filed one more memo requesting the court to permit me to lead evidence. My memo was accepted and an order was passed.
Hmm.
The next day, plaintiffs file an application seeking to recall the order and the court recalls and posts the matter for argument.
ಅಲ್ಲ, ನಾನು ಕೊಡ್ತೀನಿ.
ಆಯ್ತು ಅವ್ರಿಗೆ ಒಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟು
ಅಷ್ಟೇ ಸ್ವಾಮಿ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು only, my lord, my only
Only
request.
protraction ಅಷ್ಟೇ ಇದು. It is a collusion between the defendant number 17 who led the evidence first as DW1 and these defendants have not propounded the will. They are collusion each other. The suit for partition.
No, you have filed in a suit for partition.
I have filed a suit for partition.
What is the
Defendant
relation?
number 17 set up a will. Therefore, my lord, a issue was cast by the trial court on that effect.
He has-
Rebuttal evidence is chosen.
Hmm.
Defendant number 17 led the evidence as defendant number 1. They filed a memo after the closure of the evidence. If it any, after the closure of the plaintiff's evidence, we will lead evidence. But it has been closed in the year 2017 itself. They are participating all through the proceedings, are aware of these facts because they are in collusion with the defendant number 17. Now, after the case has been heard, now the case, not the plaintiff's argument have been closed. Now the present writ petition is filed. My prayer is this. After
When the day which has been posted for arguments, you could have filed an application for.
No, my lord, when the matter was posted for arguments, immediately I filed a memo.
When is that posted for
Yes,
argument?
my lord, posted for arguments, my lord, on annexure E, my lord, page 48. My lord, page 48, my lord.
Hmm.
That is dated, my lord, 13/10/23.
Hmm.
My lord, immediately I file a memo. Kindly see the next page, annexure F.
Here filed by the plaintiff under is hereby dismissed. Further evidence on behalf of the plaintiff is not adduced despite granting. No, even evidence was not, you know, completed on the day he has filed.
what they say is, though the opportunity has been given, we have not given any opportunity to lead evidence. But my submission is, the defendant number 17 who opted to read a rebuttal evidence, they have led their evidence. Thereafter, my lord, they have also once again filed a memo. Even after the examination of the plaintiff, we will lead evidence.
No, see, who has set up the will? Defendant
My
number
lord,
17.
17.
Petitioner is
My lord, the
We are
petitioner,
defendants.
defendant number 2 to
2 to 9.
2 to 9.
9. So the defendant number,
First, that evidence of the defendant number 7 has been allowed.
yes,
Because-
defendant number 17 was allowed. And they closed the evidence.
Evidence.
Then defendant number 2 to 4 have been examined.
No,
They were
no, that is not correct, my lord.
Kindly see my
Right.
this
After
point.
that,
ಎಲ್ಲ ನೋ ಅಂದ್ರೆ
2 to 5 ಆದ್ಮೇಲೆ
2 to 4 ಆಯ್ತು. ಅದಾದ್ಮೇಲೆ ಪ್ಲೇಂಟಿಫ್ಸ್ ಮಾಡಿದ್ರು. ಪ್ಲೇಂಟಿಫ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಮೆಮೊ ಇದು ಅದ್ರ ಆಗುವ ಪ್ಲೇಂಟಿಫ್ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ನಾವು ಮಾಡ್ತೀವಿ ಅಂತಂದ್ರು. ಪ್ಲೇಂಟಿಫ್ದು ಕ್ಲೋಸ್ ಆಯ್ತು. They did not choose. So many opportunities have given.
that order sheet for that after
ಅದಕ್ಕೆ
plaintiff,
order sheet ಇಲ್ಲ ಇದು.
plaintiff evidence.
Last may
They are
get
given
it with the reference to the full order sheet. My kindly my the point ಕೊಟ್ಟಿದ್ದನ್ನು ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ.
Yes. No, even after giving an opportunity, he has
ಹೌದು,
not
ಹೌದು,
used,
ಹೌದು.
then he is not
Blood,
entitled.
that is
ಅಷ್ಟಕ್ಕೆ
not
ನಾನು ಹೇಳೋದು.
correct. That is not correct.
Well, show me
Blood,
that order
let-
sheet.
Blood,
let
kindly,
him show-
kindly see. Blood,
Mr. Ravi Shankar, show me
Yes,
that
yes.
in the order sheet.
yes. Kindly
When
take
your
a look at
evidence
the
is
order
from-
dated,
When your petitioner plaintiff evidence is over,
the
Mr.
plaintiff evidence was over.
My lord, that is
On-
annexure E. My lord, just now I have
I-
shown.
Order sheet al nodana.
22/8/2017,
22.
8/2017.
No, 13/10/23.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ.
Plaintiff's evidence closed and posted for.
They let the evidence in the definition.
No, that is not correct. Yes, you correctly find out that when it is over, how many opportunity has been
ಆಯ್ತು,
given?
ನಾಳೆಗೆ ಹಾಕಿ.
Saturday.
ಅಲ್ಲ ನಾಳೆ ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ಸ್ವಾಮಿ. Court is not granting time.
Saturday, day after tomorrow. Saturday.
My lord, tomorrow, my lord, let them,
No, no, I
let
want
the
to guess
court.
tomorrow, let us.
ಹಾಕಿ.
ಅಲ್ಲ ನಾಳೆ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ಸ್ವಾಮಿ.
Ade, tomorrow we'll see. Tomorrow you just mark
If
that
it is
date.
so, Millet, I will not say anything. You'll
Yes, if that opportunity has not given, then
Even
they
I
come.
am-
Otherwise,
My lord, my only prayer is give me an opportunity to lead evidence.
they are already given a sufficient.
No, my lord.
Order sheet ಅಲ್ಲಿ ತೋರಿಸಿ ಅಂದ್ರೆ ಒಬ್ರು ಮಾರ್ಕ್ ಮಾಡ್ಕೊ ಬಂದಿರ್ತಾರೆ ನೋ ಅಂತ ಅಂದ್ರೆ ವೆದರ್ ಐ ಹ್ಯಾವ್ ಟು ಸಿ ಆರ್ಡರ್ ಶೀಟ್ ಆರ್ ಐ ಹ್ಯಾವ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಯುವರ್ ದಿಸ್. Yes. Yes, tomorrow.
My lord, tomorrow, my lord, let the court.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಯಾಕೆ ಸ್ಟೇ ಯಾಕೆ ಬೇಕೀಗ?
See, tomorrow, if that is by in the order sheet, you mark the dates which has given.
Right.
If no opportunity, I will allow that and
ಅಷ್ಟೇ.
directed to give
ಅಷ್ಟೇ,
an
ಅಷ್ಟೇ.
opportunity.
ಅಷ್ಟೇ.
He is also agreed that.
ಆಯ್ತಾಯ್ತು.
Serial number 65 adjourned, passed over matter. Serial number 22, Shivakumar KB.
Yes, 22. Yes.
The defendant has filed an application, plaintiff has filed an application seeking direction to deposit the rents. Now, what has happened is during the entire period of COVID, we are entitled for the abatement of rent. And there was because of the construction being not complying with the fire safety measures, the electricity was disconnected for 18 months. And we equipped the building with all that. So we have in fact paid excess amount to them. Now in the COVID period, the entire
suit
remission has to be there.
Suit for?
Suit for ejectment and also recovery of money. Now kindly see the lease deed at page 22.
Yes.
Class number 9 only. 5 lines from the bottom.
Yes.
The lessee shall not be required to pay the lease rent under the lease for the period during which the lessee is unable to use the scheduled premises as a result of occurrence of forced marriage.
Able to use the scheduled premises.
Process. 22 months was not been able to use. Other rent our kelta idare.
Where is that?
Yes. Now kindly turn to the trial court order. At page 111.
Yes.
The principles laid down in decisions are well founded. These decisions are come to the aid of the plaintiff in the present fact and circumstances case. As per the statement of objection filed by the defendant, the total amount of 3,18,77,608 and the rent of 1,71 lakhs is, and its amount to 4,91,44,682. The amount of rent due as per the plaintiff is 5,95 lakhs. The 5,95 lakhs out there, including the COVID period and including the period for which electricity was disconnected. So I have been directed to pay 1 crore rupees.
No, electricity is disconnected for what?
The building was constructed without fire safety measures. So the fire department wrote a letter to the electricity department, please disconnect electricity because it does not comply.
How many months in that COVID period?
COVID period is 23.5 months. And 18 months disconnection of electricity. And we equipped with the fire safety measures and thereafter the electricity was restored.
That after that, what is that remaining amount you have to?
Remaining amount, in fact, I am entitled to recover from it because I have spent the money for equipments and all that.
There is no any due according to you.
In fact, excess amount is paid. Our building construction they did not put up the construction. They extracted additional advance of 55 lakhs.
Is there any such condition that they have to pay that all expenses in the lease deed? That
So
is
I
not
have
there.
incurred the expenses because the fire safety measures were not there. The fire department wrote a letter to electricity department. Electricity department disconnected the electricity. For 18 months, it was not there. Now, whatever it may be, my submission is, there is an order to struck off the defense. Kindly turn to page 111, IA number 6 mele.
111.
11.
Hmm.
The application filed under 150 of CPC, IA number 6 hereby allowed in part. The defendant directed to pay an amount of 1 crore towards the arrears of rent till the further orders. The defendant is also directed to pay the said amount in 3 weeks from today. Failing with the defense will be struck off. So this is the order which is coming in the way.
Yes, defendant is directed to pay that amount of, no,
One-
out of
one-
5, the court said 1 crore.
1 crore.
Hmm.
And if I don't pay within the 3 weeks, that is on 25th,
You deposit some amount?
I will deposit 25 lakhs
Yes,
in 4 weeks.
yes, or issue notice.
4 weeks, 25 lakhs.
Stay of order dated. Four 1/20/25 passed in IA number
6.
passed on IA number 6 in commercial OS number 282 of 2022 by 84th Additional City Civil and Session Judge, Commercial Court, Bangalore, till next date of hearing, subject to condition. Petitioner has to deposit 25 lakhs before trial court within 3
4
weeks
weeks.
from today. 3 weeks.
Agu.
Yes, complaint ಮಾಡಿದಾರ. The net counsel for the petitioner submits that office objection is complied. Office to verify and proceed.
Serial number 24, Devendra N.
Petitioner, I filed a suit for injunction before the trial court. At the time of filing the suit, I filed a IA number 2, restraining the defendant not to interfere regarding running of the hotel business. The plaintiff regularly paid the rent to the defendant. I have produced the rental agreement for suit for bare injunction. Restraining. So all of a sudden, the defendant came near the scheduled property, scheduled premises, and threatened the defendant. That's why we filed a injunction suit against the defendant to not to interfere the scheduled premises, that is the hotel. After filing the suit, the defendant came before the scheduled property and disconnect the water and electricity.
Where is, what has happened to your application?
The issue emergent notice to the defendant. Page number 19.
Now, when is that order has been passed? 6/2/2025. Next date.
Next date.
When that order has been passed?
6/7/1.
What is that injunction order you have sought? Where is your IA?
Document number, next document, page number B, annexure B, page CC 28.
Please to export the order. No, they are already closed.
No, yesterday I have photographs. Yesterday also running the hotel.
What is that relief you have sought?
By oversight, I filed another IA in the, I have a certified copy I have in this, 2 IAs I have filed. One IA for not to interfere. Another IA is to not to obstruct the, continue the.
Which is that IA where notice has been issued?
Two IAs.
ಏನ್ ಐಎಲ್ ರಿಲೀಫ್ ಏನ್ ಕೇಳಿದ್ದೀರಾ?
Not to interfere.
ಎಲ್ಲಿದೆ ಓದಿ?
ಇದರಲ್ಲಿ
ಪೇಜ್ 28 ಅಲ್ಲಿ ಏನಿದೆ ಅದು?
ಇದರಲ್ಲಿ by oversight that IA is not stitched.
What is this IA? IA number C, annexure C.
Annexure C is the, that is the another IA to not to break open the lock open.
That means to say you are not there.
After filing the suit, they opened and we running the hotel business till today.
You opened it?
Opened it yesterday and today also we are running the business.
Then why you have filed an application for this thing?
I have 2 IAs filed on that day.
No, Mr. Counsel, don't make use of this order and break open it. See, you have filed an IA number 2/2025.
Please.
In OS number 2, is it not? What is your OS?
OS number 2/25.
You read that IA prior.
Application, the above request the honorable court immediately ex parte order, permission to plaintiff break open to lock and get into.
That means to say now already is locked.
After filing the suit, they have opened.
Who opened?
The defendant.
How can you open that?
We have a photographs and CC camera footage.
You have filed this application after filing the suit, is it not?
At the time of filing the suit, I filed 2 IAs. One not to interfere, another one not to.
Without court order, you only break open and entered.
No, they voluntary, he came and we have CC camera footage.
Who has opened
he himself.
He has opened and given that position.
I will show the. ಇಲ್ಲಿ ಎರಡು ಬೀಗ ಇದೆ ಸರ್, ಒಂದು ಬೀಗ ಮೇಲೆ ಬೀಗ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ನೈಟ್ ಬಂದು. ಇದು ನಾವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟ ತಕ್ಷಣ ಓಪನ್ ಮಾಡ್ಬಿಟ್ರು, ನಾವು ರನ್ನಿಂಗ್ ಮಾಡ್ತಾ ಇದೀವಿ ಈಗಲೂ. Today also we have a footage, CC camera ಇದೆ ಸರ್.
Yes, you maintain status quo position as and
please.
Or issue notice. Parties are directed to maintain status quo in respect of position of petition scheduled property till next date of hearing.
Restore the water connection, electricity.
That we'll see. Yes.
A date may be, the police have, they have indulged tomorrow, they came up, their defendant is, though it is, they are threatened to file atrocity case against the.
Now that I said status quo, please, you take an hand summons also. In addition, permitted to take out hand summons to the respondent.
Date may be given next to.
Service ಮಾಡ್ಬಿಟ್ಟು ಬರ್ರಿ.
Please, oblige. Much oblige.
Yes, submission.
And some
office objection is complied. Office to verify and proceed for.
Serial number 49, Udita Ramesh.
I may permitted to.
40.
And delivery.
Yes.
Oblige.
Yes.
My lord, for the petitioner, my lord. My lord, with regards to the parties who are in the plaint but not made parties to the suit, my lord.
Yes, we have made your submission that they are not necessary parties.
They're not proper or necessary parties, my lord.
Yes.
My lord, this matter, my lord.
Submission of learned counsel for the petitioner in respect of office objection is accepted. Office objection is overruled. Yes.
My lord, the prayer is for direction to consider my 39 rule 4 application, my lord. My lord, the facts of the case, my lord, is on
that a respondent defendant is appeared now.
Yes, my lord. Defendant number 4. I am defendant number 4, my lord.
You are the defendant number 4.
Yes, my lord.
You have filed an application for what?
39 rule 4, my lord.
We are vacating.
Vacating stay, my lord. I'll just give the facts, my lord. On 12/1, my lord.
Yes, we'll. What is the stage now?
My lord, it has been pending for objections, my lord. They have still not filed objections.
Then you have filed an application.
My lord, I filed my application 17th February 2024.
And where is that order sheet?
My lord, if I may direct my lord to the page number 38, my lord, is page number 38 is where the order for 39 rule 1 and 2 is granted, my lord. 38.
Yes. When it is granted?
It was granted on 12th January, my lord. 12th January, ex parte order was granted, my lord. Yes, 2024, my lord. Ex parte order was granted, my lord. With the notice was issued to me on the same day, return.
You 17/2/24, you have filed an IA.
I have filed my written statement and the IA. Subsequent to that, they have kept.
After that, you show me that order sheet, what has happened?
My lord, subsequently, the next page, it says, my lord, page number 43, my lord. Advocate for D4 present, advocate for plaintiff files the application under 151 extension, extended till next date, so and so, advocate for plaintiff file so and so application, call on file objections to IA number 4 to 9. My lord.
Which is your IA?
My IA is IA number 6, my lord. No, IA number 5. What has happened, my lord, in the honesty is, they have filed 10 IAs now, my lord. Now what has happened is the court is told.
No, that is different. One interim order is granted. If the vacating is filed, court has to pass an order.
It is.
Which is your IA, Mr.?
My lord, it's IA number 5, my lord.
IA number 5.
Yeah.
What is that other IAs they have filed?
My lord, other IAs, my lord, they have filed for under 26 rule 9. They filed multiple IAs, my lord.
No, you tell me what is the purpose they have filed. Is there any conflict?
There is no conflict, my lord. What they've, because the suit, my lord, is for injunction, my lord.
No, I don't want all these stories.
There is no conflict with the.
Don't know why they have filed an IA.
My lord, I'm not sure of the subsequent IAs, my lord, because that is regarding the,
What is the next date?
my lord, the next date of hearing, my lord, is 15/2, my lord, even as of the last date, my lord.
15/2.
Yes, my lord.
15/2, it is posted for what?
Objections to my IA as well as all the IAs. My lord, since filing
This petition is filed by defendant number 4, seeking direction to dispose of IA number 5 filed by the petitioner under order 39 rule 4,
yes, my lord.
directed to so and so. What is that annexure D?
My lord, annexure D is my IA.
Yes. Directed to dispose of that IA number 5 filed under order 39 rule 4 of CPC. In view of the prior sought by the petitioner, issuing notice to respondent is not necessary. Who is the plaintiff?
My lord, the plaintiff are respondents number 1 and 2, my lord.
Respondent number 1 and 2 are the plaintiff have filed a suit for
injunction, my lord.
They have filed a suit for injunction. Along with that plaintiff, they have filed an application for temporary injunction under order 39 rule 1 and 2. The trial court by order dated 12/1/2024 has granted an ex parte temporary injunction. After service of summons, petitioner defendant has filed IA number 5 under order 39 rule 4 for vacating that interim order on 17/2/2024. Till today, his application is not disposed of, hence he is before this court. Since the application for vacating is filed on 17/2/2024, no order has been passed on IA number 5 filed by the petitioner. Under these circumstances, it is suffice for this court to direct the trial court to dispose of that IA number 5 filed by the petitioner under order 39 rule 4 of CPC as expeditiously as possible, not later than end of February 2025.
Yes, my lord.
Till number 55, P. Fred Richardson.
Petitioner, my lord. Defendant number 1 and 2 has not made the parties because I'm not seeking any relief against the defendant number 1 and 2.
Yes.
My lord, the petitioner is transferee pending.
Petition of counsel for the petitioner is accepted. Office objection is overruled. Yes.
My lord, the petitioner is transferee pendently, and during the suit is for easementary rights, my lord. Seeking for a declaration to declare that the suitable property is the only way leading to the property of the plaintiff.
Yes.
Plaintiff for the respondent's hearing. But
Yes.
during the pendency of the suit, there was an internal transaction happened, and defendant number 1 in the trial court and the relatives have executed a gifted in favor of the petitioner. Hence, the petitioner is a necessary party. He has filed 1 Rule 10 application, and that application got rejected, my lord. My lord, kindly see page 8 of the petition, my lord.
Plaintiff has filed a suit against that which defendant?
Defendant number 1 and 2, my lord.
They are the respondent herein?
And they have not made them as a parties, my lord, because I'm not seeking any relief against
There is that.
kindly see the plaint, my lord. I have produced the plaint, my lord. Page number of 35, my lordship.
Yes. Filed a suit for
A suit
easementary
for
right.
easementary right, my lord.
In respect of which property?
In respect of survey number 52/1, my lord.
But subsequently you have purchased.
I have purchased.
From whom?
From the defendant number 1, Anand, my lord.
Defendant number Anand.
Anand. Anand has executed a release deed in favor of one Srimati Akkayamma.
You filed an application to
Yes, my
explain.
lord.
Why it is?
Stage is for plaintiff evidence. My application 1 Rule 10 has rejected, stating the reason that, my lord, kindly see page 8 of the petition. I have extracted the order, my lord. Page 8, my lordship.
Yes.
considering the fact that the applicant is not yet acquired the right title or interest over the suit property. He is not a proper and necessary party to the suit. Lord, it is, I have produced a memo along with a gift deed. I have documents through which I have acquired the right. Presently, I am in possession. I am the owner of the
When that
property.
gift deed has been, after the
four-
pendency of the suit,
4/4/2024, my lord.
during the pendency.
Yes, my lordship. The
This
plaintiff is
pendency,
seeking.
what is your right when the
He
pendency
is
of,
seeking.
no, when during the pendency,
Yes, my
if
lordship.
any transaction is occurred, you can't claim any right, madam. Otherwise, tomorrow after your evidence, you will alienate that property to
My
somebody.
lord,
He's gone.
suit is
he
for
plead-
easement rights. He is only claiming 15 feet road in the suitable property. The property I have acquired is
For
14
vendor-
guntas.
You know, see, you are only there is a gift in your favor.
Yes, my lord.
The person who has gifted, they will defend.
The person who has gifted is not a party. They have not made all the parties to the suit. That also I raise an objection. However, that is not considered.
Who
All
has gifted this property to?
Srimati Akkayamma, who is the sister of defendant number 1 before the trial court, Anand.
Who is that actual owner of that property?
Father of the defendant number 1, my lord, Devappa.
Who is that Anand and Manjunath?
Sons of this one, Miss Sri Devappa, my lord.
Sons of Devappa.
Devappa.
You are, who has gifted to you?
The daughter-in-law of Devappa.
Daughter-in-law of Devappa.
Devappa.
Means daughters.
That daughter-in-law is own sister of the petitioner.
Yes. She has not been made as a party.
No, my lordship. And the plaintiff is aware of family members, and plaintiff is a relative of the defendant. It's an internal dispute between the family, my lord.
There was no any partition.
No, my lord.
Yes.
Stage is for plaintiff evidence, my lord.
Yes, heard. Issue notice. You take hand summons.
I will take my lord.
Yes. In addition, petitioner is also permitted to take out hand summons to that. Which respondent?
For the respondent number 3 is contesting, my lord. The other respondents are not they're not contesting, even though they have filed wakalat.
Yes.
Sri Basavaraju is contesting plaintiff.
Others are, there are
Others
also,
are-
others also plaintiff, they are
The
necessary.
plaintiff not necessary, my lord. Actively, the Basaraju is contesting the matter.
Now that you want to dispense notice to all others.
I will take notice to all the people, my lord.
Yes, you
Because
take
same
and-
council.
Yes. And summons are service to the council.
And service to the council, my lord.
Yes, emergent notice in addition. Petitioner is also permitted to serve a notice on the council appearing for the respondent before the trial court. Leads this matter on 10th.
Till then, I request.
No,
for-
no, what is that? Still the evidence has to be completed.
Plaintiff has completed his evidence. Now the
Now-
cross has started, my lord.
Now,
I need
when is
a-
that next date?
3/2, my lord.
3?
My lord. February 3rd.
And then you will have it on 31st. You serve it and you will see on 31st.
Yes, my lord.
Yes, leave this matter on 31st.
Much obliged.
B group matter, serial number 66. Keshava Bhatia for petitioner, K. Ravishankar.
Yes.
Partition.
Who is your opponent? You are here. Yes.
OS 699 of 2007 for partition and possession. Decreed 1/6 share granted. Appeal dismissed, second appeal also dismissed. Thereafter, my lord, final decree proceedings has been taken to put my 1/6 share, my lord, all the part. That has become fine. In the final decree proceedings, my lord, with the consent, my lord, nobody seriously object. Court commissioner was also appointed to divide to file a report, to assist to the court. But he has filed a report. Yeah, in fact, a very, very correct report he has filed. And that was objected, my lord, only by first respondent, by filing a objection, which I have produced. But that objections has been upheld and that report has been rejected.
What is his objection?
My lord, his objection is, my lord, to equalize the share, my lord, some amounts he has directed to be paid against in 2 shares. Kindly see his report, man. Kindly see his report. Page, my lord, 20.
Page,
Ink page 20. 20.
yes.
My lord, from last line only I shall read, my lord. Till then, my lord, I took warrant and all that.
Yes.
The property was resurveyed in the presence of
No, in page number,
20.
in that page only last, yes.
I have read it, my lord, from the bottom. My lord, I shall read some 4-5 lines earlier.
Yes.
Though in execution of the commission warrant, the property was fully surveyed by Sri Anand. However, in spite of undersigned, repeated reminders, he has failed to provide the sketch to the undersigned. Hence, undersigned reported the same to this honorable court, and as per the subsequent direction issued by this honorable court, the undersigned once again conducted SWOT inspection on so and so. At that time, Sri Jayaprakash K, attached to the office of the Tahsildar Mangalore, has assisted the undersigned in execution of the commission warrant. The property was resurveyed in the presence of parties and their respective councils, and as instructed by undersigned, the surveyor Sri Jayaprakash K has divided the property and submitted the sketch to the undersigned. At the time of the execution of the commission warrant, the petitioner and their counsel and the respondent and their counsel, the undersigned, by taking into consideration the valuation of the land and building, has divided the property on equitable basis. On survey, it is revealed that though total extent is 1.04 acres.
Yes, now what is that difference?
But difference amount, my lord, kindly see next page, my lord. Next page, first paragraph.
Yes.
The immovable property more fully detailed in schedule A here below, hereinafter referred to as A schedule property is allotted to the absolute share of respondent number 4, Srimati Lily D'Souza. The A schedule property also comprises a small shed-like structure. However, the same contains no door number. However, the said shed measures 7.78 square meters. The total valuation of the property is 27,64,910. Towards the equalization of the share, the respondent shall pay rupees 13,819. The respondent 5 and 6 shall jointly pay 32,299, and the respondent number shall pay 14,246, and respondent number 2 shall pay 14,187 to respondent number 4. Total, my lord, some small, very, very small amounts, my lord, compared to them. This is objected, saying that he has no authority and all that, he has overstepped his commission warrant, and therefore
See,
that
now A scheduled property they have divided.
yes.
There is no this thing, only that house property.
No, the entire property, my lord, house and compound, it
Total
is
valuation of 27,000 yavadakkidu?
total valuation.
27,000, 27 lakhs 64.
Yes.
Total valuation of the property is that.
Yes.
Just now you read now.
Yes, my lord.
Towards the equalization of the share, the respondent number 1
So,
shall.
my lord, I am sorry. My lord, further he says, my lord, these divided portions is that value. Divided portion. Your lordship gets it, my lord, in the next page. In the next items and all that. Kindly see the next paragraph. The immovable property more fully detailed in B schedule here below. Hereinafter referred to as B schedule property is allotted to the absolute share of respondent number 1, Mr. Henry D'Souza. B schedule property also comprises a residential building bearing number so and so, which measures 150 square 0.16 square meters. The valuation of the B schedule property is 28,53,278. So also, my lord, C schedule he says, next paragraph, 29,87,657. Next one he says D schedule, 27,23,899.
No, what is his case? That valuation is less. What he is?
Allah, my lord, it should be equal. Equal to equalize it. Suppose if, my lord, if one property's value is a little more, my lord, to compensate the other, to equalize it, he has said that minimum, very negligible. Perhaps parties may not insist also, my lord, for the payment of it there. That has been objected and that has been upheld.
What is the reason given by?
Reason, kindly see the reason. Otherwise it is unworkable. But it is only to drag on. Kindly see, my lord, reasons, page 15, 16, only short order. On careful perusal, can I just read?
Yes.
perusal of the report, it becomes clear that the court commissioner has executed his warrant on several days. At page number 2, the report is mixed that on survey, it is revealed that to do the extent is 1.0.
No, the court said
Yes.
he gone beyond the directions of the court.
Yes,
Is it permissible?
it is permissible.
There is.
When an authority is given, my lord, when that power is given to divide and all things that is necessary, my lord, to completely adjudicate that, my lord, is also. I rely on AR, this AR 2017. But fourth page there, last. The only other contention advanced is that the power claimed should be held to be an essential power for the proper discharge of the conferred power. It was urged that without such a power, charges framed against any officer bearer cannot be properly inquired into, as he may utilize his office to interfere with the course of the inquiry, and possibility of his continuing to misuse his office during the pendency of the inquiry cannot be ruled out. It is well recognized, it is well recognized that when an act confers a jurisdiction, it impliedly also grants the power of doing all such things. Acts or employing such means are essentially necessary to its execution. But before implying the existence of such power, court must be satisfied that that power is absolutely essential for the discharge of the power conferred, and not merely that it is convenient. So,
No, this is for appointment of the commissioner. See, commissioner can go beyond that. This is not the judgment related to that appointment.
But the issue is this, under section 54A, whether a commissioner or a revenue officer can partition the property. That has been settled by this court because there was an amendment in the year.
Who has done it?
Not the commissioner. He divides the property, allots the share, does everything. For that, the court said, no, you can't do it. That is the purport of the entire issue. Kindly have the look at this. This has been considered.
No, he has to only
So,
mark that property.
Aste divide ಎಷ್ಟು ಮಾಡಬಹುದು
and report it. My lord, divide and report it. Judge personally cannot
Sorry.
go. Court means, my lord, officer of the.
This judgment.
kindly. That has been referred in the judgment itself. Like 2000.
If you want to go through this, he will grant time next week.
Pardon.
You want to see this judgment?
I think my learned friend.
But I have got it.
Empty number of times I have gone.
In the amendment of 16th, in
Ah.
all cases which.
Because the court commissioner has no power to divide the property
The commissioner.
and vary the schedules.
Possible to affect the partition, it can affect the partition on such a report, and court commissioner can't make a division. Yes, admittedly, division is made by the court commissioner, not by the court. Therefore, substantial question of law has to be answered. Yes.
My lord, he has.
Para 11.
My lord, he has, that
It
is,
is an
my
amendment.
lord, he has not divided, he has reported it, my lord, to the court, my lord, the method to work it out.
Petitioner number 1 is entitled for
They
this.
bandit.
He has to pay this amount. He has to pay. How can he can
That's
say
not-
that? These are all the shares.
Correct, that's all.
That is what.
That's all, that's what he has
No,
said,
he
my lord.
said he.
Whether, my lord, the court, my lord, after applying its mind again,
No. he
but how
said-
does the court personally divide the properties? Now the section says, my lord, this section has been kindly see this decision, my lord. ILR 2016, page 11A. It's not possible at all. My lord, that is not the intention of section, para 6, section 64 of the CTC as amended by the state of Karnataka is as under. Not
ಈ
section-
ಎರಡರಲ್ಲೂ ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ ಆಸ್ ಅಂಡರ್ ಅಂತ ಬಟ್ ದಿಸ್
ಅದೇ ಅದೇ that interpretation not, my lord, kindly
This
see this.
latest. What Ravishankar is produced is latest. Justice Chavan's is 2015, this is 2016.
My lord, after quoting the section, a bare perusal of the provision clearly reveals that whether the decrees for partition or for.
Where you are reading?
Para 7.
Para 7.
Internal page 186.
Yes, a bare perusal of the provision clearly reveals that where the decree is for partition or separate possession of a share, then the partition of the estate or the separation of the share shall be made by the court in accordance with the law. If necessary, the court may seek the report of a revenue officer not below the rank of a Tahsildar. Thus, a discretionary power has been bestowed upon the civil court to call for a report of a revenue officer if it deems it necessary to do so in order to execute the decree for partition and separation of share. Since it is a discretionary power, it not be exercised in each and every case. Then, in case the civil court decides not to call for the report of a revenue officer, then a second option has been given to the court to appoint a court commissioner, and such a person to be appointed can be any other person as the court may appoint as the commissioner. Thus, it is not necessary that such other person has either of the rank of a Tahsildar or above the said rank. In fact, it is not even necessary that such other person needs to have any connection with the revenue of.
ಈ ರೀಸೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದಾರೆ ಲಾಯರ್ಸ್ ನೆಲ್ಲ ಅಪಾಯಿಂಟ್ ಮಾಡಕ್ ಬರಲ್ಲ 54 ಅಲ್ಲಿ ಅಂತ ರೀಸೆಂಟ್ ಎಲ್ಲ ಮೊನ್ನೆ ನೋಡಿದೆ ಎಕ್ಸೆಪ್ಟ್ ರೆವಿನ್ಯೂ ಆಫೀಸರ್ ನೋ ಅದರ್ ಕೆನ್ ಬಿ ಅಪಾಯಿಂಟೆಡ್ ಅಂತ ಇಲ್ಲೆಲ್ಲ ಮೇ ಬಿ 2 weeks ಬ್ಯಾಕ್ ಸಮ್ವೇರ್ ಐ ರೆಡ್ ಇದ್ದಾರೆ.
I'm sorry.
ರೆವಿನ್ಯೂ ಆಫೀಸರ್ ಬಿಟ್ಬಿಟ್ಟು ಎರಡು ಲೈವ್ ಲಾವದಲ್ಲಿ 2 weeks ಬ್ಯಾಕ್ ಅಲ್ಲಿ ನೋಡಿ ಐ ರೆಡ್ ಇಟ್ ಸಮ್ವೇರ್ ದಟ್.
I will.
You also
This is, my lord, only drag on, my lord.
judgment
It is impossible for the
No.
persons who are.
No, there are two things. Judgment you relied on. What are the options available for the court? Here, after appointment, what is the power?
Correct.
That is the.
Whether he can allot the share, whether he can
the
say,
Supreme Court
this
decision
is
is
the
there.
amount.
Supreme Court decision somewhere I read. I think advocate has been appointed. Court said.
Okay, court
50
My lord, that is very clearly given under the section. If you read it, my lord, kindly see the section.
No, I have not read the entire this thing. Somewhere.
I
here
will.
Yes, you see that.
Sorry,
Yes. Next week.
some specific date, my lord.
Yes, release this matter on 11th January, the February.
11. Madam.
Oh, I am in the 10th, 11th date I am giving.
28th or
Now
29th. This
the
month.
date which I have given is more than 50 matters. I don't know other matters, how it will be added. Therefore, I am going to give the date after that only. So many matters, every day we are giving dates and taking a memo. Don't know how much I can do it. I am doing till 5 o'clock. Yesterday, 6 o'clock.
Problem
here.
Only before.
Let us see. Yes.
It gets accumulated.
Yes.
Serial number 67 adjourned, serial number 68, Pancham RD for petitioner, K. Sridhara.
Yes.
My lords, I am for the petitioners matter, my lords. My lords, IA filed by the petitioners, my lords, for amendment came to be
Who is the
rejected.
respondent?
Sridhar, my lords. K. Sridhar.
Sridhar, where is he? What is that? Stay is there.
Stays there, my lords.
Then we'll extend that he is not there. Yes.
Please, lords.
None appear for the respondent. Interim order granted earlier is extended till next date of hearing. Yes.
Obliged.
66 interim order granted earlier is extended till next.
Serial number 69, Prithviraj BN for petitioner, Sandeep K.
For the petition. my lord.
Correspondent.
Two partition suits between brother and sister.
Hmm.
They inquired, they are saying that let it be disposed on merits. my lord. ಇದರಲ್ಲಿ there are two partition suits, one filed by the sister. Synopsis ಅಲ್ಲಿ your lordships page 1 on 6/6/2019. The
Yes.
respondent case Latamani files a partition suit in OS 487 of 2019 before first additional senior civil judge CJM at Mysuru. In this suit, only five properties are there. Subsequently, on 18/9/2020, the petitioner, the brother of the plaintiff in the earlier suit, he files a comprehensive suit in OS 48 of 2020 at KR Nagar. In this suit, 12 properties are there, 12 immovable properties, and most of the properties are immovable properties,
No, that-
agricultural lands situated
That
at KR.
5 is not included here.
It is included. It is included. Since most of the properties are agricultural properties,
24 CPC before the district judge, so on. So, I transfer.
ಅದು dismiss ಆಯ್ತು. Against that order, we have.
Your application for transfer is dismissed.
Yes, ma'am.
Yes, mister.
My lord,
Why it is dismissed?
Right,
because-
because the prayer sought there was to transfer the case before the Mysore court to the Nagara court and tried together. Whereas my lord, the case before the Nagara court was stayed by filing an application under section 10. After that order, he files an application for transfer.
But that
No,
stay,
that is-
stay will not come in the way of transfer. The reason assigned is non-suit is subsequently filed.
ಅದೇ subsequent suit na stay ಮಾಡ್ತಾರೆ.
Stay ಆಗಿದೆ.
If the same party.
Page number 13, my lord.
Let that be OS be decided for 87. You file an application for inclusion of other properties.
Please.
ಅಲ್ಲೇ ಮುಗ್ದೋಗುತ್ತೆ ಎಲ್ಲವು.
Let it be disposed of. On merits, it may be disposed. my lord.
Yes. What is that order?
Page number 13, my lord.
Page number?
13. 13, my lord.
What is the reason given?
Since the parties to the both the suits are one and the same and the properties are one and the same,
This is factually
the
wrong.
relief sought are one and the same, there was no necessity on the part of the petitioner to file a subsequent suit seeking the same relief. Otherwise, petitioner can seek stay of his suit till disposal of the previously instituted suit, my lord. This was the order.
It is factually.
ಯಾವ್ದು? Which is that annexure?
Annexure A, my lord. Page number 13.
No, what is this miscellaneous petition?
That is first transfer.
That is what it is challenged here.
That is the order.
Where is that order?
Page 10, my lord, annexure A.
ಆಯ್ತು, finding ಎಲ್ಲಿದೆ?
Finding.
The oral pleading of the defendant produced petitioner sees that relief I filed. Page 13,
Please, my lord.
Well onwards, the reason starts.
Yes, reason start.
Page-
Before that. so-
Para
so
eight-
careful
eight
that didn't
onwards.
make out any good ground to why he has filed suit seeking that same relief when the suit for partition so on so. Because the petitioners filed one more suit for partition subsequent before the court. Previously instituted suit can't be withdrawn or transferred to the court which has subsequently suit filed by the petitioner. Parties to the both suits are one and the same and the properties are one and the same of relief the same. Therefore, the remove necessary part of the petition for the subsequent same relief. Petitioner can seek stay that his suit still the disposal of. It is already there. Your suit is stayed.
Yes, my lord.
It's time, my lord.
ಮತ್ತೆ ಇಲ್ಲಾಕೆ ಮತ್ತೆ ಹೇಳಿದ್ದಾರೆ?
Seek.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ನಾನು ಇದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅವರು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ಲಿಲ್ಲ ಕೋರ್ಟಿಗೆ ಅದನ್ನ.
But as on that day, it was already stayed. Yes, tell. This petition is filed by.
And both parties stay in Mysore, only same address.
I am not passing any order. Yes. Petition filed by the plaintiff in OS number 48 of 2020, pending in the file of Senior Civil Judge JMFC, Karnataka. Challenging order dated 9th January 2023, passed by Principal District and Session Judge on IA on miscellaneous petition filed by the petitioner under section 24 of CPC. The respondent herein has filed an suit OS number 487 of 2019 before First Additional Senior Civil Judge CJ Mysore for partition and separate position. Thereafter, petitioner has filed OS number 48 of 20 before the Principal Senior Civil Judge JMFC Karnataka seeking a partition and separate position. In both the suits, the parties are same, one and the same, properties are one and the same, relief sought by are also one and the same. The subsequent suit filed by the petitioner in OS number 48 of 2020 has been stayed till the disposal of the previous suit, that is OS number 487 of 2019. Since the suit filed by the respondent herein is in respect of the partition and separate position, there is no reason forthcoming why that petitioner has filed one more suit. Considering this aspect of the matter, the trial court has rightly dismissed that. The trial court has rightly, the principal district and session judge has rightly dismissed miscellaneous petition. Miscellaneous petition 104 of 2021 filed by the petitioner. There is no error or illegalities in order passed by the court below. Hence, the petition is rejected.
Serial number 70, Virupaksha PH for petitioner, Chetan AC.
Here for the petitioner.
Yes.
What's the petitioner, my lord, had filed, my lord, HRC, my lord, against the respondent here in my lord. Before the principal civil judge at Davangere, my lord. That was allowed, my lords, directing the respondent, my lords, to hand over, my lords, possession of the suitable property in favor of the petitioner. My lords, as on the date of the order, my lords, the respondent was due, my lords, of rupees 1,42,000 of rent, my lord, payable to the petitioner. He filed revision petition, my lord, under section 46 of the Karnataka Rent Act, my lords, before the district judge, my lords, at Davangere, my lord. In the said HRRP, my lords, an application was filed by the respondent, my lord, seeking stay of the order of the learned trial judge. I filed an application, my lords, the petitioner, my lords, filed an application under section 45, my lords. Application is at Annexure D, my lords, page 47, my lord. Admittedly, my lords, as on the date of filing the revision petition, my lords, the respondent, my lords, was due, my lords, of rupees 1,42,000, my lords, of rent. I filed an application, my lords. May I read that application, my lord? It is prayed that the Honorable Court be pleased to pass an order to dismiss the revision petition filed by the revision petitioner for having not deposited the arrears of rent of rupees 1,42,000 due as on the date of filing the revision petition along with the revision petition. My lords, the learned first appellate court, my lords, after I filed this application, my lord, Annexure F, page 55, if your lordship kindly peruse, my lord.
Annexure
F, my lord, page 55. After this was, application was filed on 4/8/2022, my lord. The respondent herein, my lords, files a memo, my lords, before the learned first appellate judge. It is submitted, may I read, my lords, the memo, my lord? Page 55, my lord.
55, yes.
It is submitted that without prejudice to the contentions taken in objections and appeal memo, appellant may be permitted to deposit 1 year disputed rent of rupees 12,000. It is further submitted that the Honorable Court be pleased to pass an order not to disperse the disputed rent amount to the respondent till the disposal of the revision on merits. My lord, after this memo was filed, my lords, the learned first appellate judge, my lords, heard our arguments, my lord, on the application filed under section 45, my lord, and passed the impugned order, my lords, at page 56, my lord. Lords, my contention, my lords, before your lordships, my lord, is that, my lords, as on the date of filing the revision petition, my lords, since the respondent was due, my lords, of rupees 1,42,000, my lords. Section 45, may I read, my lords, of the Karnataka Rent Act.
Dismiss.
Revision petition maintainable is my contention, my lord.
But you have to prove that there is a due.
My lords,
otherwise everybody will come and say that there is a
lords,
due on dismissal.
when the order was passed by the learned trial judge, my lords, it had held, my lords, that the respondent had failed to pay rents, my lord, and directed eviction of the respondent.
Where is that?
My lords, Annexure A, my lord.
No, petition is filed for what purpose?
For eviction of the respondent. I filed, petitioner filed, my lord, HRC for eviction of respondent. That was allowed, my lord, by the learned trial judge. Against that order, my lords, appeal is filed.
Yes, appeal is pending.
Pending, my lords.
In that appeal, you said that he has not paid that arrears, appeal has to be dismissed.
Please, my lord.
That appeal or revision?
Revision, HRRP, my lord.
Yes, revision has to be dismissed.
Please, my lord. My lord, may I read, my lord?
What is that order passed by that?
My lord, the
IA filed by so and so
Please,
is
my lord.
allowed, consequently further proceedings of the execution petition. What is that execution?
My lords, after the order was passed by the learned trial judge, my lords, I filed execution petition.
No, where is that? First, you will come to that order. On your application under section 45.
Lord, this is the order, my lord.
What is that order?
Page 56, my lord, is the order, Annexure G, my lord.
50?
56, my lord. Relevant portion, my lord, may I read, my lord? Para 19, my lords, page 67, my lord.
ಏನಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ರು ಕೊನೆಗೆ?
Now, my lords, my application has been rejected.
ಎಲ್ಲಿದ್ದಾರೆ ಆರ್ಡರ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ?
My lord, order portion ಅಲ್ಲಿ next page ಅಲ್ಲಿ IA3 filed under section next page, my lord. Page 70. ನನ್ನ application
69 ಏನ್ರಿ ಅದು? ಆರ್ಡರ್ಸ್ ಅಂತ ಇದೆಯಾ?
Order ಅಲ್ಲಿ, my lords, IA number 2 filed by the petitioner seeking stay, my lords, of the order of the learned trial judge was allowed. ಅವ್ರ ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಇತ್ತು, ಒಂದು ಅವ್ರು ಹಾಕಿದ್ದು, IA2 ಅವ್ರು ಹಾಕಿದ್ರು.
For what?
For seeking stay of the order of the.
Yes, your this thing, trial court.
ಅದು stay ಆಗಿದೆ. That is allowed. And my application IA number 3, my lords, next page.
Yes.
IA3 filed under section 45 of the Karnataka is dismissed. Karnataka Rent Act is dismissed.
Order for depositing arrears rent not come in the way of the revision petitioner rising is about the dispute regarding the jural relationship.
My lords, may I read para 19, my lords, the
Yes.
conclusions. The learned counsel for respondent has placed reliance on decisions referred above. This court carefully perused the ratio laid down in the above said decisions. In the above referred decisions, our honorable court has held that depositing of arrears of rent is mandatory at the time of filing of revision petition, irrespective of dispute regarding the jural relationship, particularly when the trial court has given finding about jural relationship. In the case on hand, even though the present revision petitioner, who is the respondent before the trial court, has disputed the jural relationship, the trial court not accepted his contention and held that there is jural relationship between the petitioner and respondent. No doubt the revision petitioner has raised several contentions before this court, particularly about impugned order. In the opinion of this court, whatever the contentions taken by the revision petitioner are still under consideration before this court. Since the trial court has held that the petitioner is the landlord and respondent is tenant of petition scheduled property, and also in view of the ratio laid down in the aforesaid decisions, in view of section 45(1) of the Karnataka Rent Act, deposit of arrears of rent is mandatory. At this stage, it is made clear that the deposit of arrears of rent would not take away the right of revision petitioner in disputing the jural relationship. As stated above, the respondent herein as
It is the judgment you have relied and said that.
my lord, there are various,
Filing of the revision petition
lord,
irrespective
at
of the
page 61, my lord.
Our honorable court has held that depositing the arrear rent is mandatory at the time of filing the revision petition, even though so and so.
My lords, at page 61, the several judgments were relied upon, my lords, by before the learned revisional court, my lord. One judgment of 2016, my lords, reported in ILR 2016 KR 1866, my lord. My lord, may I request your lordships, my lord, to have para 32, my lords, page 120, page 125. My lord. The opening words of section 45 are couched in negative words. It states that no tenant against whom an application for eviction has been made by a landlord under section 27 shall be entitled to contest the application before the court under that section, or to prefer or prosecute a revision petition under section 46 against an order made by the court on an application under section 27, unless he has paid or pays to the landlord or deposits with the court or the district judge or the high court, as the case may be, all the arrears of rent, and continues to pay or deposit any rent which subsequently become due in respect of premises at the rate at which last paid or agreed to be paid. Here we have to notice the distinction between the words paid or pays to the landlord or deposits with the court, the district judge or the high court. If the tenant does not dispute the relationship, then he is liable to pay the rent. Then the dispute could be either regarding rate of rent or arrears of the rent. In the case where he disputes the relationship and the court holds against him, he has a right to challenge such order, in which event he is under no obligation to pay the rent to the landlord. If he is challenging the said order in a district court or high court, the phrase used is he shall deposit. If in the original court he deposits either the rate of rent or the arrears of rent, he is under an obligation to deposit the disputed amount at the rate last paid or agreed to be paid in the court of original jurisdiction. The intention of legislature is unambiguous and clear.
He has to deposit.
Please.
In other case, he has to pay.
Please,
Here
ma'am.
he has to deposit.
He had to deposit, my lords, at the time.
Yes, Mr.
Lord, issue here is whether the district judge in the revision, whether I should deposit at the time of the revision, or here he has given me 3 months time, my lord. I have deposited within that 1 day, late I have deposited, they have accepted also. My lord,
You
kindly,
have deposited entire amount.
1,48,000 deposit.
Now deposited.
Kindly see this
But,
judgment.
the section itself says, my lord, he cannot maintain a revision petition without depositing the arrears of rent. Even though, my lords, he has deposited at a later stage, my lord,
Will it not be cure the defects?
the learned trial judge, my lords, that is the reason, my lords,
Now it has come for final argument, today for final argument. Now he has moved the matter, my lord. He is
What is
trying
that? Oh, yes, what is that?
the revision petition.
In this, what you
My-
want to show?
My lord, in this case, the honorable single judge held that the district judge was not justified in dismissing the revision petition as not maintainable on the ground that arrears of rent was not deposited when the revision petition was presented. So there is some discretion for the revisional court to give me some time to deposit that amount.
Here 3 months' time was given, I paid 1 day late, I paid, it was accepted by the court also.
Where that time has been granted?
In the order, my lord.
At page 69, my lords.
3 months' time was given.
Time was granted.
Time ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ. That order, my lords, is challenged in this writ petition. On the ground, my lords, that the time ought not to have been given, my lords. At page 69, my lord.
In that second paragraph. Operative.
No, that this single judge judgment. What is that? They said the learned counsel petitioner submitted that directed this court. They have relied on some judgment.
As they relied on Supreme Court, my lord. But Supreme Court judgment is under the old act. But they have followed the same principle and.
So the Karnataka person are not apply word. In fact, there is no limitation prescribed before the revision. In view of the guidelines made on the document, if there was a delay in among 15 days in making the deposit, the revision petition. So have to come down when the revision decision made. We do to discuss the various.
One more judgment, my lord.
The question whether the revision petition was putting under. Judge was not just dismissed the revision, not from
One more para 9 in this judgment. But here in the situation is different. The court has firstly overruled the office objection and accepted the payment of arrears made by petitioner and subsequently admitted the revision petition. When once the court admitted the revision petition without exercising the other option open to it of stopping further proceeding and rejecting the revision petition as one invalidly made, it constructively follows that court was satisfied that there was sufficient reason for not making the payment of deposit. Though this court may not have recorded its satisfaction either while accepting the payment of rents or while admitting the revision petition. Therefore, the revision, though invalid at the time of its filing, has gained validity by virtue of the orders of the passed by this court overruling the office objection and admitting the petition. So when court has given me 3 months' time, it is only a technical defect.
Yes, now they have deposited, Mr.
Lords,
We pass an order on merit. We'll keep this. When is that? Next?
Today for arguments, ma'am.
No, there is no stay here.
No stay here.
there is no stay, my lords. My lords, on submission. The petitioner, my lords, is 80 years old. The respondent who is in possession, my lords, is the son, my lords, of the brother of the petitioner. He has been enjoying the property, my lords, squatting upon the,
Direct to dispose of that.
within, my lords, a time frame. Lordship may keep this pending, my lords.
My lord,
Let-
on
let the
merits,
direct-
it is a joint family property. I filed
Count
partition
22.
suit also. Anyway, time frame may be given. I have no.
The word are used before or substituting. Ultimately, succeeded in using the deposit code. Before deposits the rent, the second is held to be a tenant by things in the. Section 45, Kodi. No, in this case also, they have been given an opportunity to file it.
Yes.
Division bench. The court said, if you want to prosecute, deposit and prosecute it. Last paragraph, para 37.
Please, Mr.
He shall deposit the arrears of rent due by him to that landlord from the day the amount become due till the date of filing the revision petition. Otherwise, revision petition is liable to be dismissed. That means to say he has been given an opportunity to deposit. Now they are given, he has deposited. If he is not deposited, he cannot proceed further. That we can say that. But he has deposited now.
Yes.
Now we will direct it to dispose of that. Now what is that partition suit is coming in this way, Mr.
No, no, now final arguments in this rent revision
Their
petition.
content, my lords, the suit share property is the joint file, that is their contention.
That is different. Let him, now arguments is over.
Today for arguments.
Let the proceedings before the revision court, my lords, be concluded.
Yes, yes, we'll, now anyhow, it's for an argument. Yes. This petition is filed by respondent in HRRP number 1 of 2022 filed by the respondent herein before Principal Civil Judge Davangere, before the District and Session Judge Davangere.
First additional.
Now that HRRP is pending before whom?
Lords, first additional district and session judge Davangere.
Now it is a rent revision petition, my lord.
HRRP 1 of 2022, my lord, page 56, my lord.
HRRP 1 of 2022.
Yes, first additional district and session judge Davangere.
This in this writ petition, petitioner called in question, order dated 6/4/2024, passed by first additional district and session judge Davangere in rent revision 1 of 2022, whereby application filed by the petitioner under section 45 of Karnataka Rent Act is dismissed. Petitioner has filed eviction petition in HRC 3 of 2013 before Principal Civil Judge at Davangere against the respondent herein. The petition filed by the petitioner was allowed by order dated 24/1/2022. Being agreed by the same, the respondent herein has filed an rent revision 1 of 2022 before first additional district and session judge Davangere. In the said revision petition, the petitioner has filed IA number 3,
3, sir.
IA number 3 under section 45 of Karnataka Rent Act 1999. The trial court has dismissed that application filed by the petitioner and permitted the respondent to deposit the arrears of rent of rupees 1,00,000
42,000.
48,000 within 3 months. Now, the petitioner, the respondent has deposited that amount before the divisional court. Therefore, considering that validity of that impugned order would not arise us in this case, the only relief can be granted is trial court may be directed to dispose of that revision petition as expeditiously as possible. Accordingly, the petition is disposed of. The first additional district and session judge Davangere is directed to dispose of rent revision 1 of 2022 as expeditiously as possible, not later than 6 months from date of receipt of.
But it is pending since 2022. My learned friend submitted my notes. It is set down today for arguments, for their arguments. What should we make it 2 months, my lord, because
Petitioner
not
argument.
later than 4 months from date of receipt of the copy of this order. Both the parties are directed to cooperate for early disposal.
Serial number 71, Dishant GK for petitioner, Shreyas Jaisimha.
Appearing for
For the petitioner.
appearing for the respondent in the matter.
There's a slight
But I've,
inconvenience.
moved the matter. My lords, the matter is pending before the commercial court, wherein the.
Now, what is
May I
the,
make one submission? That's there. At the time of shifting, my lords, this file has been misplaced. May I request for a date in the first week of
That's no, no.
February? my
I have
lords?
moved this matter precisely because there are similar matters which was pending before the commercial court, which was subsequently transferred to the jurisdiction of civil court because it was held to be not coming under the purview of the commercial dispute. There is a division bench order of this honorable court wherein it is categorically held that it does not come within the purview of a commercial dispute.
no, what is that, this thing they are claiming,
My lords, I am for the defendant petitioner, my lords. The suit
plaintiff-
was filed by the plaintiff respondent herein seeking for a recovery of money, my lords. This arises out of a mortgage deed and a loan agreement. What has happened is, my lords, there is
no, you are the petition.
Yes.
their own suit, my lords, came to be returned. The plain came to be returned to the jurisdictional civil court. It was before the commercial court, my lords. That order, my lords, the grievance of the respondent, he can go file the necessary application in order 7 Rule 10 before the trial judge, my lords. That this judgment, this,
No,
Please, ma'am.
he has filed in a suit in commercial court.
please,
Who has filed an application for transfer that to regular court?
there was no application.
So
my lords.
motto has been held that it is.
The similar
In
matters,
other
suo moto.
matters, in other matters,
Hmm.
not connected with these matters, my lords, what has happened is there's a list between the
No,
same parties.
See, other matters, they have passed an order.
Please, my lord.
What is that challenged in this petition?
My lord,
They have
herein,
challenged
my
because
lords,
their evidence stage was closed. They have impugned that particular order in this writ petition.
if I may make my
At least stay
submission.
the Swami, the High Court.
No,
It-
I am asking that order passed in that other suit.
They're not
this.
related. They're not related, my lords.
What
There
is that order passed in this case, Mr.?
In this case, my lords, the order that is being impugned before your lordships is the stage of PW1, chief examination of PW1 came to be closed the very same day that I led my chief examination. That came to be impugned before your lordships, my lords. There's an interim order acting, my lords. What the
That
judgment,
Nobody is challenged that maintenance.
no, my lords.
No,
No,
we
my
have not challenged.
the
it.
order
It's
that
already
is
been
being-
Civil court. I think
No,
there's
that
no.
No, that
point
is
is-
that your suit.
Yes, yes.
He has to challenge that it is not maintainable.
Yes, because similar matters.
But he has
Own
not
matters.
challenged, court is proceeding, what to do?
Because on the other our intention is
No.
to submit before the court that it may be transferred to the civil court. At least it will proceed.
Because of the stay, they
stay
can't.
ಕಾರಣ ನಮಗೆ move ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ.
See, I will make it clarify. This interim order will not come in the way you to file any application before that. That can be decided in accordance with. If they said it is not maintainable, it has to go that, it become infructuous.
Some
Why do you want-
similar ಎಲ್ಲ loan agreements. There are
Yes,
different
yes.
loan agreements. Parties are also similar.
Yes,
Please, ma'am.
yes. Now I
My lords, in
understood.
serial number 71
And
and
73.
73.
No.
However, in 73, my lords,
No,
what has happened?
why you are worried that he wants to transfer his case to that regular court?
No,
Yes.
I am okay with this.
ಯಾಕಂದ್ರೆ
my
ಸ್ವಾಮಿ
lords.
ಮೂರ್
However, there is some inconvenience. It's serial number 73
no one-
between the same parties.
See, now your case for adducing the evidence, the permission is not granted.
Please, man.
What is the effect if it is transferred to the regular court? Everything has to
Dino,
be-
Dino.
That's
then your purpose is also served.
Yes.
my lords, I have no objection to that, my lords. However,
then-
it's 70, serial number 73, my lords.
Hmm.
Same parties, my lords, same dispute.
Hmm.
However, in serial number 73, my lords, an
Hmm.
application for summoning of witnesses came to be allowed.
Hmm.
Pursuant to which this very same judge, the trial judge, set aside his own order of summoning the witnesses because there was a deficit
No,
of 40
now,
rupees.
If that also has to
If
be
I-
transferred to
no,
the
no, if I
regular
may-
court,
There's no point in keeping that.
why all this?
I understand, my lord. If I may make this submission.
Hmm.
At the time when my application and order 16 came to be allowed, I was directed to deposit Bata, witness Bata. 46,000 has been deposited before the commercial court, my lords. My only request is, my lords, let them file an application before the trial judge, because, my lords, now I have to withdraw the 46,000 that I have deposited before the registrar. It has to be returned, my lords.
Where?
Commercial court.
That when they're passing an order, that
they can
liberty
be-
can be asked that,
My lord, that clarification was
that
given.
you have to be asked there.
They can ask
My lord,
that.
that's exactly my lord. That's precisely my submission. Let them file an application returning their own plaint, because the plaintiff can file an application order 7 rule 10. Let them do so, my lords. In the meantime, I will file a necessary memo or an application to
Now,
withdraw.
when they are passing an order on that, you can ask that amount deposited has to be returned because that case has been closed before that court. Here also, if you disposing any case, we'll say that amount can be returned to that it can be done it.
Please, my lord, if that.
The pendency
But
of
not
this
my
case
only-
will not come in the way of.
The request is, we contested this matter before the commercial court for 3 years. In the interest of time, if a direction.
My
can
lords,
be
I
given
object to
the
that, my
No,
lord.
if you file an
You know,
application,
proceedings, okay, they
that
cannot
will
be.
not come in that way. I will say, just says,
Please.
pendency of this court and granting an interim order in this writ petition will not come in the way of the commercial court to consider if any application or memo filed by the parties regarding mentality of the case before the commercial court. If such a application or memo is filed, the commercial court is liberty to proceed in accordance with law. Yes, in both the cases.
Please,
Both.
ma'am.
71 and
71 and 73.
Yes, both the cases. Aladmele ಬಂದ್ move ಮಾಡಿ, then we'll finalize this. Yes.
Bill number 72, Jai Prakash Reddy for petitioner, DM Chowda Reddy.
No, the problem is in all cases, commercial courts are entertaining. Even HRC matters, they are entertaining that. The purpose of constituting the commercial court is now defeated. Everybody is moving that commercial court.
Please, ma'am.
Even that HRC's matter, even between that companies, commercial matters also. Once that lease term is over, then commercial court has no jurisdiction. That's what Supreme Court is also.
To 1C.
To early disposal, everybody is rushing to that commercial court. Now that purpose has been defeated if everybody goes there. Yes.
Bill number 72,
My lords, sorry, sir. My lords, the that interim order will not be in the way of the plaintiff to move an application. However,
Parties, I said parties, anybody can move that.
Please,
Yes.
with
The
respect to,
interim order granted is extended till next date of hearing.
please, ma'am, both the matters.
Yes.
I'm ready.
Yes, madam. Preparing for petitioner, madam. This is the,
Yes.
my lord, the plaintiff's petition, my lord.
Hmm.
The suit is for a partition and separate position.
Yes.
The husband of the impeding applicant, my lord, has filed IN number 11 for impeding himself as one of the party to the proceedings. That application was dismissed for default, and thereafter he filed another application, IN number 12.
Where is your opponent? Next week.
The
Yes.
date may be fixed, my lord.
None I appear
Because
for the
2000
respondent.
2010 matter, my lord, suit,
Stay there.
stay there.
You have taken stay.
ಅಲ್ಲ ಸ್ಟೇ ಇದೆ ನಾವೇ ತಗೊಂಡಿರೋದು
Yes.
ಅದಕ್ಕೆ ಒಂದು
None appear for the respondent. Leave this matter on 5th. Yes, interim order granted earlier.
4th or 6th.
4th, 6th. Interim order granted earlier is extended till next date.
Bill number 73 adjourned, cell number 74, Rajshekar S for petitioner, Prasanna Kumar RS.
Yes.
Third defendant's petition. Suit is one for partition and separate position.
Hmm.
They have filed the application seeking amendment to the plaintiff.
Hmm.
It is available at page 39.
Yes.
They have sought for the proposed amendment to declare that agreement of sale dated so and so, so and so.
Hmm.
And general power of attorney dated so and so. And the consequent proceedings documents are sham and frivolous.
Hmm.
To amend the existing prayer B as prayer C.
Hmm.
And to add 4A to E
Hmm.
paragraphs. May I request my lords to kindly turn to the plaint for a moment. Kindly see annexure C for a moment.
You are a purchaser or a?
I am the purchaser. Kindly see page
Amended is
27 for a moment. Page 27. Paragraph number 4 starts from page 26.
Yes.
Page 27 minutes.
Yes.
Last 6 lines. That since the property is standing in the name of first defendant trying to alienate the suit schedule property to one PC Mallappa.
Page
as-
27.
Page 27. Third line, my lords.
Yes,
Defendant
property
is
stand, yes, stands
First
in the.
defendant trying to alienating the scheduled property to one so and so. As such, the first defendant has executed a registered GPA and agreement of sale by receiving entire sale consideration without consent or knowledge of the plaintiffs. And second defendant in favor of said so and so under the white document number so and so, hence the suit. Now, kindly see this suit was filed on 14/1/2020. I'm sorry, 2015. Lord, this suit was filed
2020.
in the year 2015. Suit is of the year 2015.
2015.
294 of 2015.
No, this shows 2015.
The amended plaint.
Yes, 25, yes.
Now, kindly see this suit was filed in the year 2015. I had filed my written statement wherein my lords specifically pointed out the factual aspects involved in the matter. And there was a earlier suit filed by one of the family member. And that suit ended in my lord's compromise. May I request my lords to kindly turn to the compromise in RA. Available at page 51.
Yes.
This was the compromise filed in RA number 10015 of 2018.
Yes.
Now, may I request my lords to kindly come to page 58, who are all the parties to the said proceeding. The order sheet is there. RA. Respondents will kindly be seen. Jayalakshmamma, Saudamma, Narayan Swami, Jnaneshwari.
ಆಯ್ತು ಈ ಪಾರ್ಟಿಷನ್ suit for partition ಅದು.
For partition, adu sir.
Now,
Idu suit for partition.
he is that, what is his name?
They are page 24 ಅಲ್ಲಿ.
Chaudamma,
Saudamma, Narayan Swami, Jnaneshwari.
they are the parties.
Kumar.
In respect of same property.
Same property. That is
ಏನಾಯ್ತು
one-
ಅಲ್ಲಿ?
That is my first submission.
ಅಲ್ಲ ಏನ್ ಪಾರ್ಟಿಷನ್ ಏನಾಯ್ತು ಅದಕ್ಕೆ?
Actually, suit decreed, appeal filed, in appeal compromised, and they have in the compromise, they have specifically stated, these persons do not have any right over the property.
No, that the property which you have purchased has went to the share of?
That, ಅಲ್ಲ ಅದರಲ್ಲಿ 10 ಗುಂಟ, ಒಟ್ಟು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ 1 acre. 10 ಗುಂಟ ಜಯಲಕ್ಷ್ಮಮ್ಮ ಅನ್ನೋರಿಗೆ ಇದೆ ಅಂತ ಹೇಳಿ ಡಿಗ್ರಿ ಆಯ್ತು. ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ದಟ್ ವಿ ಫೈಲ್ಡ್ ಅಪೀಲ್. RA ಫೈಲ್. RA ನಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತು. ಇಲ್ಲ this there was a prior partition in the family. In that partition 1 acre came to be allotted to the share of Nagarajappa and another 1 acre came to the allotted to the share of this Muniyappa and Subramanya. ಅವರ ಹೆಸರಿಗೆ ಬಂದಿದೆ. ಇದರಲ್ಲಿ the plaintiffs do not have any right over the property. That was the compromise. That apart, now my lords may kindly see page 68 for a moment. I had filed a suit for specific performance in the year 2014. Page 68. Insofar as the very same agreement, and that ended in compromise in the year 2018. And compromise came to be recorded on which is available at page 69.
In that they are not a party.
In that they are not a party. Now, my reciprocal submission is, as on the date of filing of the suit itself, the plaintiffs who are the respondents before my lords are aware of the execution of this particular power of attorney as well as agreement way back in the year 2015. Now kindly see when they have come up with the present application.
Hmm.
They have come up with the present application in the year 2022. Page 41 ಅಲ್ಲಿ ಸಿಗತ್ತೆ ತಮಗೆ.
Yes.
When they,
The reason they
when-
given for delay.
when they were aware of this particular factual matrix, my lords, in the year 2015, when they filed the suit,
Yes.
nothing prevented them from pleading this aspect in the plaint at a first point, first or initial stage.
Yes.
Subsequently, my lords, they filed one more amendment application.
Hmm.
That application came to be allowed, and that is how, my lords, amended plaint came to be filed.
Hmm.
Now, after lapse of 7 years, now that too, when they got to know that, my lords, in the year 2018, the decree is passed in my favor for specific performance of contract. They have come up with the present application to deprive my right. My lords, there must be some sanctity to the decrees passed by the court.
No, but they are not aware that properties is sold to you.
They are aware.
No, what is your name?
Plaint ಅಲ್ಲೇ ಇದೆ, plaint ಅಲ್ಲೇ kindly see plaint.
ಅಲ್ಲ, ನಿಮ್ಮ ಹೆಸರೇನು?
I am the purchaser, PC Mallappa.
ನಾಗರಾಜ ಯಾರು?
Nagaraj is the person who sold the property in my favor.
No, in earlier appeal, RA.
Aryanalli, he was the defendant, respondent.
ನಿಮ್ದ ಹೆಸರೇನು?
ನಮ್ದು PC Mallappa.
PC Mallappa was not there.
ಆರ್ಯನಲ್ಲಿ ಇದ್ದಾರೆ.
ಇಲ್ಲ.
ಇದು ಆರ್ಯನಲ್ಲಿ ಇಲ್ಲ.
ಹ್ಮ್.
ಆರ್ಯನಲ್ಲಿ ಅವ್ರವ್ರು ಮಾಡ್ಕೊಂಡಿರೋದು.
ಹ್ಮ್.
ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇನ್ನೊಂದು ಸೂಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು.
ಎಲ್ಲಿ?
ಪೇಜ್ 468 ಅಲ್ಲಿ.
ಕಾಂಪ್ರಮೈಸ್ ಸೂಟ್ ಅಲ್ಲಿ ಆರಿ ಹಾಕಿರೋದಲ್ವಾ?
ಅಲ್ಲ ಅಲ್ಲ.
ಪೇಜ್
68 ಅಲ್ಲಿ. My lords, initially Jayalakshmamma filed a suit for partition. That suit came to be decreed. ಅದರಲ್ಲಿ 10 ಗುಂಟ ಅವರಿಗೆ ಇದೆ ಅಂತ.
No, 68 ಅಲ್ಲಿ your case for specific performance.
Suit for specific performance.
ಅದರಲ್ಲೂ ಇವ್ರ ಪಾರ್ಟಿ ಇಲ್ಲ.
ಅದರಲ್ಲಿ ನನಗೆ ಅಗ್ರಿಮೆಂಟ್ ಯಾರು ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರ ಪಾರ್ಟಿ ಇದೆ.
But now filed by that person who is not a party there.
ಅವರು ಆರ್ಎಯಲ್ಲಿ ಆ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಪಾರ್ಟಿ.
No, original suit ಅಲ್ಲಿ nobody has disclosed that property is sold to you.
Yes, but ಅವರಿಗೇನೆ 2015 ನಲ್ಲಿ ಗೊತ್ತಿತ್ತು ಅಂತ.
No, property sold is not.
ಇಲ್ಲ, ಈಗ್ಲೂ ಅವರು ಸೇಲ್ ಮಾಡಿರೋದು ಕೇಳ್ತಾ ಇಲ್ಲ ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ಗೆ.
ಮತ್ತೆ
ಈಗ್ಲೂ ಅಗ್ರಿಮೆಂಟ್ ಅನ್ನೇ ಕೇಳ್ತಾ ಇರೋದು ಬೈ ವರ್ಚು ಆಫ್ ಅಮೆಂಡ್ಮೆಂಟ್.
ನೋ, ಅಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಸೂಟ್ ಅಲ್ಲಿ GPA ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇ.
ಇಲ್ಲ, ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ 27.
Yes. Name of the first defendant trying to alienate the scheduled property to one Mallappa.
As such, the first defendant has executed a registered GPA and agreement for sale.
That
by-
now they are challenging.
By 22 ಅಲ್ಲಿ. They are aware of this particular fact in the year 2015
Oh,
itself.
what is that amendment there?
Amendment ಇದನ್ನೇ prayer ಅಲ್ಲಿ, additional prayer ಅಲ್ಲಿ not binding on them ಅಂತ.
Page
39 ನಲ್ಲಿ. Page 39, declare that the agreement of sale dated so and so and power of attorney dated so and so. And the consequent proceedings documents are sham and frivolous.
Yes.
ಅದು 7 ವರ್ಷ ಆದ್ಮೇಲೆ.
Yes, yes, Mr. Please.
Lord, the pleadings in the plaint, Lord, regarding the awareness of entering into the agreement by one of the joint family member, it has been pleaded. As far as the prayer, my lord, prayer may kindly be seen in the amendment sought for B, prayer number B, my lord. Proposed amendment number 1, in that B, page number 39, page number 39.
Yes.
That declare that the agreement of sale dated 29/11/2006 registered as document number so and so stored in so and so at the office of the sub-registrar so and so and general power of attorney dated so and so. General power of attorney awareness has not been pleaded over there in the pleadings.
Pleaded there.
Subsequently, my lord, subsequent prayer may kindly be seen, my lord. Stored in so and so at the office of the sub-registrar Dodbalapur, and consequent proceedings documents are sham and frivolous and not binding on the plaintiffs. Because, my lord, the agreement has entered into between one of the joint family member and the proposed defendant PC Mallappa. Lord, if the document on the said agreement and the power of attorney, a document of sale deed or some conveyance deed, if brought into existence, my lord, my rights will be affected. Therefore, my lord, this prayer.
ಮಲ್ಲಪ್ಪನ ಹೆಸರು ಹೇಳಿದ್ರಿ, GPA ಆಗಿದೆ ಅಂತಾನು ಹೇಳಿದ್ರಿ, ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದೆ ಅಂತಾನು ಹೇಳಿದ್ರಿ. ವೈ ಕಾಂಟ್ seek the
That is
prior.
what the, lacuna, my lord, to fill up that lacuna, my lord, the
Can
prayer,
you-
only the prayer I have
Can
brought
you
into,
fill up that lacuna? Can you file an application at any time?
before.
So after that,
Yes, please,
7
but
years.
Before commencement of the evidence, I have filed, my lord, not at the fag end of the
See
proceedings.
the delay, 7 years after that.
Please, my lord.
Hmm.
Please, my
What
lord.
are you doing? What is that
No, my lord,
explanation? Why you are-
even if there is a delay also, it is not going to harm the rights of any of the parties, and, my lord, if these proceedings are not challenged, my rights will get affected. Under those circumstances, my lord, it has been
No,
compelled for me.
you could have wait till that evidence has to be completed, then you can file. But any time
No,
that
not like that, my lord. My lord, may kindly see the 6 rule 17, before the commencement of the evidence, if at all it is needed, it can be allowed, is the ruling. Ruling, my lord, it has been relied upon.
Kodi.
ಅದನ್ನ ಸ್ವಾಮಿ ಆ ರೂಲಿಂಗ್ಸ್ ಕೂಡ ಕೋಟ್ ಮಾಡಿದೆ, ರೂಲಿಂಗ್ಸ್ ತಗೊಂಡ್ ಬರ್ಲಿಲ್ಲ, ಬೇಕಾದ್ರೆ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಅಕಾಮಿಡೇಷನ್ ಕೊಟ್ರೆ
21.
ರೂಲಿಂಗ್ಸ್
next week.
ಆಗ್ಬೋದು.
Yes, leave this matter on 3rd February.
Please.
Interim order granted earlier is extended till next date.
Bill number 75, Jayakara Shetty H for petitioner, Prasanna BR.
Yes, madam, ready? Yes. Yes. Appeal. What is that suit for? ಇಲ್ಲೇನಾಗಿದೆ? ಇಲ್ಲೇನ್ ಸ್ಟೇ ಇದೆಯಾ? What is the stage now? What is the stage of the matter?
Evidence.
I will direct it to dispose of the suit. Hmm. 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 No, after filing the suit, 2.5 years, there is no interim order. Then you will direct it to, now it's an argument.
No, my lord, it's
Huh?
for evidence.
Evidence. I will direct it, dispose of the suit itself. Hmm. Hmm. No, without going all these things, for 2.5 years, there is no problem. Why can't you wait for another 6 months and dispose of the suit? If there is any interim order here, I could have said that continue that till this one. That is. Hmm. Hmm. If they are both are agreed for settlement. Hmm. Hmm. What is that undertaking they have given? Ink page 80. ಏನು ನೈಬರ ಅಥವಾ ರಿಲೇಟಿವ್ನಾ?
Neighbor.
ಏನಂತ ಮಾತು? Hmm. What do you say, madam, regarding that? Is there any settlement between the parties? ಆಯ್ತು, ಅವ್ರಿಗೆ ತೋರಿಸಿ ಅದ್ ಯಾವ್ದು ಅಂತ ಅವ್ರ
No, my lord, this police undertaking is not admissible, madam.
Who is that? Prasanna? Yes. You talk to him. Yes. Next week. Verify that. Yes, on 6th.
Bill number 76, Jayakara Shetty H for petitioner, SV Prakash.
My lord, I appear for respondent, my lord.
Hmm. Hmm. And no, he has filed in a suit for that temporary injunction has been granted. Appellate court also confirmed.
Confirm. Here also there is no stay.
Again, same thing, Mr.
No matter is posted for evidence.
Let it be
The
concluded.
evidence is going on.
I will direct to dispose of that.
Please,
Yes.
my lord.
This petition is filed by the defendant challenging the order dated 10/8/2023 passed by Senior Civil Judge CJM Arkulgod in MA
JMFC, my
number
lord.
9 of 2023, whereby confirming that order dated 30th/5/2023 passed by Additional Civil Judge JMFC Arkulgod on IA number 2 in filed under Order 39 Rule 1 and 2 in OS number 527 of 2022, whereby temporary injunction has been granted. Plaintiff has filed a suit for injunction. Along with that, has filed an application for temporary injunction under Order 39 Rule 1 and 2. The same came to be allowed by order dated 30th/5/2023, being agreed by the same. The defendant has filed an MA number 9 of 2023 before Senior Civil Judge CJM Arkulgod. The same came to be dismissed on 10/8/2023, being agreed by the same. The defendant is before this court. Now that matter is posted for evidence of the parties. The injunction order granted by trial court dated 30th/5/2023 is operating as on today. In view of the above, only relief can be granted in this case, directing the trial court to dispose of the suit as expeditiously as possible. Accordingly, writ petition is disposed of. The Additional Civil Judge CJM Arkulgod is directed to dispose of the OS number 527 of 2022 as expeditiously as possible, not later than 8 months from date of receipt of copy of this order.
Much
All the
obliged.
contentions of parties.
Much obliged.
Yes.
Cell number 77 adjourned, cell number 78 Rajaram is for petitioner, connected matter Ganesha R,
Serial number?
78.
For the respondent in this case, you. Order 13 1 and 2. Both the court rejected the.
What is this, Mr.? Ready? No, that you are the plaintiff. You will fight a suit for? Then? No, ಅವಳ story ಬೇಡ. ಏನಾಯ್ತು application ಏನಾಯ್ತು ಹೇಳಿ?
It was rejected.
What is that application? LAC amount.
That is not in, ಎರಡು ಕೇಸ್ ಇದೆ. ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಫಸ್ಟ್ ಕೇಸ್ ಯಾವುದು?
First case? No, which is that first case for not to alienate or not to disperse? No, not to disperse that amount ಅಂತ ಏನಾಗಿದೆ? What is the stage now? Now that's already dispersed.
MA also rejected.
No, now that petition become infractions, now already dispersed. Now that is be subject to result of that this thing. Now that not to create third party interest, there is already an order.
No, that was also rejected. There are two.
Already illi ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ ರೀ. See, ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ first parties are directed to not to alienate income, create third party interest till that suit is disposed of.
In respect of first writ petition, he is arguing in the second writ petition.
ಎರಡ್ ಪಿಟಿಷನ್ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಒಂದೇ ಸೂಟ್ ಅಲ್ಲನ್ರಿ?
No. One is LAC, one is OS.
One is LAC.
Yes.
LAC.
Second is LAC.
Second ಅಲ್ರಿ, ಫಸ್ಟ್ ತಡಿಯಪ್ಪ. No, this OS number 15 of 2023. This first MFA. ಇದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? ಏನದು ಐ ನಂಬರ್? ಅದ್ರ ಮೇಲೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿತ್ತು? ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಎಸ್, ಆಯ್ತಾಯ್ತು, ಸ್ವಲ್ಪ ನನ್ನ ಕೇಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಮಾಡ್ಕೊಂಡು. ಐ ನಂಬರ್ 4 is confirmed. See, IA number 1 is dismissed. Consequently, impugn order passed by the trial court on IA number 4 in OS number so and so is confirmed. IA number 4 ಏನೋ? No, ಅದನ್ನ ಕನ್ಫರ್ಮ್ ಆಯ್ತು.
Rejected.
ಕನ್ಫರ್ಮ್ ಆಯ್ತು. ಇನ್ನೊಂದು ಕೇಸ್ ಕೊಡ್ರಿ. ಅದೇ ರೀ, ಸುಮ್ನೆ ಏನೇನು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತಿರಲ್ಲ. ಎರಡು OS ಮೇಲೆ ಬಂದಿರೋದು. ಇಂದು ಒಂದು 39 and 2, 39 1 and 2. This is for this thing. Ex parte order passed on the so and so stands vacated. ಏನ್ ex parte order ಕೊಟ್ಟಿದ್ರು? Not to disperse the amount. This is the IA number 3. Not to disperse. IA number 4. Not to alienate the property. Yes, now that amount is already dispersed.
Yes.
Now not to alienate is there. Now I'll dispose of that. That order will be continued till the disposal of the suit. That's all. What you want to say? In contempt act, not to create any third party interest, not to alter ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. In spite of
both IAS rejected, both MS also rejected.
No, Mr. This court has granted, Mr. Encumbrance create third party rights over the suit scheduled property. ಆಯ್ತು, ಏಲಿನೇಟ್ ಮಾಡಬೇಡಿ, ಥರ್ಡ್ ಪಾರ್ಟಿ ಕ್ರಿಯೇಟ್ ಮಾಡಬೇಡಿ ಅಂತಿದೆ ಅಷ್ಟೇ. No, Mr. Counsel, that interim order granted by this court will continue till the disposal of the suit. Yes, that's all, Mr.
So kindly see page number 66.
ಏನನ್ನ ಹೇಳ್ಬೇಕಂತ?
Unregistered relinquishment deed, that is not admissible in evidence. Based on that created document ಮೇಲೆ they have filed declaration suit. Kindly see page number 66.
ಆಯ್ತ್ರಿ, ನಾವೇನ್ ಹೇಳ್ತಾ ಇದೀವಿ? Disposed of interim order is there, that will be not to create third party interest. Releasing that amount, it is already over, that writ petition will not. Yes.
Time bound may be.
ಏನಕ್ಕೆ, ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
Readings completed, issues ಆಗಿದೆ, evidence comments ಆಗಬೇಕು.
ಆಯ್ತು. WP number 2824 of 241 of 2023 is filed by ಎರಡರನ್ನು ಕ್ಲಬ್ ಮಾಡಿ plaintiff challenging order passed by ಫಸ್ಟ್ನೇದು IA number 3 ನಾ? ಫಸ್ಟ್ನೇದು IA number 4 ರೀ. Yes. Filed by the plaintiff challenging order passed by the trial court on IA number 4 filed under order 39 rule 1 and 2. Seeking temporary injunction restraining the defendant from interfering to the position of the plaintiff position in respect of suit scheduled property, whereby trial court has dismissed that application. Even the same is confirmed by first appellate court. WP number 27872 of 2023 is filed by the plaintiff, challenging order passed by the trial court on IA number 3, filed under order 39 rule 1 and 2, seeking direction to that ಯಾರಿಗೆ ಯಾವ ಬ್ಯಾಂಕ್ ರೀ seeking direction to the Karnataka bank to not to release that. What amount?
4,42,000.
Not to release that compensation amount deposited in that Karnataka bank. Thus, said IA number 3 has been dismissed by the trial court. Same has been confirmed by the first appellate court. In respect of IA number 3, order passed by the trial court regarding releasing that the amount is concerned, both the parties has submitted that. After that order passed by the trial court, the amount has been released in favor of
Defendant.
which violating that order.
No.
ಮತ್ ನೀವು ಅಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬೇಕಿತ್ತು. Now as on today, yes, both the parties are agreed that as on today, that amount has been withdrawn by that defendant. Therefore, the writ petition, the relief sought in that writ petition 27872 of 2023 will not survive for consideration. In respect of writ petition 28241 of 2023 is concerned, this court, while passing interim order, has directed the parties to on 19/2/2024 has directed the parties to not to alienate, encumber or create third party rights over the suit scheduled property till next date of hearing. Under these circumstances, the above writ petitions are disposed of. The interim, the trial court is directed to dispose of the suit as expeditiously as possible, not later than, what is the stage now?
Evidence has to come.
Not later than 10 months from date of receipt of the copy of this order.
Please.
The interim order granted by this court on so and so date will continue till disposal of the suit. Yes.
Bill number 79, PN Harish for petitioner, SV
My
Prakash.
lord, I appear for contesting respondent in the matter, my lord. Kindly grant 2 weeks time to file objection, my lord.
I object, my lord. I appear for respondent number 3, my lord. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪೆಟಿಷನರ್ ಮತ್ತೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೊಲ್ಯೂಡ್ ಆಗಿಬಿಟ್ಟು ಸ್ಟೇ ಆಗಿದೆ ಸರ್. ಐ ಆಮ್ ದಿ ಸಪ್ರರ್ ಇನ್ ಫ್ಯಾಕ್ಟ್.
Already ನೀವೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಗೆ.
ಐ ಅಪಿಯರ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2. ಹೌದು.
I appear for respondent number 3, my lord. My lord, notice to respondent 1 and 2 dispensed with.
What is your,
Below, I am the main contesting.
who are you?
I am the purchaser of the property.
Plaintiff or defendant?
Defendant.
Who is, what is that suit for? Who is that? Why he wants to come as a plaintiff? Who are you, mister? What is your interest? See, now No, you have filed an application suit for declaration.
Yes.
Hmm. Hmm. Yes. Hmm. ಆಯ್ತ್ರಿ ಅವ್ರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡೋದಕ್ಕೆ ಇವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು how they are colluded, how it will help them, mister.
Because my lord, from
Now,
last
what
1
is
year,
that interim order granted here?
stay ಆಗಿದೆ ಸ್ವಾಮಿ, last for 1
Stay.
year.
ಅವ್ರ ಸೂಟ್ ಸ್ಟೇ ಆಗಿದೆ, ನಿಮಗೇನ್ ತಲೆ ಬಿಸಿ?
I am the purchaser in the lower court.
ಆಯ್ತು, ಪರ್ಚೇಸರ್ ಏನು ಸೂಟ್ ಸ್ಟೇ ಆಗಿದೆ ಅಷ್ಟೇ, ಪರ್ಚೇಸರ್ ಪ್ರಾಪರ್ಟಿಗೆ ಏನಾದ್ರು ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಸ್ಟೇ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಏನಂತಂದ್ರೆ ಸೂಟ್ ಪ್ರೊಸೀಡ್ ಆಗ್ತಿಲ್ಲ, ಮತ್ತೆ
ಪ್ರೊಸೀಡ್ ಆಗ್ತಿಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇ ಇದೆ. Now that you have not interested in this case, now that Prakash who has filed an application is dismissed, now application is allowed. Now
Allowed.
he has to be, you have nothing to say that. Yes, Mr. Prakash.
My lord, kindly grant 2 weeks time to, I will file objection to.
What is that objection for?
My lord, the petitioner, my lord, have local standing in the suit, my lord. They have obtained the decree with collusion.
ಗ್ರೌಂಡ್ ಮೇಲೆ ಐಎ ಮಾಡಿರ್ತಾರ, ಐಎ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿರೋದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಕ್ಕೆ ಇಲ್ಲಿ ಏನಿದೆ, ಯಾವ ಪ್ರಾವಿಷನ್ ರೀ? ಇಫ್ ದೇರ್ ಇಸ್ ಎನಿ ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಫೈಲ್ಡ್, ಎಸ್ ಯು ಕ್ಯಾನ್ ಫೈಲ್. ಆ ಕೆಳಗಡೆ ಕೊಟ್ಟು ಆರ್ಡರ್ ಮೇಲ್ಗಡೆ ಇನ್ನೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕದ? ಅವೆರಡು ಕೇಳ್ಬಿಟ್ಟೆ ಇಲ್ಲಿ ಮಾಡಿರ್ತಾರೆ.
My lord, kindly grant 1 week time, my lord.
Why is yes, he wants next week, yes, at the request of counsel for the
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ my lord. Date may be fixed.
ನಿಮಗೇನ್ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ರೀ? ಅವ್ರಿಗೆ
ಇದ್ರಲ್ಲಿ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ ಸ್ವಾಮಿ, ಈಸ್ ಅ ಸೀನಿಯರ್ ಸಿಟಿಜನ್.
ಅವ್ರ ಸೂಟ್
ಅಲ್ಲ, ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದಾರೆ, ಅದಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬಿಟ್ಟೆ
ಬಂದಿದ್ದೀರಾ? ಆಯ್ತು, yes, at the request of counsel for the respondent.
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್.
Is this matter on 11th? Yes.
Obliged.
Interim order granted earlier is extended till next date of it.
Obliged.
P. Veeraya Hiremat for petitioner, P. Nataraju.
APF for respondent.
Hmm. Hmm. Page
40 million.
ಮತ್ತೇನ್ ಮಾಡಿದ್ರು? ಅವರೇ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ. Yes, mister, what you say?
We have no.
Now, in view of the Supreme Court judgment, trial court has no power, that has to be sent it to that, this thing.
Yes, ma'am.
Not matter may be allowed and directed to the DR to calculate the.
Yes. Yes, which is that paragraph? How do you, Sandesh or judgment? Yes. Yes, paragraph 23. Hence, the above reason that directed to pay the 10 times of penalty of the citizen somebody into the case of file. Directed to send that agreement district register to determine the deficit stamp duty and penalty payable of the complaint certificate from the district register without reference to the purpose. Receiving the evidence of the parties. Yes, where is that discussion? Trial court has no this thing.
Judgment of time.
Third, in this writ petition,
45 of the trial, page number 45, my lord. The
Page
trial
number?
court order.
in this writ petition, petitioner called in question, order dated 31st-10/2023, passed by 7th Additional Senior Civil Judge JMFC in OS number 1164 of 2021, whereby the agreement dated, loan agreement dated 22/10/2019 as impounded and calculated the penalty of rupees, stamp duty and penalty of rupees 29,37,000 payable by the plaintiff. Bernard Counsel appearing for the plaintiff has contended that in view of judgment of Apex Court 2020-24 SC 5327, the trial court has no power to calculate that penalties and stamp duty. Under the Stamp Act, they have to be referred to the competent authority, that is district register. Which is that relevant paragraph, Mr.? In para 28.8, 21.8. 21.8 extract. 21.8. 21.8. 22. Extract 22-23. This, the same is not disputed by other side. In view of the above, writ petition is allowed, order dated so and so is set aside. The trial court is directed to send that agreement dated 22nd October 19 to the district register to determine the deficit stamp duty and penalty payable. Upon receipt of the compliance certificate from the district register, sent to that district register. Upon receipt of the compliance certificate from the district register, can proceed with that matter. Yes. Yes.
Serial number 81, Rajesh Gowda for petitioner, D.V. Venkatesh.
I represent respondent.
Yes.
One, sir.
Yes, madam. Yes, Mr.
Not to interfere anta iroduna adanna the dishonorable court granted. Whereas both the court below, trial court and as well as the first appellate court dismissed the application filed by them under Art 39 Rule 1 and 2 not to interfere the suit property in the suit property. Whereas this defendant, respondent purchased the property in the year 1970.
What is the stage in the suit?
Evidence commence. Evidence.
Evidence ಇದೆ. Now that you are the defendant.
I am the defendant in that.
Now that this court has granted a maintenance status quo, that will be continued and suit may be disposed of till the disposal of the suit.
ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಯೂಕಲಿಪ್ಟಸ್ ಟ್ರೀಸ್ ಇದೆ. ನಂದು adjacent land is also mine. Both the eucalyptus trees are ripened up. Now I have to cut off the trees. ಇಲ್ಲ ಅಂದ್ರೆ ತಹಸೀಲ್ದಾರ್ will issue notice.
She wants time next week, then we'll hear that whether that has to be, receiver has to be appointed or not, we'll see.
Receiver cannot be appointed in the present appeal because the application filed by them is not to interfere with the social property, whereas my property, I have planted the trees
And I am in possession of the suitable property since from 1953.
Yes, let us see, letter. Interim order granted earlier is extended till next date of hearing.
Serial number
Date may be
82.
fixed.
Yes, leave this matter on 13th. Yes.
Serial number 82,
Right.
Shobhit M. Shetty for petitioner, Sandhya D.
Yes.
I appear for the petitioner in this matter.
Yes.
In this matter, petitioner challenged the order dated 16/11/2023. Start from page 12, relevant at page number,
What is the suit for?
in this, not suit, my lord, this
No, what has
execution
happened?
petition.
Suit.
Execution petition.
Execution
Suit is
petition.
not there. Facts of the case is that, my lord.
What is that you want to be executing?
I have.
My submission,
I have filed an execution petition to execute the LAC award, my lords.
That's what I am asking.
I have filed an application for impleading the.
Wait, it is his petition. Now that you want to execute that order
My lord.
passed.
I am the special land acquisition officer appointed under the NHA Act by notification, section 3A notification. In this particular matter, my lord, land of the respondent number 325 acquired by the state government for the formation of a national highway in the area of Sakaleshpur in the year early 90s or 2000. Subsequently, there is a compensation determined by the respondent number one hearing. And accordingly, he determined the compensation. Agreed by that, they have filed a reference quote. Reference quote is LAC number 2 of 2014. In 2014, they have filed a LAC. Thereafter, since they have not paid any, there is an announcement, since they have not paid the compensation, the respondent number 3 to 5 hearing filed execution petition before the executing court. That is
LAC court ಅಲ್ಲಿ ಏನಾಯ್ತ್ರಿ?
Announcement is there, my lord.
ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್ ತೋರಿಸಿ.
That's what, my lord. There what happened? Subsequently, they filed execution petition against respondent number 1 and 2 hearing. After appearance of respondent number 1 and 2 hearing, they say that it is not pertain to us, it is pertain to petitioner hearing in the year 2023. Actually, in this matter, what had happened, my lord? Respondent number 1 and 2 acquired, and they are the proper authority to make the payment. Respondent number 3 is appointed by the Act to make the payment wherever he passes a general award pertaining to National Highway Authority of India. This institution, petitioner here, came into existence only in the year 2012. Lordship, may kindly see now the page number.
Now, what is that order you are challenging, Mr.?
Page number 27, my lord, relevant portion.
20?
27, my lord. This execution petition filed by the DHR to execute the award dated 27/4/2014 in LAC number 2 of 2014, passed by this court. On service of notice to the JDR number 1 and 2, JDR number 2 has sent a letter stating that all the records pertaining to National Highway Authority Hassan has been sent to the Executive Engineer, National Highway Division Hassan on 28/9/2018, and he has also sent the copy of the letter for transferring the files pertaining to National Highway Subdivision Hassan. On the basis of the application filed by the DHR, the Special Land Acquisition Officer Hassan is impleaded as JDR number 3. On basis of that letter dated 20.
No, you have been impleaded, that you are challenging that.
Yes, my lord. Actually, that letter also, now Lordship may kindly see, the letter.
Degree is against whom? LAC order. You are not a party there.
I am not the party.
Then?
Moreover, property also
Then
not.
why you want to execute that? Who are the party, madam? If there is no, tomorrow he will say that I have no concerns, somebody else concerned, that then they will be implemented and executing that.
My lords,
Now Lordship may kindly see Annex F, page number
Who has
41.
filed an application for impleading you?
the respondent number
Statement.
3 to 5 years.
Decree holder, my lord.
ಅವ್ರ ಹೆಂಗ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ application ಅನ್ನು?
Based on this letter, my lord. That letter
Can
says,
that be allowed, madam? Execution is against to that person who has suffered any degree.
moreover, we are not a
If
party
they
to
are
the
not
execution.
concerned with that, they could have stated when that LAC order has been passed that we are nowhere concerned. When they have suffered any degree, when the payment, they will say that. Tomorrow, somebody will say that I am not concerned with that, BBMP can be asked to pay that.
Moreover, this letter also, there is a misinterpretation of this particular.
Who has acquired that land?
National Highway Division.
Who are you?
Pertain to state, I am the National Highway Authority of India. I am the Special Land Acquisition Officer for National Highway Authority of India. I am acquiring the land and handing over the property to NHI. But here, Lord should be kindly see, kindly.
But
pay-
that land acquisition officer.
Yes, my lord. I am the Land Acquisition Officer. Lord should be kindly see.
Now, who is appearing for National Highway Authority?
Execute that government has to take notice.
I am for the land.
National Highway Authority is our appear, huh?
I am for the land loser.
Land loser.
Land loser.
Decree
That's what that, who is
Decree holder.
respondent ಹೇಳಿದ್ದಾರೆ ಯಾವ್ದು
Government
case ಇದು?
ಬೇಕಾಗತ್ತಿದೆ. AJ 22.
No, not this thing, that National Highway, you are for the National Highway Authority.
Yes, I am for the National Authority of India. But this is from National Highway Division Executive Engineer, wherever National Authority of India is coming. That is a statutory body appointed under the NHAI Act.
This land is acquired for whose purpose?
This is earlier acquisition by the National Highway, by the state government. Lord should me kindly see.
No, state government for what purpose?
NHO and National Highway only.
Who has to pay that
He
compensation?
has to pay the compensation, and now it has been transferred to NHAI for widening of 4 lane. Earlier it was
First it was been acquired and now it has been handed over. to
handed
you.
over for 4 lane.
It is not
2 lane
acquired
to
by
4.
you.
No, my lord.
It is, land has been acquired under that State Highway Authorities Act under National Highway
Yes,
Authority.
they are- NH Act, National Highway Act 1956. But this particular petitioner appointed under the NHAI Act 1988. As per section 3, small a, my lord. One more
Who is
thing.
appearing for government? No, that because of your dispute, parties
Allala.
cannot be.
Ali
If all are says that you are not responsible, we'll ask them to take back that land.
Yes,
We'll ask them to go and block that road. If
Allah.
all said you are not responsible, then let them give their land back.
One submission, my lord.
No, no,
In that
we'll
page
ask
number-
who is,
Allah, page number 14.
no, we'll ask that,
If
we'll
the-
ask that to file an affidavit. You are saying that you are not
Yes,
responsible.
ma'am.
Let them also file not responsible. Then we'll ask that to take back that land. This is
First,
not
I
that
kindly
now you
see.
have to support that.
Notification is of the year.
No, who is appearing for,
1999, my lord.
you take out notice to that,
Allah, I have gone.
I will ask that special land acquisition officer, executive officer to present before the court. They have
Allah.
been served and not represented.
Government has to take.
No, they are served, they have to.
Yes,
yes.
my lord.
Tell serial number estido?
82, sir.
82.
General procedure is that, my lord.
Yes.
Along with assets and liability, they have to hand over the
No,
entire
we'll
liability
verify.
to
If
them.
they said they are also not responsible, then we'll ask them to go and take back that land. Yes. Even though respondent number 1 and 2 has been served. None appear. The Special Land Acquisition Officer, National Highway Authority, India, Air Circle, Bangalore, and Executive Engineer, National Highway Authority of India, Mangalore, is directed to be present before this court. On on 3rd February, the
Yes.
registry is directed to communicate this order to that respondent number 1 and 2. Yes.
Meantime, let them produce some award copy also, so that it will be easy, because whenever
No,
we
let
apply
us
for
if
certified copy of the,
nobody is responsible to pay that compensation, let them give back that land.
when we wanted to file application for LAC record, they are not giving us because
Everybody
we
is arguing on
subsequently.
technicality.
Yes,
You
ma'am.
are that head, you could have asked that concerned officer to pay that compensation.
Yes, we
You have taken
requested
that
them.
land for an farmer.
He's,
If nobody says that technically we are not responsible, okay, let them take back that land.
yes, ma'am.
Yes.
Executive
Let them
engineer
present.
also written a letter that they are not responsible.
Yes,
All the
let them
records have
come
been
before
sent to
the
Haas and
we'll-
Millard.
we'll-
That's
we'll
why we
ask
have
them
included them
Interim
as
order
a part.
till that period.
Yes, interim order granted earlier is extended till next date of hearing.
Second, date,
Yes,
date to second.
let us see. Yes.
Okay.
16/1/2025. My lord, I moved a memo before your lordship, madam. Your lordship was pleased to pass the order saying that matter shall be listed on today, my lord. My lord, because my lord, the honorable trial court posted the matter tomorrow, my lord. Because suppose if they lead tomorrow evidence, my lord, it is a ex parte. It will be decided for a judgment, my lord. Even then, my lord, the board people, they are not ready to list the matter today or tomorrow.
No,
My
that-
petition will be infructuous, my lord. My lord, 2 memos I have moved, my lord. Date is given on 23/1.
Wait, Mr.
Please, my lord.
RFI ಇದ್ರು date ಇದೆ ಕೊಡ್ರಿ, ನಾನು ಹೇಳಿದ್ದು. ಯಾರು? ಹಳೇದು ಯಾವತ್ತಿನ ಡೇಟ್ ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ರು?
ಇವತ್ತಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Scrutiny ಅಂತ
My lord, yesterday it has come to from scrutiny branch to board, my lord.
Solving the problem.
Please,
Yes, please. Scrutiny ಏನ್ ಮಾಡ್ತಿದ್ರು? ಅಲ್ರಿ ಸ್ಕೂಟ್ನಿಗೆ ಯಾಕೆ ಯಾವತ್ತು ನಾವು ಕಳ್ಸಿರೋದು? ಏನ್ ಮಾಡ್ತಾರೆ ಸ್ಕೂಟ್ನಿಲಿ ಇಟ್ಕೊಂಡು? ಯಾರು ಅವ್ರ ಕನ್ಸರ್ನ್ ಬರಕ್ಕೆ post this matter tomorrow.
Please,
Yes.
grateful, my lord, please.
Yes. Other matter will take up any date if you want.
ಲಿಸ್ಟ್ ನಂಬರ್ ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಸುಮ್ಮನೆ ಅದು ನಾಳೆಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಗಂತ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು ಸುಮ್ಮನೆ.
Yes, entry order ಇದೆಯಾ?
ಇದೆ ಸುಮ್ಮನೆ.
Yes, serial number 2, entry order granted earlier is extended till next date of hearing.
Please, much obliged.
Please this matter.
21. Serial number 97.
Any date.
99.
Serial number 97, my lord.
ಯಾವ್ದದ? No, 99. That why it is urgent? Or that in view of that matter has to go back now. Tomorrow.
With your lordship's kind permission. Serial number 97.
You have made some other method from tomorrow. You see that. We have made some.
Serial number.
This interim order which is not granted, new matter is coming end. Therefore, I told that new matter has to become first, then old matter. From tomorrow onwards, they are doing that. Yes.
Serial number 95, my lord.
90.
Serial number.
Serial number. Yes, Mr. What has happened?
For the respondent, my lord, copy is not
We'll have it
served.
on 28. 28.
Copy is not served, my lord. That no, my lord.
ಆಯ್ತು, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ ಅತ್ಲ.
ಆಮೇಲೆ ಸೀನಿಯರ್ ನೇಮ್ ಚೇಂಜ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
ಯಾರ್ದು?
ಕುಮಾರ ಅಂತ ಇದೆ, ರಾಜ್ ಗೋಪಾಲ್ ಆಗ್ಬೇಕು.
Office is directed to show the name of counsel for the caveator respondent number 1 correctly in the cost list has TK
Raj
Gopal. Yes, please this matter.
Serial number 90.
Serial number 95, my lord.
Serial number 97.
I'm appearing to the respondent, my lord. They are seeking for the direction not to hold public auction. But already there is a stay by the DRT, my lord, the same stay.
Not to,
Sale notice.
not to,
Not.
then what is what?
Idralli it will not survive, my lord. There is a
Not Monday. Wednesday, 29th.
Serial number 95, my lord. Electricity and water supply is disconnected.
Serial
number 95.
95.
Yes, lord. Tomorrow it may be called.
Serial 95 tomorrow.
Obliged.
Serial number 97, my lord.
Serial number?
Serial number 97, please.
ಅದ್ ಮಾಡ್ತಾರೆ. ಯಾವ್ಯಾವ್ದು entry ಮಾಡಿದ್ರೆ extend ಆಗಬೇಕು.
Your lordship, serial number 92, a date may be given, your lordship. The respondent herein
Date
is
and entry order will be given by that court officer.
Lord, serial number 91
a
tomorrow, my
specific
lord.
date may be
Tomorrow,
given, your
tomorrow,
lordship.
serial number 91.
ಯಾಕೆ? Tomorrow.
91.
Why tomorrow?
My lord, already the arguments is done there, my lord.
Now what is
Final
the next
argument,
date?
my lord,
Next date?
28 it is there. 28,
Monday.
27 final.
97, my lord.
Court officer, serial number 92 on specific date, could you please?
One ನಿಮಿಷ sir, one ನಿಮಿಷ. The week commencing from 10th ಇಂದ date. ಯಾವ ಡೇಟ್ ಬೇಕು ನೀವೇ ಕೇಳ್ಕೊಳ್ಳಿ, ಒಂದೊಂದಾಗ ನಾನು ಕೂಗ್ತಾ ಹೋಗ್ತೀನಿ. Number 83.
Court officer, serial number 87.
ಸರಿ ಸರ್, ಸೀರಿಯಲ್ ಬರ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು.
85 ಹೇಳು.
10th.
ನೀವು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೋಬೇಕು. 10th ಇಂದ ನೀವೇ ಕೇಳಿ. ಎಕ್ಸೆಪ್ಟ್ ಫ್ರೈಡೆ. 11th ಅಲ್ಲ.
ಸರಿ ಸರ್.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಎಂಟ್ರಿ ಮಾಡಿ.
86 ಹೇಳಿ. 86 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ. 86 10th ಕೇಳೋಕೆ ಆಗಲ್ಲಪ್ಪ. ಯಾವ್ದಾದ್ರು ಒಂದು
ಕೋರ್ಟ್ ಆಫೀಸರ್ 97.
List wise ಕರೀತಾ ಇದ್ದಾರೆ ಸರ್. Court officer 87.
87 ಹೇಳಿ ಸರ್.
Next week ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಹಾಕಿ ಮಾಡಿ ಸರ್.
ಸರ್ ವೀಕ್ ಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ 10th.
ಆಯ್ತು ಸರ್, 10th ಕೊಟ್ಬಿಡಿ ಸರ್. ಅದು 2011 ಮ್ಯಾಟರ್, ಅದಕ್ಕಾಗಿ
86 12th ಹೇಳಿದ್ನಲ್ಲ ಸರ್. 86 10th ಹಾಕಿದೀನಿ, ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ
ಸರ್? 87 ಸರ್, 87.
ಅದೇ 87 10th ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಸರ್?
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಸರ್, ಅದಕ್ಕೆ 2011 ಮ್ಯಾಟ್ರು.
88 ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ ಇದರಲ್ಲಿ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಸರ್?
ಇಲ್ಲ 11ನೇ ತಾರೀಕು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 97.
92 ಯಾವ್ದಾದ್ರು ಡೇಟಾ?
Sir, 92 11th ಗೆ ಹಾಕ್ಬಿಡಿ.
13 ಬೇಡ, ಅದೇನೋ ರೆಡ್ ಮಾರ್ಕ್ ಹಾಕಿದ್ದಾರೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 92.
93
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 92.
ಅವ್ರಿಗೆ ಹೇಳಪ್ಪ. ಒಂದ್ ನಿಮಿಷ ಇರಿ ಮೇಡಮ್, ಒಂದ್ ನಿಮಿಷ ಇರಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 92 ಈಗಷ್ಟೇ ನೀವು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ.
ಡೇಟ್ ಯಾವುದು? ಯಾವಾಗಾರ ಕೊಡಿ ಸರ್, ಡೇಟ್ ಯಾವ್ದು?
10th 11th ಗೆ ಹಾಕ್ಬಿಡಿ ಸರ್.
ಸರ್ ಮೇಡಮ್ ಹೇಳಿ. 92 ನಾ?
ಹೌದು.
ಅವ್ರು ಯಾರೋ ಹೋದ್ರು. ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 92.
92 17/1 ಡೇಟ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸೀರಿಯಲ್ ನಂಬರ್ 97.
ಸರ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ, ಒಂದೇ ಒಂದು ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ ಸರ್, ಹೇಳ್ತೀನಿ. ಸಿದ್ದಪ್ಪ ಅವ್ರೆ.
ಆಯ್ತು ಆಯ್ತು.
94 ಹೇಳಿ. ಮಾಡಿದ್ದಿಲ್ಲಮ್ಮ 10th ಇಂದ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ತೀವಿ. ನನಗೆ ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದು 10th ಇಂದ ಕೊಡಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? 97 ಹೇಳಿ ಸರ್ ಸಿದ್ದಪ್ಪ ಅವ್ರೆ.
ಸೊ ಇದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿಲ್ಲ, ಅರ್ಜೆನ್ಸಿ ಇತ್ತು.
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ 10th ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಆಗಲ್ವಾ?
ಹಾ ಸರಿ ಸರ್.
ಯಾಕಂದ್ರೆ ಸರ್ವಿಸ್ ಆಗೈತೆ ನೋಟಿಸು.
ಸಾಹೇಬ್ರು ಹೇಳಿರೋದು 10th ಇಂದ ಕೊಡು ಅಂತ. 10th ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮ್ದು ಓಪನಿಂಗ್ ಡೇ.
ಸರಿ.
98 ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಡಿಸೆಂಡಿಂಗ್ ಆರ್ಡರ್ ಇಂದ ಮಾಡಿ ಅಂತ. ನೋಡೋಣ ಏನಾಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ಪಾಪ ಅವರು ಓಲ್ಡ್ ಅವರು, ನಿಮ್ದು ಹೆಂಗೋ ಆಗೋಗುತ್ತೆ. ಅವ್ರು ಓಲ್ಡ್ ಅವರು ರೀಚೇ ಆಗಿಲ್ಲ, ಹೆಂಗೋ ನಮ್ಮ ಮುಂದೆ ರೀಚ್ ಆಗ್ತಾ ಇತ್ತು, ಅದು ಹೋಯ್ತು. ಪೋಸ್ಟೇ ಆಗ್ತಾ ಇರಲಿಲ್ಲ, ರೀಚ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ. ಇಲ್ಲಿ ಹೆಂಗೋ ಮುಗಿತಾ ಇತ್ತು. ಹೇಳಿ ನೋಡೋಣ ಏನೇನಾಗುತ್ತೆ. ಎಲ್ಲಾರು ಮುಗಿತಾ ಹೇಳಿ ಹೇಳಿ. ಮೆಮೋ ಅಲ್ಲಿ ಕೇಳಿ. ಅವ್ರ ಮೆಮೋ ಬುಕ್ ಅಲ್ಲಿದೆ ನೋಡಿ, ಸ್ವಲ್ಪ ಬೋರ್ಡ್ ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲೇ ಇದ್ದಾರೆ, ವೆಯ್ಟ್ ಮಾಡ್ತಾರೆ. ಹಾ ಹೌದು, ಖಂಡಿತ ಕರೆಕ್ಟ್ ಹೇಳಿರ್ತೀನಿ ನಾನು. ಅದೇ ಮಾತೆ ನೀವು ಹೇಳ್ತಾ ಇದ್ರೆ ಕರೆಕ್ಟ್ ಹಂಗಿದೆ. ಸರ್ ನಿಮ್ದೇನು ಸರ್? ಸರಿ ಓಕೆ, ಬೋರ್ಡ್ ಕ್ಲಿಯರ್ ಮಾಡ ಬರುತ್ತೆ. ನಾನು ಆಕ್ಚುಲಿ ಶನಿವಾರದಿಂದ ಮಾಡಕ್ ಹೇಳಿದ್ದೀನಿ. ನಾಳೆ RFA ಅಲ್ಲ, ಹಂಗ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಉಲ್ಟಾ ಆಗ್ಬಿಡುತ್ತೆ. ಹಾ ಅವಾಗ ಕೆಲ್ಸನೇ ಕೆಟ್ಟೋಗುತ್ತೆ. ರಿಟ್ಗಾದ್ರೆ ಸರಿ, ಅದು RFA ಸರಿ ಹೋಗಲ್ಲ ಅಂತ ನಾನೇ ವರ್ಡ್ ಮಾಡುತ್ತೆ. ಅದು ಹೆಂಗೆಂಗೋ ಹೋಗ್ಬಿಡುತ್ತೆ, ತಿರ್ಗಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡೋದು ಕಷ್ಟ. ಬೋರ್ಡ್ ನನ್ನ ಮಧ್ಯೆ ಸಿಗಿಸ್ಬಿಟ್ಟು ನೀನು ಇದ್ ಮಾಡ್ತೀಯ. ನನ್ನ ಹತ್ರ ಯಾವ್ದಿಲ್ಲ, ನಾನು ನಿನ್ಗೋಸ್ಕರ 3 ದಿವಸ ಗ್ಯಾಪ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ನಿಲ್ಸ್ಕೊ, ಇನ್ಮೇಲೆ ಸೀದಾ ಅಷ್ಟೇ. ಈಗ ಇವ್ರೆ ಹೇಳಿದ್ರೆ ಮಾತ್ರ ಅದು. ಅದನ್ನೇ ಈಗಲೇ ಕೊಡ್ತೀನಿ. ಸರಿ ತಗೋ. ಈಗ ಹೇಳದ್ನಲ್ಲ ಅವನು. ಸಾಹೇಬ್ರು ಹೇಳಿದಾರೆ ಸಬ್ಜೆಕ್ಟು ಅಲ್ಲಿ ನೀನ್ ಕರ್ಕೊಂಡೋಗಿ ನಿಲ್ಸಿ. ನೀನ್ ಸುಮ್ನೆ ನಾಳೆ ನೀನ್ ಮಾಡೋದು ನೀನೇ ಜವಾಬ್ದಾರಿ. 99 24ನೇ ತಾರೀಕು ನಾಳೆ. ಹೌದು ಸರ್. ಯಾವ್ದೇ ಒಂದು ನಾಳೆ ಅಂದಿದ್ದು. ಹ್ಮ್. 95. ಹ್ಮ್. ಓಕೆನಾ? ಅದ ಮೊದ್ಲೇ ಒಂದು ಅದು ಹೋಗಿದೆಯಲ್ಲ ನೀನು ಹೇಳ್ದಲ್ಲ. ಹಾ ಎಷ್ಟು? 65. ಹಾ ಅದು ಹೋಗಿದೆಯಲ್ಲ ಬರ್ಕೊಳಪ್ಪ. ಏನಾಯ್ತು ಆರ್ಡ್ರು? ಬರೀ 8 ಜನ. ಅದ್ಯಾರು ಸ್ಪೆಷಲ್ ಎಲ್ಲೇವೋ ಅವ್ರನ್ನೇನೋ ಕರೆಸ್ತೀನಿ ಕೋರ್ಟ್ಗೆ ಹಾಗೆ ಹೀಗೆ ಅಂತ ಇದ್ರು.